Where's the witness? If you'll come and resume the stand, please. It's cross-examination. You may bring the jury. Thank you. Good morning. Good morning. Welcome, ladies and gentlemen. Day 14. Cross-examination continues. You may proceed.
Good morning, sir.
Good morning.
And this will be very brief, I believe, but just very briefly, yesterday we covered that it was difficult to download the information from the vehicle because it was encrypted by the manufacturer, correct?
Yes, the encryption was done by the manufacturer.
And you essentially had to reverse engineer the device using a test vehicle.
That's correct.
And looks like you got a lot of good data out of it, but there's some of it that isn't quite clear. Like we said, that we didn't exactly know what necessarily would trigger something like a system startup.
Correct.
But some of the other ones would be pretty obvious, like engine on obviously means somebody cranked the car.
Yeah, the engine was turned on at that point.
Okay. And I'm not going to go through that spreadsheet again. I just wanted to clarify that. And how long did this process take you, this reverse engineering process?
Our whole analysis took just about 1 year.
Wow. It's a long time.
It's a hard effort.
Will you be able to reuse this work on other 2021 Chevy Suburbans?
Some of the tools we developed will be reusable.
And I asked before, and I guess no one reached out to the manufacturer for assistance in this process?
Our group did not.
Okay. Do you know why? I mean, I think yesterday you said in the past there wasn't, they weren't very helpful, but it seems like the worst they could do is say no. Do you know why it was decided to not reach out?
For our unit, I believe that our attempt is to get the data ourselves without outside assistance. In many cases, we end up finding data that even the manufacturer doesn't know is there.
Okay. Now I want to turn to what I think a technical issue was resolved, and I'm going to show you a printout that has been marked as Defendant's Exhibit 90, and I believe you've had a chance to review this.
Yes, sir. I've reviewed this material.
And you recognize it?
Yes, this is from our results.
And what is this?
This is a list of events that were recorded from the vehicle. There was a category we called events that just listed times that something interacted or something occurred with the vehicle.
And on this printout, the only event, I guess, listed here are iPhones or something called Richard's iPhone earlier on connecting to the vehicle. Is that correct?
I see from the first page here, yeah, there's one that's labeled iPhone with a Bluetooth MAC address, and it's a device connection timestamp.
You've seen this before in your review, and you can look at it now. Do you see is this pretty much all device connections, phones connecting to the Bluetooth in the car?
Yes, I see other Bluetooth devices connecting as well.
And is it, just to be clear on this, the only phone connecting in the month of June, at least, is one named iPhone that has a phone number ending in 1227, is that correct?
The phone number itself is not listed on this page. It is the Bluetooth MAC address that it's identified by.
Is the, under connected devices, right above the word events where it says iPhone and there's a MAC address, is the IMSI number that's listed there, 803-942-1227, is that the phone number?
That's for the iPhone, correct.
Okay. And that's the phone that was connecting in June?
That appears to be the only one that connected in June.
Yes. Is this something that you also had to reverse engineer out of the vehicle?
Yes, all of the data we found was unknown prior to taking a look at the test vehicle.
And the event that we're looking at here, device connection, that is the phone connecting to the Bluetooth in the vehicle so that you could use it for whatever goes over the Bluetooth connection, whether it's phone calls or apps or whatever, depending on.
Yeah, and it indicates a connection event from the Bluetooth to the vehicle's infotainment system.
And up here in connected devices, does this indicate that this iPhone was, I guess, paired to the vehicle?
That's correct.
Okay. And so, in your experience, if your phone is paired to your vehicle and Bluetooth is on and it connects, that typically happens automatically when you get in and turn it on if your phone is with you?
Yeah, if there's a device that is registered, paired to the vehicle, it will automatically connect to that vehicle.
And finally, I just want to ask about, you had mentioned in your direct testimony that there's sometimes you can get location data. Were you able to get location data from the vehicle?
From the infotainment system, we had limited location data, and there was some location data recovered from the OnStar module.
And do you recall, was there any location data recovered for the day of June 7th, 2021?
There was no location data recovered on June 7th.
And in fact, there wasn't any for June 6th or June 8th either. Is that correct?
I'd have to verify those dates, but in this essence, on the day of interest in June 7th, there was no location data.
Your Honor, apologize, I forgot to please move Defendant's Exhibit 90 into evidence, I believe, without objection.
No objection.
No further questions, Your Honor.
Not from the stage, Your Honor.
Thank you. You may step down.
Thank you, sir.
Call your next witness.
The state calls Chris Wilson.
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
If you would, please, sir, be seated and state your name and spell the last name. Yeah.
My name is James Christopher Wilson, W-I-L-S-O-N. I go by Chris.
Good morning, Mr. Wilson.
Good morning.
If you would, tell the jury just a little bit about yourself, where you grew up, where you went to school, and what you do for a living, please.
Well, as I said a moment ago, my name is Chris Wilson. I grew up in Bamberg, about 35, 40 minutes west of here. Graduated school there, went to school up in Spartanburg for college. Came back to Columbia to go to law school at USC. Finished law school in 1994, worked for a judge in Greenville for 1 year, and then moved back to Bamberg where I grew up to practice law, and I've been practicing law there since 1995.
Are you going to have a solo practice in a firm?
Right now it's me and one associate. I've had my own firm since 1998, and there have been varying associates that have worked with me, or at one time I had a couple partners, and one partner left, and then one partner moved, and so we split up as a result of that. But I've had my own practice since '98 with different people coming and going.
And what's the name of the practice?
Right now it's Wilson Law Group.
Wilson Law Group?
Yes, sir.
Tell the jury what kind of legal work you do, please.
I do all kind of cases, but over the last 10 to 15 years I've primarily concentrated on just personal injury cases, people that are injured in wrecks or hurt at work, tractor-trailer wrecks, especially a lot of those, just personal injury cases.
Do you know the defendant?
I do.
Do you see him in the courtroom here today?
I do.
Can you point him out for the jury?
Yes, sir, redhead with the glasses over there between Mr. Griffin and Mr. Harpootlian.
Your Honor, can the record reflect he's identified the defendant?
Yes.
Tell me how you came to know the defendant.
I've known Alex since we were in high school. I think I was a year younger than him, but Bamberg and Hampton are only about 30 miles apart, and so we had several mutual friends, people that I was closer to back then, but got to know and be around him some then. We had played some ball against each other, and I think even played on the same ball team one summer. So I knew him a little bit through high school, but not much. Didn't keep in touch at all when we were in college. Started law school at the same time together, and became really close friends through law school. Lived together a little bit of that time. Finished law school. I moved to Greenville. He moved to Beaufort, and we would keep in touch some, but we were a little bit separated. And then when I moved back to Bamberg and he ultimately moved back to Hampton, we got much, much closer. Our wives had known each other through college, and so they became closer friends. Our kids grew up together. We just spent a lot of time together personally, and then he and I did a number of cases together. We worked professionally together.
Did y'all become close friends over the years?
Yes, sir.
Best friends?
Yes, sir. I considered him to be one of my best, if not my best friend. Yes, sir.
Did you get to know his family?
Very much. Not just his wife, not just Maggie, not just Paul, but, Buster and his parents, his in-laws, his brothers and sisters, his mom and daddy. I mean, the whole family. And they knew my family, or he knew my family.
Y'all did things together socially?
Yes, sir. We had kids the same age. Our kids are close. We did a lot of things together, and we worked together.
Up until about June of 2021, did you talk to the defendant almost every day?
Yes, sir. I didn't see Alec all the time, not every day, maybe not even once a week, but we talked by phone probably pretty much every day, several times a day sometimes. Sometimes just about, Gamecocks and football and baseball and whatever, sometimes about kids, sometimes about business, sometimes about cases we were working on, just all kind of stuff.
Did you feel like you knew him pretty well?
I did.
You mentioned y'all worked some cases together. How many cases together did you work over the years?
Well, my firm, when I first started out by myself, was smaller. I didn't have a lot of resources. I was just getting started. His firm was bigger with a lot more resources and a lot more lawyers. They handled some bigger cases that I really wasn't capable of handling together on my own. And so when it first started out, I was associating him and his firm a lot more often, probably over the course of, these last 20 years, probably 25 or 30 cases. But it slowed down. I mean, as my firm got bigger and I became more experienced and could handle a lot more things on my own, it was less and less often that I would associate his firm. But if I ever felt like it could benefit my client with either the type of case that I was handling or where the case was going to be brought to have his firm involved, I would call Alec.
How many times do you think you worked a case with him or shared a case with him over the years?
Probably 30, maybe more.
And when did that start, do you think?
I opened my own. I didn't do it any until I opened my own office in '98, and I don't remember exactly when he moved back to Hampton from Beaufort, but it was probably starting in the early 2000s or somewhere thereabouts.
And were all of these plaintiffs' cases where y'all are representing a plaintiff who had had some alleged injuries or something like that, or suffered some sort of harm?
Yes, sir. I mean, there may have been, one or two here or there that was something different than a personal injury case, but almost everything was personal injury cases.
And were all these cases worked on contingency?
Yes, sir.
And can you explain to the jury what a contingency is, how a lawyer gets paid with a contingency type case?
Sure. A contingency fee is basically the attorney and the client enter into an agreement on the front end of the case when the client retains the attorney. There are no attorney's fees up front. There's no prepayment. There's no hourly billing arrangement. Basically, the attorney has an interest in the case so that when the case resolves, the attorney receives as a fee a portion of the recovery. Generally, it's a third, sometimes 40%, depending on whether suit has to be filed or what type of case it is. But basically, the lawyer is taking all the risk in pursuing the case. If it doesn't work out well, the lawyer doesn't get paid for their time, and generally the lawyer fronts all the cost in pursuing the case for court fees, depositions, experts, all of that type of stuff. And so at the end, if there's a recovery, the attorney's repaid their fee contingent on a successful outcome and repaid whatever costs are advanced in the case.
Those costs and expenses, the cost of litigating the case, hiring an expert, travel, taking depositions,
Gets
court
expensive.
costs, things like that.
Yes, it gets very expensive.
Do those come out of the lawyer's 33% or 40% of the recovery, or are those recovered separately from the lawyer's fees?
Separately and in addition to the fee.
In the cases that you've worked with Alec over the years, was he with PMPED during those cases?
Yes, sir. I don't believe I associated him on any cases when he was in Beaufort. It was not until he returned to Hampton.
If you are in your firm and Alec is in his firm and y'all are sharing a case and ultimately you're successful, there's a settlement, there's a trial verdict, and you get a recovery, how do you go about splitting that fee?
All of that's agreed to up on the front at the beginning of the case. So, for instance, a client comes in and hires me for whatever reason, whatever type case. If I look at it and decide that I could use some help, either because there's a lawyer that knows that area of law better than I do, or maybe they're more local to the case, or maybe I just need some extra manpower, whatever it is, when I associate that lawyer and his firm, we make an agreement at the beginning as to what the fee split will be, and the client approves that and signs off on it. It's generally 50-50 on almost all the cases. I think on every case I ever worked with this firm, it was a 50-50 split on the fees.
In those cases that you worked with Alec over the years up until one at the end, did your office typically handle the disbursement of the fees when the settlement money came in?
Yes, sir. I mean, I've gone back through all my files, and with the exception of one or two cases that I think were a little bit different than normal, his firm had part of the family who had lost a loved one, and I had part of the family that had lost a loved one. And instead of them having a dispute about who was going to control and handle the case, we decided to work together, and so the firms worked together. And everything may have gone through them on those cases, but on cases that I associated his firm on, that I went to them to bring them into the case, I would generally handle the disbursements, yes, sir.
All right, and when we say handle the disbursements, does that mean your office would handle actually cutting the checks to the client as well as to his firm for their share of the lawyer's fees as well as their share of any expenses to be reimbursed?
Yes, sir. When the money would come in, whether it was by a settlement or a verdict that had been paid, the money would come to my office and it would have to sit in my account for the appropriate amount of time. And then when checks were ready to be written, I would write the checks to his firm for their fees and for their cost, to my firm for my fees and my cost, to any medical bills or liens or anything had to be paid, and to the client for their money.
Okay. And you would write the checks for his share of the fees to the firm, is that correct?
Yes, sir, to PMPED, or Peters Murdaugh, Parker, Dietrich, and Elsroth.
When you would write those checks to his firm, would there be one check or two? Would you put the fees and his share of reimbursed costs in one check together, or would you write two separate checks?
Starting out, I think we would include, not just for his firm, but for my firm, fees and costs would be in the same check. And then, more than 10 years ago or so, and maybe even longer than that, we started doing it in two separate checks just to keep the accounting of it easier, to keep up with what part of payment was fees and what part of the payment was cost. So, over the last 15 years, it's been two checks.
Do you have a staff member who helps you? It's kind of your main staff member that might handle some of these disbursements?
I have several different staff people that help me handle cases and disbursements. I have a bookkeeper that keeps up with the checking accounts and writes all the checks that I instruct her to write, and then I'm the only person with signatory authority. And I have a staff member that helps me work cases and actually helps me put together disbursement sheets and check medical lien balances and who's owed what money and those type things.
And who is that person you're referring to?
Vicky is the person that helps me do all of that.
Do you ever have called to work a case with the defendant involving Mack trucks?
Yes, sir. I contacted Alec and his firm to get involved and work with me and another lawyer on a case involving Mack trucks.
All right, and tell the jury just a little bit about the case without getting into too much detail. What kind of case was it?
Sure. So, lawyer contacted me about a wreck that a client of his had been involved in. A drive shaft out of a Mack truck had fallen into the interstate as the vehicles were traveling down the road. This gentleman's vehicle, along with a bunch of other vehicles, hit this drive shaft, and he was injured. So this lawyer, it was a trucking case when he first contacted me and looked at it, and that's a lot of what I do. So he called me for some help with that.
Okay. And so you got involved in this particular case?
I did.
As you looked at the particular case, did you decide to involve the defendant?
I did. Very quickly after looking at it, this other lawyer and I both realized that this case was probably a products liability case, that the drive shaft shouldn't have just fallen out of the truck for no reason like that, and that there might be something to do with a defect in the truck. And we found some information about a recall or a potential recall, and I knew that's what Alec and his firm specialized in, those type cases, so I called him and asked him to get involved. We were pushing some deadlines to bring in all the parties that we needed to, so it was important to get somebody involved in it fast that knew what they were doing.
And did he agree to get in on this particular case?
Yes, sir.
So you got three attorneys in there who are going to split the fee, is that correct?
Yes, sir.
Tell the jury, again, without getting too much into the weeds, tell the jury a little bit about how the litigation went. Did y'all ultimately try the case and kind of set up how y'all ultimately got to that point?
Sure. So we actually brought two cases. We brought one case for the wife of the gentleman that was injured in the wreck for what are called loss of consortium claims. That generally is just the loss of a spouse, their loss of the services of their other spouse. Maybe that spouse can't do all the things around the home they used to do, or they can't be quite the husband or the wife that they were before. So we brought a claim for the wife for loss of consortium, and we brought a separate case for the husband for his personal injuries. Not to get too technical, but the wife's case, Mack Trucks didn't answer the papers like they were supposed to, and so they went into default on that case, and that put them in a really bad spot. On the husband's case, they answered the papers and initially contested the case, but after getting Alec and his firm involved in the case, we started doing discovery, which means we were asking for a bunch of documentation and things, and I'm not sure that they just didn't want us looking any further. And so they reached out to us, and we had communications with them about ways to try to pursue the case outside of the traditional going through all of that and going to a jury trial. COVID had hit, and so things were slowed up in the court, and ultimately we reached an agreement to try both of those cases together in front of a judge without a jury. Both parties waived any rights to appeal. Mack Trucks admitted liability, and we agreed to waive punitive damages. I think that's the structure we tried it under.
Let me ask you two quick questions about that. You said that COVID had hit, and like the rest of the world, that had slowed up everything in court, correct?
Very much.
And, you know, some things were moving, but because things were slowed up in court, that might slow up the ability to get verdicts and settlements and that sort of thing. To some extent, COVID had an effect on everybody. Is that correct?
Yes, sir.
All right. And then you mentioned in this particular case, you ultimately agreed for both parties to waive the right to appeal. Is that correct?
Yes, sir.
And did that have the effect of meaning that whatever verdict was issued, it wouldn't be tied up in the courts for a long time, the money would go ahead and be paid?
Yes, sir.
Did y'all eventually try that case in front of a judge instead of a jury?
We did in January of 2021, first
January?
couple weeks.
Okay. And did the defendant try that case with you?
He did.
And did y'all ultimately get a verdict?
We did. We got verdicts in both cases.
Okay. And do you remember how much those verdicts were?
Combined, they were $5.5 million. I believe it was $4 million on the husband's case. He had passed away, I believe, within about 4, 5, or 6 months of us going to trial. So I think it was $4 million on behalf of his estate for his injuries and what that had cost for him. And then I believe it was $1.5 million on the wife's loss of consortium.
Who did the closing argument in that case?
Alex did.
For y'all's side.
Alex did.
The defendant did?
Yes, sir.
Did he get emotional in closing?
He did.
Did he spend much time with the husband in that case?
I don't think Alec had spent a lot of time with the gentleman. He had been kind of sick towards the end, and I don't know that Alec had spent a lot of time with him. He had spent a lot of time with the wife, and especially throughout that week in trial. I mean, it was an emotional case. They had serious loss.
Closing argument, that's when the lawyer gets up and sort of summarizes the case to the judge or the jury, depending on what kind of case it is.
Yes, sir. Honestly, you do more than summarize. You argue.
You argue.
Yeah, you put your heart into it, and you tell the judge or the jury why it is you hope and think they do what you're asking them to do.
You said the verdict was how much in total?
$5.5 million combined.
And what does that mean the fees were going to be for the 3 lawyers involved in this case?
I don't remember the exact split for everybody. I know that my fee was going to be like $791,000, and the fee payable to Alex firm was going to be $792,000.
And do you recall?
And I don't remember the third attorney right off the top of my head.
Do you remember when you received that $5.5 million into your trust account?
Yes, sir. Part of it came in by wire, but it was a smaller part. And I want to say that was about, we tried it in the first part of January. The judge didn't issue a ruling right on the spot. It took a couple weeks for him to issue his ruling, which is normal. And then within a couple weeks of that, after some back and forth with Mack Truck's attorney about whether they were going to file any kind of post-trial motions, or they could have tried to file an appeal and see where it went, even though we had an agreement up front. We were worried that they might get around that. But anyway, after a couple weeks of back and forth, and a wire was sent for part of the money, right probably middle of February, and then shortly after that, a check arrived for the rest of the money.
Do you remember when that was?
I don't remember exactly. I want to say the last few days of, no, it's probably the last few days of February, somewhere around in there. 2021.
Hold on for me 1 second.
Your Honor, for the record, I just want to object to this line of questioning under 404, 403, and to this exhibit. I do not have any additional objections other than those that were previously made.
I don't know what the exhibit is.
Sure.
Your Honor, this is just a text, but it's related to the in-camera matters that have been addressed.
objection.
All right, I'm going to show you what's been marked as admitted into evidence as States 450 and see if you recognize that document, please.
Yes, sir. This looks like a snapshot of a text string that I would have provided that is just communication between me and Alec.
All right. And in the middle of that particular text, that particular page, there's some text, and do you see the date on that?
March the 10th. This would be 2021.
All right. And that's a text from the defendant, is that correct?
Yes, sir. It looks like we had been talking about getting together to play golf, and then he texted me. You want me to read it?
Go ahead and read that to the jury, what your text conversation right there is.
March 10th. I need to get checked today. If it's just too much for you, I will deal with it.
All right. And what's your response?
I'm working on it.
So that's March 10th of 2021, is that correct?
Yes, sir.
May I have the Elmo, please? All right, well, let's talk about that text a little bit. So does that text help you kind of get an idea of roughly when the disbursement check came in on the Mack truck case?
Yes, sir. So by our rules, the Supreme Court, any check that's of a certain size has to be in your trust account for at least 10 days before you could disperse. And this was a sizable check, so I was going to wait more than 10 days just to make sure there weren't any problems. So if that's March the 10th, like I said, those checks, the final amount of that money would have come in sometime, towards the end of February. Because I think I waited 12 to 15 days, as I recall.
You said it's a sizable amount of money. This was a pretty big recovery, correct?
Yes, sir.
I imagine you contacted the other attorney and you contacted the defendant to say, hey, got the money in.
I did.
Did you when you contacted the defendant about that, what, if anything, did he say?
Great news, good. I told him that I was going to sit on it a little bit longer than normal to disperse, just because if it had all come in a wire, I could have dispersed immediately because those are considered received funds. But with it being a check, I wanted to wait, and so I let both of them know that I had received the money and that I wasn't going to do it on the 10th day, but that I would do it shortly thereafter.
Did the defendant ask you to do anything when it came time to dispersing his firm's share of the funds?
He did, yes, sir.
All right, tell me about that conversation.
When it came time to disperse the checks, and I was calling him and the other lawyer to let them know that I'd have the checks ready, I guess somewhere around March the 10th, Alec told me that he was going to put the monies into an annuity, that he was going to put his fees in an annuity. He called it a structure, but in essence he explained he was going to put those monies into an annuity, and that the checks needed to be made payable directly to him instead of to his firm so that he could do that.
Okay. And did he explain to you why he was going to do that?
He had just indicated that he was putting money away. He indicated he was concerned about the boat case, and that he was going to put some monies in an annuity or into a structure.
You say he was concerned about the boat case. What exactly what was he concerned about? What did he tell you he was concerned about?
He was concerned about his exposure in the boat case.
In a civil lawsuit?
Yes, sir.
And you were aware that the defendant had been sued civilly in the boat accident case?
I didn't know if he had been sued himself, but I knew there was a lawsuit going on involving, and I believe I did know that he was himself sued at that time. Yes, sir.
So this was different than how you normally did things, correct?
Very much.
Did he have any further explanation to you as to why this would be okay? Why this was all right to do?
He told me that he had already cleared it with the partners in his firm. I mean, he was a partner himself with the authority to do things for the firm, but he told me he had already cleared it with his partners in the firm, and that they were going to put the monies on the books and that they would be accounted for at the end of the year whenever they did their year-end settle up, that he would already be accounted for as having been paid these monies already.
Looking back at this exhibit that's now up on the screen, on March 10th, Exhibit 450, he says, I need to get the check today. Is that correct?
Yes, sir.
And did he tell you any more about why he needed to get the check today?
I spoke to him on the phone that day, and he just asked me if the checks were going to be ready that day. As I recall, I was on the road. I wasn't sure I was going to make it back to the office or not. My bookkeeper was getting the checks ready, and I spoke to him on the phone and told him that if I got back in time to sign the checks, I'd have them ready that day. He told me he'd like to get them that day. Yes, sir.
He told you that he had already cleared this with the partners. They were okay with him getting this money right now instead of having to wait till the end of the year.
He told me that the partners were aware that the monies were being paid to him, that he was going to put them into annuities, and that they would be accounted for on the books of the firm as already having been credited as paid towards him.
Did you believe the defendant when he told you these things?
Yes, sir. I didn't have any reason not to.
Your best friend?
Yes, sir.
Did you trust him?
I did.
Didn't set off any red flags to you at this point?
No, sir. And I'd known him for 30 plus years and didn't have any reason not to trust him.
Did you ultimately initially write a couple of fee checks?
I did, yes, sir. I think I wrote one check in the gentleman's case and one check in the lady's case. And then the gentleman's check was rewritten into two checks. These were, when I say these checks, I'm talking about fees that were paid.
Okay. I'm going to show you what's previously been marked as State's Exhibit 345. You said the total fees that were going to go to Alec in this case were how much?
$792,000
And he asked you to write the checks out to who?
to him,
Him directly.
Richard Alexander Murdaugh,
Instead of what?
instead of PMPED or the law firm.
Which would be the normal practice.
Yes, sir.
All right. I'm going to show you what's been marked as 345 and see if you recognize this document. State's 345.
I do.
All right. What is that?
So this is a check that was initially written to Richard Alexander Murdaugh, Esquire, for $600,000 on March 10th, 2021. This says fees on the bottom. This would be the fees on the gentleman's case for payable to his firm, which Alec told me to write to him. This check was voided and rewritten into two separate checks.
All right.
It's marked void.
All right, Your Honor, this time I would move to admit State's 345 into evidence.
Your Honor, we do not have any additional objections to that document.
It's admitted.
All right. And this check is made out for how much?
$600,000.
All right. And again, there were two cases, so there were going to be two separate checks. Is that correct?
Yes, sir. This was just the fees on the gentleman's case.
And that was going to be how much total?
Total was $792.
But this one is
$600.
And then the one for the other one?
$192.
192. Okay. All right. And so you initially write this check. Did you deliver this to the defendant, or what happened?
I didn't deliver any of the checks. I believe he had somebody pick them up that day from his office, a runner or something like that. But no, so this check was voided out, and we rewrote two separate checks made payable to Richard Alexander Murdaugh.
Why did you do that? Why did you void this one for $600 and then write two separate checks?
When I called Alec and told him, or when we were talking and I told him I thought the checks would be ready, he instructed me that he was doing three separate annuities, and so it would need to be in three checks, and that this check would need to be made out in two different checks that totaled $600,000.
A bunch of different annuities, huh?
Yes, sir. It wasn't all going into the same annuity or the same place.
So you recut into 2 checks, is that correct?
Yes, sir.
All right, I'm going to show you what's been marked as States 346 and see if you recognize that set of documents, please.
Yes, sir, I do.
All right, just flip through it real quick.
Yeah, let me tell you what they are.
Well, just flip through it first, if you would, please.
Yes, sir, I recognize all of this.
All right, and tell the jury what those are, please.
So the top document is the $192,000 check dated March the 10th, 2021, made payable to Richard Alexander Murdaugh, Esquire. And on the bottom it says fees. That would have been the fees on the ladies' loss of consortium case.
Okay.
The back of it, the rest of it's just the back of the check. Looks like it's endorsed Bank of America, deposit only. A signature that looks like Alec, but it's kind of scribbled and says Bank of America.
Okay.
The next page is a check for $225,000 dated March 10th, 2021, payable to Richard Alexander Murdaugh, Esquire. And on the bottom it says fees. This would be part of the rewrite of that $600,000 check.
All right.
Same type of endorsement paperwork on the back. And then the third check is a check dated March 10th, 2021 for $375,000 made payable to Richard Alexander Murdaugh, Esquire. And on the bottom it says fees. And that would be the second part of the rewrite of that $600,000 check for the fees in the gentleman's case.
Your Honor, at this time I would move to admit States 346 into evidence.
We don't have any additional objections, Your Honor.
They're admitted.
All right, I'm going to show you what's been marked as States 347. See if you recognize those 2 documents, please.
I do.
All right, tell me what those are.
So these are 2 checks from my firm made payable to Peters, Murdoch, Parker, Ellsworth, and Dietrich. The memo part is redacted, but I know what these are. So these were cost reimbursement checks in both of these cases. One check for the gentleman's case and one check for the wife's case. They're dated May 13th of 2021. Made payable to the law firm. One of them is for $14,619.13, and one of them is for the same amount except for 14 cents.
All right, tell me the date on those expense checks, please.
May 13th of 2021.
And go back, if you would, and let's again remind the jury what the date of the fee checks are, particularly after they were recut at the defendant's request.
March 10th of 2021.
Let me put these up on the screen real quick. And Your Honor, I'll move in States 347, please.
No objection.
They're admitted.
All right, we're at States 346, and this is the check for $192,000. Is that correct?
Yes, sir.
And the date is March 10th. Is that right?
Yes, sir. That's the day that all 3 lawyers' checks were cut to be paid.
Same date of that text the jury's seen, correct?
Yes, sir.
Next page, this is the check for how much?
$225,000.
And that's part of the $600K?
Yes, sir.
Same date?
Yes, sir. March the 10th.
And that's your signature on there?
It is.
Going back to the first one, you said that looks like whose handwriting?
Yes, sir.
Whose?
Alex.
Right there on the second check on the back. That looks like whose handwriting to you?
I mean, the top left of it looks like Alex's signature.
Okay. And then finally, this last check, that's the $375, that's part of the $600,000?
Yes, sir.
Is that your signature right there on the check?
It is.
And the same date?
Yes, sir. March 10th.
And do you recognize that signature at all?
I mean, it looks like Alex, but I mean,
Best as you can see on this
best I
document.
can tell, yes, sir.
Okay. All right. What those particular checks? What did you? Once those were cut, the defendant's been texting you about it. What did you do once you recut them?
I think, as I said a little earlier, at some point in time we were having a phone conversation, and I told him that I was on the road, that if I got back and was able to sign them, I'd let him know. And I ultimately did make it back to the office, I believe, that day, was able to get the checks signed, and either called him and said they're ready, and he said I'll send somebody up to get them, or maybe I called him as I was going back to the office, but before I actually signed them, and said, hey, I will be back to sign them and they'll be ready. And he said, well, I'm going to send somebody up to get them. And so they would have come up. I think he had a runner come up that day that would have picked up a package that had those checks. I don't remember exactly for sure, but generally it's going to be those checks, a cover letter, and a package that has a partial disbursement sheet. Our client had signed off on allowing the fees to go ahead and be paid. Then, while we were waiting on some liens to resolve themselves, some costs to come in, and some things like that. So our client had signed off on a partial settlement statement, and I would have provided that.
The voided check we saw before, and these checks all have the same date, is that correct?
Yes, sir, they do.
All right, and do you recall anything about that? Did you call him up and say, hey, great news, I got it taken care of? He said, wait. How did that go down?
I don't remember. I don't remember how many different conversations we had that day, whether it was over, one conversation or two conversations. I don't remember. But at some point, he instructed me that the $600,000 check needed to be made into separate checks.
And he sent somebody to pick
I
them
think.
up?
I didn't mean to cut you off. We talk a lot every day, and so we probably had multiple conversations that day. But at some point, he instructed me to do that.
He's one of your best friends.
Yes, sir, very much. Not just my best friend, Mr. Waters. Our families were close. Our kids, our wives, we're close.
You had a friendship with Maggie, too.
Yes, sir, very much.
You had a friendship with Paul, too.
Yes, sir.
You had a friendship with Buster, too.
Yes, sir. Haven't been able to have that since. Not like it was, but yes, sir. Hope to one day. But yes, sir.
Why didn't you disperse the fee checks the same day? Do you recall?
The fee checks were
I'm
dispersed.
sorry, my bad.
Cost
The
checks.
expense checks, the cost checks.
Yes, sir. We were still waiting on some costs to come in, and we had several experts in that case, and it's not abnormal to have costs that come in after a settlement or after a verdict that you reach. Sometimes you're taking depositions up to the last minute. Sometimes you have experts that are working. They're going to send you their bill for their trial time, and so a lot of times those costs will come in. I think our client had authorized us to hold some money back in escrow for an expected cost. And so we had a lot of bills that were coming in even into late April.
You mentioned that the defendant had said something about his exposure in the boat accident lawsuit as a reason for structuring these fees.
Yes, sir.
Did he say any more about that?
Not in that conversation when he asked me to write the checks directly to him. We had had some other conversations, and I don't remember if they were before this or after this. I think they were after, but I don't remember for sure, where he had just said that there was, some fights going on between insurance companies.
When the defendant asked you to do this unusual step and write the fees direct to him, and you said you trusted him, correct?
Yes, sir.
What was your general perception of his law practice, of his wealth, of his financial security, knowing him as well as you did? What was your perception of that?
Big firm, big reputation. Alec had a big reputation. I thought he made a whole lot more money than I did. Everything I knew from the way his partners treated him, the type of cases I saw him working on with them, the type of cases I knew he worked on with me, that he was, one of the biggest dogs in that firm, one of the biggest producers they had. Seemed to own a lot of things, do a lot of things, spend money. didn't ever seem to have problems. And I knew I was associating him and his firm on very good cases throughout the years, and I knew other lawyers that were. It just seemed like they were doing very well, and that he specifically was doing very well.
And is that perception that you had of him one of the reasons why you trusted him? That there was no shenanigans going on?
I don't know that that's the main reason. I trusted him because I knew him and had dealt with him personally and professionally for a long time. But I had no idea if he was having money problems. I mean, I would have never suspected that his asking me to write checks to him had anything to do with money problems on his behalf. Nothing gave that appearance. So, I mean, that could have factored into the back, but mostly it's just I knew the guy and I trusted him. And he wasn't asking me to do anything that raised any flags with me. He told me he had cleared it with his firm and with his partners. I didn't have any reason to doubt that.
I'm going to put States 347 up on the screen. And what are these again?
That's a cost reimbursement check in one of those cases. I can't tell you which one it is.
All right. And then if we go 2 pages back, this is the other check?
Yes, sir, in the other case, cost reimbursement.
All right. And those are the same amount?
1 penny difference. I think Alec sent me the cost total, and I just split them evenly between the two cases.
And what's the date on that check, those checks?
May 13th of 2021, which I believe would be the time, obviously, we wrote the checks, and they would have been mailed to his office shortly thereafter.
And you said that there was a reason why these came a couple months later?
Yes,
Y'all
sir.
were waiting for some information?
Waiting on costs to finalize up. Instead of writing multiple checks as costs came in, we just kind of wait sometimes till the final bill's received.
Is that your signature on these checks?
Yes, sir.
And those would have been mailed to Alex Law Firm, correct?
That's the general practice, yes, sir, is we mail them to the firm. And I don't know any reason why these wouldn't have been done differently.
In May of 2021, did your office, after these checks were mailed, did your office receive any communication from the defendant's law firm?
My paralegal, Vicky, received an email from Alex Paralegal,
Okay.
Annette.
And tell me about that. What was the communication? It was received from Annette?
Yes, sir, from Annette Griswold, Alex Paralegal.
All right. Your paralegal, Vicky, received a communication from Annette Griswold, the defendant's paralegal.
Yes, sir. Vicky got an email from Annette that said, hey, we got the, something to the effect of, hey, we received the cost checks, either why no fee checks or where are the fee checks.
Okay. And did Vicky respond to that?
She did.
And what did she respond?
She responded to Annette that the reason the fee checks weren't included is because they had already been paid to Alec, that he had already received the fee checks.
Was that on about May 19th, 2021?
I'd have to look at the email, but I believe so, yes, sir.
Did Vicky raise any issue with you at this point? Did you know anything about it at this point?
No, sir. I was preparing, I was in trial the following week in Hampton, actually, all week long, and I was preparing for that. Vicky sent that email back. She didn't notify me about that actually until all this blew up, and I turned all that over to SLED after we found it, after all this blew up in September.
Moving into late May 2021, did this matter that Annette was raising with your firm come to your attention?
It did.
And tell
And
me.
it wasn't late May. It was the first part of June.
I'm going to show you what's been marked as Exhibit 348, and let's take a look at that real quick before we move on.
Sure.
See if you recognize that.
I do.
Tell me what that is.
So this is an email string that begins on May the 27th from Jeannie Seckinger, which is the bookkeeper or accountant in Alex Law Firm. And it's an email from Jeannie to Annette Griswold, Alex Paralegal, on May the 27th, where she's telling Annette that she got the expense checks and it didn't match their records, that Alec thought he had more outstanding cost but can't say what, and was asking Annette to reach out to my office, to Vicki, to get some more information. And then it looks like Annette forwarded that email to Vicki on May the 27th. Vicki was on vacation and did not come back in until the following week. It looks like she emailed her again on June 2nd. Vicki might have come back in on like June the 1st, or I think May the 31st was Memorial Day, a Monday, and so June the 1st was then when Vicki came back in. So Annette emailed her again on June the 2nd and asked for some information, and then Vicki emailed her back and said, since this involves documents she didn't deal with, which was bookkeeping stuff that she didn't deal with, she would forward it to me.
And so that happened on what day?
June the 2nd,
Of what year?
2021.
Your Honor, this time I'd offer States 348 into evidence.
No additional objections, Your Honor.
Admit it.
All right, and so this is going to the bottom. This is the email from Jeannie to Annette. Is that right?
Yes, sir.
And then that gets sent from Annette to Vicki on May 27th, correct?
Yes, sir.
And then she gets back from vacation, and then she responds on June 2nd, 2021, correct?
Yes, sir.
And what does she say?
She's going to forward that to me. And she did. She CC'd me up in the email string.
All right. And did you have a conversation with Vicki at that time about this issue?
I did.
And what did you tell Vicki? Or what was y'all's conversation?
She said, I've gotten this email from them asking about the cost in this case. What do you want me to do? And I said, tell them that you'll forward it to me and I'll deal with it.
Around this time, had you had any conversation from any other partners in PMPD, the defendant's law firm?
As best I recall, Mr. Waters, I was in Hampton the entire week before, and I was working out of their office. I was trying a case down there like the week of May the 24th, and I was working out of Alex Firm's office. Lee Cope approached me and said, hey, I need to talk with you about this back truck case. Has all the money been dispersed? I said, Lee, it hadn't all been dispersed. We've got some liens, some medical liens we're waiting on to deal with. We've got some costs that we're waiting on to come in, and it all hadn't been dispersed, but I don't know off the top of my head. I'll have to check on it. And I was stuck in trial through Friday of that, or through Thursday of that week.
Did you reach out to the defendant after Lee had that conversation with you?
I reached out to him after I got this email.
All right. And tell me what your conversation was with him when you reached out to him, having received this email from Vicki asking about these fees.
I called Alec. I said, Alec, I got this email from your firm. They're asking about issues with costs, that you think you've got more costs that are owed to you. I put down on the settlement statement and wrote checks for the amount of costs that you gave me. But if there are more costs outstanding, just figure out what they are, because we've been holding some money back. And I think at that point we were waiting on a medical lien to resolve. And I don't think the client will have a problem paying the cost out of what we're holding back.
Did you have any discussion about the disbursement of the fees at that point?
I did. I said,
tell me about that.
I said, Alec, this is the case that you asked me to write the fee checks directly to you. Is everything all right? And he said, yeah, everything's fine. I just need to make sure my partners know that this is the same case, that you wrote the checks to me, and that it's already on the books.
Did you believe him?
Yes, sir.
After you had that conversation with the defendant, did you do anything else, or did you think it was handled? Because you had spoken to your best friend, Alex Murdaugh.
He told me it was taken care of. He told me he had talked with his partners about it. I didn't think there was any other problem. I didn't do anything else.
A couple weeks later, did you have another conversation with him about this same issue?
Yes, sir. This would have been after June the 7th, yes, sir. And it might have been more than a couple weeks, because I didn't ask him anything after Paul and Maggie. I didn't want to. I asked him if everything was all right, and he said it was fine.
got that email forwarded to you from Vicky on June the 2nd. Did you call Alec that day?
I think it was, I didn't cut you off, but I think it was that day.
Thereabouts?
Yes, sir.
You remember June 7th, 2021?
Yes, sir.
Was that a Monday?
Yes, sir.
Gamecocks had played some baseball that weekend. You'd
Yes, sir.
seen the defendant?
I'd seen him and Maggie and Buster, my wife and I, and our children. Had been with him and Maggie and Buster the weekend before, Saturday, yes, sir.
On Monday, June 7th, 2021, what was your day like just during the day?
Went to work. I was in the office most of the day. I think I had something scheduled that had canceled out. And ate lunch with a friend. And I live in Columbia, even though I practice in Bamberg. Kind of later in the day, I ran by the pharmacy, picked something up, and then headed to Columbia and stopped to pick something up at the store on the way home.
Went home,
Yes, sir.
normal evening?
Yes, sir.
Remember what you were doing that evening?
Just hanging out with my wife, and I don't remember how many of our kids were home. But I think just our youngest, just watching TV.
Watching TV.
Yes, sir. I was kind of late getting home, so there wasn't a whole lot of the evening left.
That evening, did the defendant call you?
Yes, sir, he did.
About what time did he call you?
I don't remember exactly. I turned my phone records over, but I think it was around 9:20, 9:15, 9:20.
Before we talk about that, I'm going to show you States 451. Do you recognize that?
I do, yes, sir.
What is that?
This is my phone log that I turned over to SLED.
Does that reflect calls from Alex Murdaugh on the night of June 7th, 2021?
Yes, sir.
Well, tell me.
To and from. Porch, and I was trying to mess with something with the pool pump. Sounded like it was running funky, and so the phone rang, and it was Alec, and I answered the phone.
What did he say?
He said, "Hey, hey Bo," is normally how he would greet you, "Hey Bo," and I don't remember if he said, "What are you doing?" or what. I pretty quickly told him, "Hey, I've got my hands in the middle of this pool pump, messing up. Can I call you right back?"
Did he sound normal to you?
Sounded normal, yes, sir.
So you said, "Hey, I'm busy right now. Let me call you back."
I did, yes, sir.
And what did he say?
Said, "That's fine, no problem."
And having that exhibit, and Your Honor, I apologize, I'd move. States 451 into evidence at this time.
Submitted.
And having a chance to look at your phone records there, what time was that first call?
Looks like it was at 9:11 p.m. incoming from his cell phone.
All right, so you got off.
2-minute phone call.
2-minute phone call.
Yes, sir.
So you got off the phone. What happened next?
I finished trying to fix the pool pump, called Alec back,
All right. And what time was that?
9:20 p.m.
And tell me about that conversation. Tell the jury about that conversation.
Called Alec back. I generally say, hey, Bo, too. And, hey, Bo, calling you back. He said, hey, I'm about to get to my mom's house. Can we talk a little bit later? I told him, sure. There were a couple of things I needed to talk with him about, cases that one case that we were working on and one case that I had going on. I wanted a little advice. Ask him how his mama was doing, and I asked him how his daddy was doing because I knew his dad was getting a lot worse. We had talked about that over the weekend at the baseball game in Columbia, and I think we had talked on the phone on Sunday also. So he said, can I call you back or can we talk later? And I said, sure.
You said his daddy was getting worse. Had he called you that day, Monday at all, to give you any updates to your recollection?
I don't think we talked earlier in the day on that Monday, but we had talked on that Saturday before and on that Sunday before. And so I knew his father was getting worse, and I think I knew that he was either going to or had already gone to the hospital.
So that second call, was that also very brief? He said, hey, I'm at my mama's.
3 minutes.
So what happened after that? You still watching TV?
Still watching TV, yes, sir.
Did you talk to the defendant again?
I did. He, I believe, texted me sometime later that evening, and I think the text was something, are you still up or still up, something like that.
All right, stand by for me real quick.
Sure.
I'm going to show you what's been marked as States 452 and see if you recognize that document.
Yes, sir. This is a snapshot of text communications between me and Alec that I snapshot and provided.
All right. Your Honor, this time I'd move States 452 into evidence.
No objection.
Submitted.
452. This is a screenshot of the text that you of your text that you provided. Is that correct?
Yes, sir.
All right. And we see down at the bottom, is that a text? Who is that text from?
That's from Alec to me at 9:52 on June the 7th. It says, call me if you up.
Okay. Did you receive that text? Were you still awake at that point?
Yes, sir, I was.
All right. And what did you do?
Picked up the phone and gave him a call.
Okay. And tell me about that conversation.
Um,
Call it one time or two times?
No, I called. The first time I called, he didn't answer, which is kind of normal with Alex sometimes. Sometimes he wouldn't answer because he was either on the phone or sometimes he was just in bad service, I think, and couldn't get a call to go through. So I'm pretty persistent. I call right back. So I called him. I didn't get an answer, and then I called him back. And that was at 9:50. According to these records, 9:52 is when I tried to call and didn't get an answer, and I called back at 9:53 and said, "Hey, Alec, I got your text calling you back. How's your mama?" And he said, she's doing about like normal. I think. I mean, she'd been doing poorly for years. And I told him I needed to talk to him. We had a case we were working on that involved a piece of equipment that had malfunctioned, and the company had preserved the equipment, but they weren't going to preserve it too much longer. We needed to get it inspected, and they were kind of pushing on us about when the inspection was going to occur. And I said, hey, we need to talk about this and get this squared away so we don't miss the chance to inspect this equipment, and I need to talk to you about some motions or something I've got upcoming that I need a little help on. And he said, hey, that's cool, but I'm about to get back home. Can we talk tomorrow? And I said, sure, fine.
That was some total of what he had to say was he's about to get home to Moselle, and can we talk tomorrow? Correct?
Yes, sir.
We put States 451 up on the screen. And right here, is that your writing right there?
That's my handwriting, yes, sir.
And that says Alex M., and those are the defendant's calls, is that right?
The bottom one is him calling me and me telling him I'm on the pool pump. The next one is me calling him back and telling me he's about to get to his mama's. And then the next one up here is me trying to call him after that text that he didn't answer. And then the top one is me calling him back after he didn't answer and talking to him for those couple minutes.
All right, and then that one in the middle, that's just an irrelevant conversation with some other person?
Just a friend of mine who I told his name was probably coming out today. So I told him that he was on my phone.
We did scratch out his number.
That's right, yes, sir.
Now we did.
Yes, sir. I felt like his name would probably come up today, and he should know that.
Just go about your evening after that? Did you just go about your evening after that?
Pretty shortly after that, I went on to bed. My wife stayed up, but I went on to bed shortly after that.
How'd you find out?
I was asleep. My phone's always kind of sit beside the bed. I could hear it buzzing, but I really wasn't paying it any attention. My wife comes in kind of, just hysterical. She says, you got to wake up, you got to wake up. And I don't remember if she was on the phone with Randy's wife or Randy himself. She's trying to tell me what's going on, and I'm looking at my phone, and I've got a text from a person I knew in Hampton that's texting me saying, hey, give me a call. I got to tell you something before you hear it somewhere else. It was a person that was in the county government down there that I knew that was just trying to get word to me before I heard it somewhere else. My wife, I don't think I respond to that person or her text immediately. My wife's telling me what's going on. I just told her, I said, I'll get some clothes. I got to go to Moselle. We started trying to call our daughter right at about 11 o'clock. Started trying to call our children, tell them what was going on. I don't even know how much my wife and I spoke about it. I mean, she knew I was leaving. I got in the car, went straight to Moselle, grabbed some clothes and went straight to Moselle.
So how long does that take?
From Columbia, about an hour and 40 minutes or so. I mean, I called some different people on the way that I thought needed to know. I mean, repeatedly tried to call my daughter. She was extremely close. She is and was extremely close to Buster and Paul. And, we couldn't get her to answer, called her boyfriend, just repeatedly calling her. I think I talked to Randy on the way down, but I can't say for sure I did, but I know I talked to somebody in their family on the way down just to tell them I was on the way.
About what time did you get to Moselle?
About 1 o'clock in the morning.
Other family and friends were arriving then too?
Already had arrived, I believe, yes, sir. I mean, when I got there, I went through the main gates. I could see, I don't know that I knew at that point that this had occurred at the kennels, but I could see that there was tons of activity there as I passed by to go to the main gate, and when I turned in the main gate, I was on the road headed up to the house. You don't go very far and you can turn right to go to the kennels. I almost was going to turn and go down to the kennels, and I think John, Marvin, and Randy were walking out and kind of waved off and said, go to the house.
Is that where you went?
Yes, sir.
Was the defendant there?
He was, yes, sir. Yeah,
You talked to him?
I did. I walked in, hugged his neck, and cried. Didn't know what to say.
Hug his neck and cry.
Yes, sir.
A lot of people there coming out to support him, as you would expect, correct?
Yes, sir. There were a lot of the lawyers that he practices law with, several family members, you know, some friends of his that I knew. There were a lot of people already in the house, yes, sir.
Did you stay there during the early morning hours as a friend, supporting your friend?
Yes, sir, till 5:30 or so in the morning. 4:35, I don't know. I mean, it's all, I mean, everybody was shocked and destroyed, and I mean, times it felt like it stood still. So I don't know exactly what time it was, but sometime 4 or 5 o'clock that morning, everybody decided it would be best for Alec and Buster to go get some sleep, or at least try to, and not stay there that night. And so I went back to Bamberg and slept in my office.
Did you return to Moselle the next day after getting some sleep?
I did, about 9 o'clock that next morning.
Were you there as much as you could be at Moselle or wherever you were needed over the next few days in the aftermath of all of this?
Yes, sir. I was there almost entirely the next 2 days.
At any point, did you ever have any conversation with the defendant about what he did that night?
Not really, no, sir.
What do you mean by not really?
I mean, I didn't ask him. I didn't want to know what he found. I didn't want him to have to describe that to me. I didn't want him to have to relive it, so I didn't ask him about it.
Didn't ask him.
No, sir.
It's only natural.
Yes, sir. I mean, I was there as a friend, supporting him and his family. I didn't need to know the details. I knew all I needed to know is that two people that I loved were gone.
Certainly weren't going to ask him about the stupid issue with the fees in this time.
No, sir, not at all. Didn't know there was an issue with the fee. I mean, I did not know there was an issue with the fee at that time, so I didn't have anything to ask him.
Over the next few weeks, did you do what you could do to be a supportive friend?
I did. Yes, sir. I mean, I tried to call him even more often. If I was anywhere close to Hampton, I tried to stop by and check on him. I tried to make him go places and do things. Not much, but I felt like he needed to get out. You know, just, I mean, I was worried he was going to hurt himself. I mean, I was worried he was going to kill himself, just like I think a lot of people were, family and lawyers, his partners. And so I think we all talk regularly about keeping an eye on him, and about being there for him.
After a few weeks go by, the shock starts to abate just a little bit.
It still hadn't abated.
Still hasn't abated, just a little bit.
Yes, sir.
At some point, does the defendant call you about those fees?
He does. Yes, sir.
You remember roughly when that was?
Sometime around the middle of July.
What does the defendant say to you?
He tells me that he has not been able to put the monies into the annuities like he thought he could, that he's messed it up, and that the monies needed to be paid to his firm, and that that he needs to send the money back to me to run it through my trust account to write the checks to his firm directly.
You remember how that conversation came up?
I don't remember exactly how it came up, no, sir.
But he contacted you to say, hey, I messed up those annuities, I need to send the money back to you, correct?
Yes, sir.
Did he send the money back to you?
Not all of it, no, sir.
What did he send back to you?
600,000 of the 792.
And in what form did he send that money back to you?
It came in the 600,000 came in two separate wire transfers.
Tell me about those.
I don't remember the dates, but I think it was July 15, July 16, somewhere around in there. One came from Palmetto State Bank, and I think one came from Bank of America.
One for $350 and one for $250,
I
correct?
think, yes, sir, I believe that's right.
That was only $600,000, correct?
Yes, sir.
And you had dispersed to him directly how much?
792,000.
Did you have a conversation with him about the fact that it was $192,000 short?
Yes, sir.
And what was that conversation?
He told me that he had already put the 192,000 away to where he wasn't going to be able to access it. I took it that he had already put it into the annuity and that it wasn't going to be available without some type of penalties or cost. And he said, I don't have the 192, but I'll be able to get it to you very shortly or soon. I don't remember if he said within a couple of days or a couple of weeks or what he said, but it was soon.
What did he want you to do, though, once this money came back in? Did he ask you to do anything?
To rewrite the checks payable for the fees to his firm.
Did he ask you to communicate with the firm at all?
He asked me when the money was back into the account if I could send an email that I was holding those monies so that they would know those monies were in the trust account.
All right. But you're $192,000 short, so what was his discussion then?
He told me he didn't have the $192,000. And I mean, at that point, I know that I've got a trust account for which I'm responsible for. I've got money that's supposed to have been in my trust account payable to his firm for fees. That's my responsibility. And so I had to put $192,000 of my own money into my trust account to hold for the fees for his firm.
And how did you do that? How did you put $192,000 of your own money into your trust account to cover the defendant?
I wrote a check for myself and put it into my trust account.
And just quickly, explain to the jury why you have to do that. What is it about a trust account that you have to do that if you're going to send that email to the firm?
Because I can't tell somebody I'm holding money in my trust account that I'm not holding in my trust account. I'm responsible for that trust account. Trust accounts are money that belong to someone else that you're holding in a fiduciary relationship, and you're responsible to make sure that those monies are held and dispersed appropriately. And at this point, I'm hearing that I haven't dispersed or paid those monies the way they're supposed to be paid.
At that one time, did he ask you to cover that money, or was that just kind of a given that he was short?
I knew I had to, and I think he asked me to, but I knew that I had to.
So you get the $600,000 from the two wires, and you write $192,000 of your own money,
Yes, sir.
and then you send an email to the law firm. Is that right?
I sent an email to Alex,
To Alex?
yes, sir, that he tells me he's going to forward to his firm, which I, ultimately found out that he did forward to the bookkeeper and one of his partners.
I'm going to show you states 349 and see if you recognize that.
Yes, sir. This is an email I sent on Monday, July the 19th, 2021 to Alec.
All right. Is that the email you're talking about?
Yes, sir.
All right. This time I've moved states 349 into evidence.
No additional objection, Your Honor.
Admit it. Can you read that email to the jury, please?
Sure. Alec, as discussed, I'm confirming that I am holding in trust $600,000 in the, and that's just redacted to take the gentleman's name out, the gentleman's case. and $192,000 in the, and that's redacted out to take out the wife's name, in the wife's case, which represent attorney's fees. I will continue to hold these monies in trust until I am instructed by you or your firm regarding payment.
After you sent that email, did the firm contact you? Did you have to disperse the money, or did that just kind of end the matter?
Not until September the 3rd, when Lee Cope called me after they claimed that, after they say that they had discovered that Alec was stealing money.
Well, let's talk about the interim. But at that point in time, you sent that email, and nobody's making any further inquiry at that point in time. Is that correct?
No, sir.
All right, and that money's just sitting there,
Sitting in my trust account.
including your personal 192 that you wrote to cover Alec, correct?
Yes, yes, sir.
Did you ever have a conversation with Alec about when he was supposedly going to get you that money?
Yes, sir.
Tell me about that.
I know we talked about it one time. I think it was at the August convention down in Hilton Head that most of the lawyers that do what we do attend. I had begged Alec to come down there and for Buster to come with him at least one day to play golf with some of us so they'd get out and do something so Buster could do something normal. And I think it was while we were playing golf that I just said, hey, where do we stand on you getting me repaid? He told me that, I knew that Maggie's estate would be tied up, and I figured that that was a delay. He told me that he was, moving towards selling some property and that his father had obviously just passed and that there would be some money coming to him from his father's estate and that he was working on it and he was trying to do it as quickly as he could. He apologized for it taking longer than he said it would.
Had he told you that he had tied up some money in structures or something like that, and that's why he couldn't get to it right then?
That's what he told me, why he couldn't get the $192,000, because that he had already put it into, the way I understood it, he had already put it into the annuity and couldn't get it back out. I think once you put those monies away, is my understanding, is you can't just pull them right back out. It's not like a checking account or a savings account where you can deposit and withdraw immediately.
But that's what he's explaining to you, correct?
Yes, sir.
So that conversation you had with him at the trial lawyers conference playing golf, that was when, roughly?
First weekend in August. Actually, it'd probably be that we normally try to play golf on that Thursday, so whatever the first Thursday in August is.
Not long after that, did you have another conversation with him about the money that you had covered for him?
I did.
And roughly when was that?
Sometime shortly after that, in the middle of August maybe, I called him up and said, I need to come see you and talk to you about something, and I went down and talked to him about this money. But it wasn't it was about the money. I needed to be repaid. That's a lot of money to me, and I wanted to be repaid.
$192,000, that's a lot of money.
Yes, sir.
A lot of money to anybody.
Yes, sir.
I'll show you what's been marked as States 350. You recognize that?
I do.
And what is that?
So,
What's the date on that first?
August 17th of 2021.
Your Honor, at this point, I'd move States 350 into evidence.
Additional objection.
It's admitted.
All right. Tell me about that document. What happened? What's your conversations related to that document?
At some point in time when I'm talking to Alec, I said, hey, I need to come see you in your office and talk with you about something. I don't even think I told him exactly what it was. He said, sure. So I went down and went in his office. I said, look, I hate to even talk to you about this and I hate to ask you this, but if something happens to you, and I think I phrased it like if you get hit by a car or something happens and you die, I can't get repaid that money against your estate unless there's something in writing between us. I knew enough to know, enough of the law to know that you can't enforce an agreement with a person that's deceased against their estate unless you got some documentation of it. And I said, boy, I hate to even ask you to do this. And I was worried that he was going to kill himself, still at that point. And I was worried about what that would, mean, more so on a human personal level, but also what that would mean about me trying to get repaid. And I said, I hate to ask you to do this, but can we do this? And he said, sure, no problem. That's our agreement, and sure. And so we scratched out, he hand wrote it, 3 sentences, nothing formal or fancy.
This is on what day?
August the 17th, and I was in his office.
Hold on for me 1 second.
I'll stand for a moment. These conferences, isn't it? Ladies and gentlemen, we have you go to the jury room for recess. Please do not discuss the case.
I just, out of an abundance of caution, before we got to this portion of the witness's testimony, as Your Honor is aware from the in-camera proceedings, there is, he has a confrontation with the defendant, and the defendant tells him some things that he, the witness here has a confrontation with the defendant at his mother's porch after receiving word about what the law firm had found. From the in-camera testimony, the witness has testified that the defendant, admits the financial misdeeds, says he had a drug issue, I think going to rehab, and some things like that. And that is, I believe, on the early afternoon of September 4th. And then not long after that, he hears that the defendant was shot on the side of the road. And so we've had some discussions about the drug issue. So before listening to that testimony, I alerted the defense and wanted to make sure that we had set our ground rules on that. And then, of course, the side of the road issue, which we've talked about earlier.
What ground rules did you set?
Your Honor sets the ground rules, and that's.
You take a break during questioning the witness to have a conference with counsel.
Well, I am seeking to admit that evidence, not only of what the defendant said about his drug use, but also to submit that not long after that he heard about the side of the road incident, and I, out of abundance of caution, raised that issue, and I believe the defense was going to object. Trying to give them the opportunity to do that in an in-camera setting.
All right.
Which, Your Honor, for both of those, I think they are admissible. As first of all, again, we're not offering any drug use, and we've had some discussion about that yesterday. We're not offering any drug use for the purposes of what's improper under 404. In this particular instance, the defendant himself identifies that as a reason for these alleged misdeeds. So not only is it not 404, it's just part of the res geste of his statement, which is part of what's been admitted.
It was admitted yesterday, so we're beyond that issue as far as the court is concerned.
All right. And then as far as the side of the road,
particulars of which have not been disclosed, but the email from Mr. Murdaugh doing rehab was published by the defense.
yes, sir. And then secondly, along with the side of the road, again, at this point in time, just going to be admitted that he heard about what had happened to the defendant. There are other circumstances that we talked about earlier that we would address at a later time about the side of the road, which we believe is admissible and admissible under 404. We could I don't know that we need to have an in-camera proceeding at this point in detail about that, but because all he's going to say is he heard that happen, but I just wanted to, again, and out of abundance of caution, we've gone this far. I just wanted to be, before I elicited anything along those lines, just wanted to alert the defense and give them a chance to object.
All right. Mr. Griffin?
Yeah, we do object, Your Honor. First, he's not the proper witness to be testifying about what happened on the side of the road. He just hears it secondhand, so any information he has is just hearsay. In the in-camera hearing, he also provided his opinion that Alex must have tried to commit suicide, and that's improper. So first it's hearsay, but more importantly, Your Honor, it is a bridge too far under the narrow exception that you've offered, that they're offering this evidence of financial crimes, that that is some motive for this alleged murder that he committed. And so the fact that whether it was an assisted suicide or they want to go further and say it's part of the same scheme and that it's a sympathy ploy, which the court hasn't ruled upon, and we don't think it meets the standard there, and it violates Rule 403. So for all those reasons, we object to it coming into evidence.
Do you want to proffer what Mr. Attorney Wilson is going to say about it?
I believe during his prior testimony in the in-camera hearing, and I certainly can do that, he testified.
I recall his prior testimony.
Yes, sir. And
which did not involve anything about a roadside shooting.
well, and so I'll go ahead and proffer, Your Honor. Yes, sir. All right. So, Mr. Wilson, kind of jumping ahead, you had a confrontation with the defendant on September 4th when you drove to Hampton County to have a meeting with him on the porch of Alameda. Is that correct?
Yes.
All right. And pull the mic forward to you a
Yes.
little bit. And without getting into all that detail, after that conversation, he made some admissions to you at that time. Is that correct?
Yes, sir.
And just very quickly tell the court what he said.
He admitted or said that he had had a drug problem for 20 plus years. and that he was going to rehab. And then he said he admitted he had been stealing money.
And did he say anything about the 192 with you? Did he have a phrase he used for that?
Yes, sir.
What did he say?
You don't have to proffer this portion. You're indicating you're trying to go beyond this into something else.
What time did this, yes, sir, thank you, Your Honor. What time did this conversation take place, roughly?
Mid-late morning, just before lunch.
All right. And that's on September 4th?
Saturday, September 4th, yes, sir.
After that confrontation, did you leave?
I did.
And where did you go?
I went through Hardee's in Hampton, grabbed a bite of lunch at the drive-through, and then drove back towards Columbia.
Did you hear about anything relating to the defendant within a couple hours?
I did. I got a phone call from Lee Cope. Might have been Randy, but I think it was Lee Cope that called me and said Alec had been shot in the head and was being helicoptered. I thought he said to Savannah Hospital. I know he said to the hospital in a helicopter.
That's as far as this witness would go.
And I've sustained the objection as to this portion of the testimony. I agree with the defense's hearsay, and if it's and he's not the appropriate witness to testify on this issue.
Thank you, Your Honor. And so obviously, yeah, all right. And you're a lawyer. You understand where to stop.
Yes, sir.
All right.
We'll take a recess for about 10 minutes.
Come to order. Please be seated.
You may bring the jury. All right, thank you. You may proceed.
Thank you, Your Honor. When we left off, we were talking about the $192,000 that you had put in your trust account to cover the defendant, correct?
Yes, sir.
And he had signed his promissory note up on the screen. Is that right?
Yes, sir.
Before I move on real quick, I want to show you what's been previously admitted into evidence in States 313 and see if you recognize that.
I do, yes, sir.
And what is that?
Looks like the original of the $225,000 check payable to Richard Alexander Murdaugh, Esquire, from my trust account dated March 10th, 2021 on this case.
All right, and that's your signature on there, is that right?
Yes, sir.
Catch the jury back up. He had asked you to send that email. You sent the email in July, and then you had those conversations in August that ultimately led to that promissory note, correct?
Yes, sir.
And then nothing more going on with it. Does anything happen in early September related to this?
Yes, sir.
And what day was it?
Friday, September the 3rd.
Tell me what happened.
About 3 o'clock in that afternoon, I'm with a group of guys. I get a phone call from Lee Cope. I tell Lee that I can't really talk much because I'm in the middle of a crowd. He says Alex stealing money, that we found out Alex stealing money from the firm and from clients, and he's going to resign from the firm. And he wanted to know if I had the $792,000 in my trust account. I told him I did. He said, well, we're going to need to get that paid to us, and asked me not to say anything to anybody about any of it until the following Tuesday when they could issue a press release.
When you told him you had that $792,000 in your trust account, did that still include $192,000 that you had covered?
It did.
Okay. What happened next?
I talked to Lee very briefly again. He told me he was in the middle of trying to deal with all that they were dealing with, and he couldn't talk. That first phone call from him was like very brief, and then I think we talked again after I got away from the crowd. But he told me that he couldn't talk long, that they were in the middle of trying to deal with all that they were dealing with, and that we would talk later. And I mean, I had to kind of go back to the crowd that I was with and try to act as much as I could like normal, so that, you know, I mean, I think they realized that I'd stepped away and take a phone call that had bothered me, and I tried to pretend like things were as normal as they could be until I could get away from that crowd.
Did this shock you to hear this?
Yes, sir.
Is that something you expected to hear about your friend, the defendant?
Not at all. I mean, I didn't expect that to be the purpose of Lee's phone call to me when I took it.
What happened next? Did you attempt to call the defendant?
I think I texted him. I may have tried to call him after I got where I wasn't in the middle of a crowd of people. I think I may have called or texted him or both. And he texted me back something to the effect of that he couldn't talk right then. That I think he said he was meeting with probate attorneys or something to that effect, and that he couldn't talk right then and he would call later or we could talk later.
When Lee Cope called you, did he say anything about this check that's up on the screen?
He did.
What did he say?
He said that they had found a check in Alex's office from my firm that was made payable directly to him. I don't remember exactly how he described it, but he said, we found a check. We found out that Alex stealing money from the clients in the firm, and we found a check from your office. And I need to know if you've got that $792,000 in your account. We're going to need to get that paid to us, and I need you not to say anything until Tuesday when we can issue a press release.
How long do you think after you got that call or those calls from Lee that you tried to reach out to your friend, the defendant?
It probably took me an hour, maybe two, to finish what we were doing and get to where I could, where I felt like I could reach out to him without being in the middle of other people.
And what was his response again?
Something to the effect of he couldn't talk right then, that he was, I think it was something to do with the fact of meeting with probate attorneys or something like that, and that he would talk to me later.
This is on September 3rd?
Friday, September the 3rd. The phone call from Lee was about 3 o'clock in the afternoon or so.
Did you talk to Alec later on that day?
That night, yes, sir.
And what was your conversation then?
I don't remember if he called me or I called him and was able to get him. And I said, Alec, I need to know what's going on. You know, Lee has called me about this, and I need to talk to you, and it needs to be face to face. I need to know what's going on. And he was non-committal about meeting, said he had a number of things he had to deal with, and that he would try to meet with me the next day.
Okay. So
I mean, I was at home. My wife was there. You know, I mean, I was talking to him on the phone, but I wanted to talk to him face to face to find out what was going on.
How were you feeling?
Shocked, betrayed, mad. I mean, I don't know, numb. Just, I didn't.
What happened the next morning? Was that Saturday?
Saturday morning, September the 4th,
What year?
2021.
Did you try to get in touch with the defendant?
I did. I woke up early that morning, told my wife. I mean, I had, you know, told her that evening that there was a problem. I didn't get into a lot of detail with her, just told her there was a problem. And woke up the next morning, told her I was going to drive down to Beaufort. I thought Alec was staying at his brother's house, and I was going to drive down and talk to him. And so I got in the car and took off driving towards Okatee.
Were you trying to get in touch with him and
Called
not
him,
getting
called him, and called him, and called him, and called him a bunch.
not getting in touch with him?
No answer. No, sir.
So you just decided to go on down there and find him.
Yes, sir.
So you drive where?
I started driving down I-95 towards Okatee, and he called me before I was going to get off and go to John Marvin's place. But he got off. He called me
Slow
before.
down. You say Okatee. What's Okatee?
I mean, that's what I call the area where his brother John Marvin lives. It might not be technically correct, but that's what I call it.
But that's where you thought he was?
I was under the impression that's where he was staying. Yes, sir.
So you were just going to show up?
I was hoping that he would call me back on my way, but if not, I was just going to show up. Yes, sir.
And so what happened along the way?
He called me while I was on the road down there and told me that he was sorry he hadn't been able to take my calls, and that he would meet me at his mother and father's house at Alameda.
Did that meeting ultimately happen?
It did.
About what time did that happen?
Kind of late mid-morning. I want to say around 11 o'clock or so, sometime before lunch.
Okay. And so tell me about that meeting.
I got there before he did. I think I waited in the car maybe out at the front of the driveway, and then when he pulled in, I followed him in. We got out, didn't say anything in the driveway. Went through the side door. I believe caretaker was there. The lady that helped take care of, one of the ladies at least that helped take care of Miss Libby was there. She went kind of towards the back, and he and I went out on the front porch.
Okay. What was your conversation with him on the front porch? About what time was this again?
I don't know the exact time, sometime between 10:30 and noon, but I want to say it was around 11 o'clock or so. It was about, I was there for about 20 minutes.
All right. Tell me about the conversation that you had.
We went out on the front porch. We still hadn't said anything to each other than he said, let's go out on the front porch and talk. We went out on the front porch, and I looked at him, and I said, Alec, and I'm sure I said F or H or something. I said, what the is going on? I need to know what's going on. Because I know about this thing that Lee's called me about, and I need to know if there's something else you've done that involves me that I don't know about. That's a problem for me. What is going on?
What does he say?
He didn't say anything. He broke down crying. Said, I can't talk. I can't right this second, Chris. He walked inside and grabbed a handful of paper towels and came back out on the porch and said, I'm sorry. I've had a drug problem. I'm addicted to opioids. And I don't remember if he said 20 years or exactly how many years, but he said, I've been addicted to opioids for something like 20 years, I think is what he said. And, I don't remember exactly how the conversation went. There were parts where it was, I don't want to say heated, like we were screaming and hollering at each other and it never came to blows, but there were parts where it was heated and parts where it was silent and parts where it was probably calmer. He said he had a drug addiction, and then he admitted he had been stealing money,
From who?
From his law firm and from clients.
Did he say?
And he didn't specifically spell any certain person out or any certain organization out, but he said, I've been stealing from the firm and from clients.
What did he say about that 192 with you? What was the phrase he used?
I have to cuss to say it. He said,
Go ahead and say it.
He said, I shit you up. I'm sorry, I've shit you up. And shit a lot of people up. I asked him, how long has this been going on? I couldn't believe that I didn't know it. Never saw it. Never suspected it. Drugs or money.
And what did he say?
Just said it had been going on for a long time.
Did he say anything else in this conversation?
Just said he had been good about covering it up, especially the drugs. I didn't really ask much about I didn't know the extent of the client stuff. I knew about me and my $192,000. And in the phone call with Lee, he had said that Alec had been stealing from the firm and from clients. But I didn't know about any specific clients or any specific cases. So we didn't talk about that. I didn't ask about that.
How'd the conversation end?
I don't remember exactly how it ended. I know I left. I don't remember. Like I said, I know we didn't come to blows, and we weren't screaming and hollering at each other when I left, and I wasn't screaming and hollering at him. I was angry. I didn't know how to feel. But at some point I left.
Where'd you go after that?
I started driving back to Columbia and just went through the drive-through at Hardee's in Hampton to grab something for lunch on the way out.
Since that conversation on September 4th, shortly before noon, have you had any conversation with the defendant since then?
No verbal conversations. No, sir.
Did you ever get a text from him?
I've received 1 or 2 texts from him.
I'm going to show you what's been marked as States 351, see if you recognize this.
Yes, sir. It's a text I received from Alec on September the 16th. I responded on September the 17th.
Put States 351 up on the screen. That's the text you received from Alec.
Offered that in evidence.
My apologies, Your Honor. This time I offer States 351 in evidence.
Yes, sir.
No additional objections, Your Honor.
Submit it.
All right, now I'm going to put it up on the screen. Was that the text you received from the defendant?
It is, yes, sir.
Was that the usual number you have for him, or was that a different number?
It's not the normal number. I don't know that I'd ever seen that number before.
Since that time, you haven't had any conversation with him?
I think he texted me maybe one other time, and I tried to respond with something as basic as what I said there, just trying to respond, but not really communicate. I think there may have been one other text very similar to that.
You ever get that $192,000 back?
No, sir.
And when you covered your friend and put that in your trust account, is it because you trusted him?
Yes, sir.
On June 7th, 2021, you're looking again at States 452. The defendant had texted you, call me if you up, correct?
Yes, sir.
And going back to 451, you called him once and he didn't answer, and then got that second call. Is that correct?
Yes, sir. He texted me at 9:52. I called him at 9:52. 1 minute, there was no answer, and then I called back at 9:53.
And that was a 3-minute call, that second call?
I can't read on the sheet, but it was very short. I think it was 3 or 4 minutes, 2 or 3 minutes.
2 or 3 minutes? 3 or 4 minutes?
Yes, sir. It's very short.
And you talked to him, I think you've testified, mentioned a couple things, and he said that he was where and he needed to go?
He said, I'm about to get back home. You know, service is always bad out here. Can we just talk tomorrow? Or he might have said, I'm about to get back to Moselle. I don't remember which phrase he used.
Thank you, Mr. Wilson. Please answer any questions the defense has.
Mr. Griffin?
Stuff. There you go. Good morning, Mr. Wilson.
Good morning, Mr. Griffin.
One thing you said in answering Mr. Waters' questions on when you got to Moselle late night on the 7th or early morning on the 8th, he asked you something about, did you talk to Alec about the fee issue? And your response was, I did not know there was an issue with the fee. Is that correct?
That's correct.
And you did not know that there was any issue with the fee on June 7th, 2021, correct?
No, sir.
The only conversation you had with anyone about the fee before June 7th, 2021 from the law firm was with Lee Cope, correct?
Yes, sir.
And he just asked you something about, do you still have money from the Ferris case in your trust account?
He asked me if all the money had been dispersed from those cases.
And you told him it had not. And you told him truthfully it had not, correct?
Yes, sir. We were holding money back from medical liens, cost, a number of different things.
And you never had any follow-up questions by Mr. Cope before June 7th, right?
No, sir.
you did have a conversation with Alec, and he gave you some explanation. I forgot. What was the explanation he gave you?
After my paralegal, Vicki, forwarded me that email that she had received from their firm saying that there was an issue with the cost, I called Alec and said, hey, look, got this email that says there's a problem with cost, that you think you're owed more cost, no mention of fees, and if you're owed more cost, just let me know what they are and we'll get it worked out. We were holding money to deal with some things, and I didn't think the client would have any problem making sure all our costs got paid before the final amount of money was dispersed to the client. I said, hey, if there's a problem with the cost, let me know. And he said, no, it's good. I said, hey, this is the case I dispersed directly to you on the fees. Is everything all right? He said, yeah, it's fine. The firm knows about it. I just got to make sure they know it's on the books already.
So he wasn't frantic, panic. There was no panic in his voice about the conversation about the fee you had?
Nothing that I heard or saw, no,
Right.
sir.
So as far as you knew, as of June 7th, there's no issue with the fee, right?
I didn't know about any issue with fees prior to June the 7th, or even after that.
And no one was demanding from you the fairest fee money, the PMPED portion of the fairest fee money
No, sir.
before June 7th, right?
No, sir. I had not received any direct contact or request for payment of fees. My paralegal had already advised his paralegal that the fees had already been paid.
Okay. Now you said a number of times in your testimony that in June and July you were worried that Alec may kill himself.
We were worried that, I mean, he was distraught. He's destroyed and upset all the time, and not eating, not sleeping, sometimes not seeming like he was just focused in and even there. And not just me, I mean, his law partners, his family. I talked to his brothers, I talked to his partners several times throughout the month of June and July just about him and what we were worried about may happen or what he may do.
And the reason he was distraught was over the death of Maggie and Paul, right?
Yeah, yes. I mean,
And at no point in time, when you're thinking, I'm afraid he might hurt himself, you weren't thinking he had any involvement in June, July, during this period of time with the murders of Maggie and Paul.
no, sir.
And that your thoughts were with him because he was a grieving husband and father.
Yeah, so my thoughts were with him, his whole family, and especially him and Buster.
And you reached out to him as much as you could.
Yes, sir.
Now, there did come a time when you were a little worried about your $192,000 and you asked him to sign this handwritten promissory note.
Yes, sir.
You testified about that. And you had a conversation about how he's going to get you paid, right?
Yes, sir.
And in that conversation...
Well, that conversation about how he was going to get me paid, I think, was prior to that. I don't think we talked about how I was going to get paid when he signed the $192,000. I just simply knew enough to know, or felt like I knew enough of probate law and law, that if something happened to him, whether he did it to himself or something else happened to him, and I couldn't make a claim against his estate without that piece of paper. So I don't think we talked about payment or how he might get me paid that day. He had mentioned previously that he was trying to deal with Maggie's estate, he was trying to deal with his father's estate, and he had some property he thought was going to sell.
But he was telling you that he did not have the money at the time.
Yes, sir.
And that conversation was for the day of the promissory note, which I think is mid-August or something.
August 17th, I think it was.
And that he mentioned that Maggie's estate was tied up. His dad had died. You remember when his dad died?
Very vividly, yes, sir. Very much.
I mean, it was
Thursday, June the 10th.
June the 10th. It's like 3 days after Maggie and Paul were murdered, right?
Yes, sir.
And that wasn't unexpected, was it? His dad had been seriously ill.
No, sir. I went by to see Mr. Randolph one of those days after June the 7th, but before June the 10th, my wife and I had gone down to see Buster and Alec, or she had come down while I was already there, and we rode over to Alameda to see, mostly to see Randolph, but to see Libby too.
And I guess he died within a day or so of you visiting with him.
So I think it was the next day.
But Alec thought he was going to get some money from his dad's estate that maybe didn't go through probate that would enable him to quickly pay you back.
That's what he said. Yes, sir. I don't think he said anything about it going directly through. He just said, you know, I've got some money that'll be coming to me from my father's estate also.
And, you know, the difference between life insurance, beneficiaries of life insurance policies, the benefits do not go through the estate, do not get tied up in the estate.
Just enough to be dangerous probably, but yes, sir.
Well, the point is, he never said to you, oh, I have this $1 million policy on Maggie's life, I have a $5 million policy on Maggie's life, or any life insurance that he was expecting to come into as a result of Maggie's death, right?
No, sir, not at all.
And after Maggie died and Paul died, he wasn't out spending lavishly with newfound money, was he?
No, sir, not that I saw.
In fact, you know, he didn't even go to Moselle to stay a single night after Maggie and Paul were murdered. You know that?
I don't know that myself directly, but every time I spoke to him, he was either staying with his brothers or staying with his in-laws. I don't think he ever went back to Moselle.
Now, you've known Alec for
1985, 86, however long that is.
that's
37 years, I guess, if my math's right.
your math's better than mine.
38, something like
Right.
that.
And he said to you that he had an opioid addiction for over 20 years.
I don't remember exactly the number of years, but I mean, I believe it was, he said, I've been addicted to opioids for about 20 years or more than 20 years.
Well, let's just say the last 5 years.
Yes, sir.
Over the last 5 years, you've known him. If he was addicted to opioids, did you notice any change in his behavior?
Not a thing, not at all.
And you were around him and in a business capacity,
Yes, sir.
professional. You were sending him cases.
Yes, sir.
He was acting like the normal Alec that you've known since college,
Since law school.
since law school.
Yes, sir.
And nothing about his demeanor set red flags off to you as to, man, he must be on something today.
No, sir. I mean, I didn't see pill bottles when we would travel together for depositions or things like that. He didn't seem to be out of it. He seemed to be capable of handling the work that we were doing. You know, when we would socialize together, didn't see anything that indicated that he was addicted or had a drug problem or was using drugs.
And if he was addicted to drugs for the last 5 or 10 years, and he was, from your observation, was a loving husband and father,
Yes, sir.
and you didn't observe him engaging any erratic behavior around his wife and kids?
No, sir.
Do you know anything about from your medical, well, from your legal career handling personal injury cases? Do you know, have you learned information about building up tolerances to painkillers, patients and clients of yours who have built up tolerances?
Not really enough to talk about it much or testify for sure.
Sure. So I'm going to go back, cover some ground you've already talked about. But
Sure.
law school, you and Alec were roommates at one point in time.
We
correct?
were, yes, sir.
And then he actually married Maggie while he was in law school, right?
He did.
And you married Dana after you graduated or while you were in law school as well?
Shortly after graduation.
And Maggie and Dana were sorority sisters at University of South Carolina?
They were.
Now, you went to South Carolina Law School, but you were
Wofford College in Spartanburg.
Harvard
undergrad.
of the upstate, right?
Yes, sir.
And you became really good friends with Alec during law school.
Alec and I we were friends and hung out a lot, studied together, did some things like that first year, but we got to be much closer friends throughout that end of the first year of law school. We lived together second year, and he married Maggie into our third year of law school.
And then you married Dana, and y'all would do a lot of things together as couples, wouldn't you not?
Yes, sir.
And one of the things y'all like to do is go to South Carolina football games. Right?
Yes, sir.
And Alec played for the University of South Carolina. You knew that.
Yes, sir.
And had a knee injury when he was playing.
I did know that. Yes, sir.
And then as you grow as married couples, you had children. He has children. Your oldest daughter was 1 year younger than Buster.
Yes, sir.
And then you have a son who's
2 years younger
few
than
years
Paul.
younger than Paul, right?
Yes, sir.
And your daughter and Paul were really good friends.
Yes, sir.
And friends with Buster as well.
Yes, sir.
And
Our kids grew up together.
exactly.
Even our youngest, who's younger than their two, they all grew up together.
And you and Dana and your kids and Maggie and Alec and Paul and Buster would vacation together when they were younger before the kids started wanting to do things on their own, right?
Yes, sir. We would vacation together and go, on trips away while the kids were younger, and would follow you around. And as they got older, kind of doing their own things. Those vacations kind of went by the wayside, but we would spend a lot of time down at Edisto Beach. We have a house down at Edisto, and they had a house at Edisto, and so a lot of our time together would be spent down there or in Columbia at Carolina football games or thing like that.
Right.
I mean, my wife and Maggie were sorority sisters and became much closer friends through Alec and my friendship.
And I'll get on to that a little more. But and you did a lot of work with Alex. You weren't in the same law firm with him, but you worked on same cases or related cases a lot, correct?
Yes, sir. More so in the beginning, but throughout the entire time I've known him, yes, sir.
And so just sort of some examples. So if two people were in an automobile accident, one's a driver and one's a passenger, the same lawyer shouldn't represent both parties to the accident, right?
In most cases, yes, sir.
And so frequently you would send him the passenger or the driver or vice versa.
Sometimes it would be that, and sometimes it would just be straight, I represent somebody who's been injured in some way, and I need you to help me with that one person. But sometimes what you're talking about there about referring one of the two people out is called conflict of interest or conflicting them out.
Right.
And Alec would conflict me cases sometimes, and I would conflict him cases sometimes.
And you had a lot of respect for his ability as a lawyer, right?
I wouldn't have associated him or sent people to him if I didn't.
And you wouldn't associate him on the Ferris case if you didn't think he could do a good job, right?
Not at all.
And he did a really good job in the Ferris case, right?
Yes, sir. I mean, our result was our client was very satisfied with the result.
And Alec participated fully in the entire case, and I think Mr. Waters asked, he even gave the closing argument to the judge, right?
He did. I mean, we had to spend a lot of time getting ready for trial, even though it wasn't in front of a jury, which sometimes doesn't come with quite as many things to have to do. Even in front of a judge, it takes a lot of work to put a case together. And so we spent a lot of time getting ready for that trial, and even working the weekend before it started in Columbia out of a central location there.
And had you tried cases with Alec in the past?
I have.
Tried cases with Alec in front of the juries like this right here?
Yes, sir.
And I don't have to tell you, but doing what we're doing here can be very stressful, can it not?
It's very stressful, yes, sir.
Long nights, and get up early in the morning.
A lot of hours juggling a lot of things.
And did you ever, were you around him during the stress of trial or cases where he just totally lost his faculties, just went off on the handle because He was on opioids. Did you ever see anything like that?
No, sir.
He was able to function in high-stress situations, correct?
Yes, sir. I mean, sometimes getting Alec to focus on the case and on what you were trying to get accomplished was difficult, but that was from all the way back in law school. That was from day one. But when he focused, he was extremely able to get it done.
And one witness described Alex normal as being fidgety.
Just sometimes not as focused as you'd like for him to be.
Was
He was taking phone calls and talking to this and looking at that and taking another phone call, and sometimes you have to say, look, man, we got to sit down and focus on this and get this taken care of.
Now, that brings me to another point. Would he always take a phone call if Maggie called him?
Always.
Would he always take a phone call if Paul called him?
Always.
Would he always take a phone call if Buster called him?
Always.
No matter what was going on?
Not when I was around him, if we were in court, he wouldn't take a phone call, but in depositions, he would sometimes get up and walk out and take calls. And if you were talking to him, trying to get a full conversation out with him in one breath was impossible because he was going to take a phone call.
And you traveled around with him for business?
Yes, sir.
Did he? Was he frequently talking to his wife and sons?
Yes, sir. Seemed to be.
You talked to him multiple times a day, right?
Yes, sir.
When you were with him, did you see him talking to Maggie, Paul, and Buster multiple times?
I could tell who he was talking to on the phone. We didn't have to travel as much together later in the last 3 or 4 or 5 years just because we were working less cases. Sometimes we wouldn't have to go as many places for depositions and things. But yes, if we were traveling, I could tell he was talking to his family on the phone.
Right. Was it hard to get Alec to go on guy trips? Did he prefer to spend time with his family over guy trips?
He seemed to, yes, sir. Most any trip that I think I've ever been on with Alec generally was family.
Right.
He's not the kind of guy that would take off and go spend a golfing weekend with us, or I think they like to spend their time hunting and fishing and doing things as a family.
And you, going back to this Ferris case that was tried in Columbia, do you remember Maggie coming up and staying with him during the trial?
I don't. I think she may have come up like that Sunday before we started the trial. I was staying at home in Columbia and he was staying in a hotel. So I think that's why I stayed in the hotel, because Maggie was coming. And we were in that point, I think we were just renting a house because we were between places and didn't have a lot of space. But I wouldn't want to testify to that under oath. But I think so.
Sure. You would go to lawyer conventions with Alec? You would go to the same conventions. And
Sure.
And you mentioned the trial lawyers, one at Hilton Head, first weekend of every August.
Yes, sir.
And before the tragic events of June 7th, 2021, would he always go with Maggie and Paul and Buster?
Most all the lawyers that go to that convention bring their families along. It's a big time that everybody gets to know each other, know each other's family, and Maggie and Paul and Buster would always be there.
And during football season, South Carolina, did he and Maggie have season tickets?
Yes, sir.
He'd go to the games with his family?
Yes, sir.
And you would tailgate with them?
Yes, sir. They would generally have a family tailgate that Miss Libby would put together. And then when she got sick, I don't remember who kind of took it over, but they always had a family tailgate. And if we weren't tailgating with them, we would always make it a point to stop by and at least speak.
And he had, they had season basketball tickets,
Yes, sir.
correct? And he and Maggie would go to just about every home basketball game
Yes, sir.
for the University of South Carolina men's basketball team.
Yes, sir.
We had some pretty bad basketball teams over the years, right?
They were actually pretty good, I think, in those years. But
Okay.
I think that was Final Four. I think Alec bought the tickets for the year after the Final Four when they tanked. So,
Right.
yeah, you might not have seen the best basketball.
And then you went to baseball games together.
Yes, sir.
And
I don't know how much baseball, we didn't do a lot of baseball ourselves, but I think they did some.
And we'll get to this, but the weekend before June 7th, it would be June 6th and June 5th, you actually went to the super regionals with Maggie and Alec and Buster and his girlfriend Brooklyn, you and your wife, correct?
Yes, sir. It was only on that Saturday that we were with them, which would be June the 5th. They had come up for the weekend Carolina baseball tournament, and my wife and two of our children met up with them on Saturday and went and hung out at some mutual friends' place for a while before we all went to the ball game, kind of separated and went to different seating areas at the ball game.
Would you agree that Alec's number one priority was his family?
Yes, sir. Appeared that way to me.
When I say his family, I'm talking about Maggie, Paul, and Buster.
His whole family, yes, sir.
And you mentioned that you became good friends with Maggie's family, Mr. and Ms. Branstetter,
Yes, sir.
and her sister Marion, and
Not so much with Marion and her husband Bart. I mean, I knew them and I was around them, but not so much friendly or close to them as with Maggie's mom and daddy.
and what was Alec's relationship with Maggie's dad?
Seemed to have a very good relationship with them. Spent a lot of time together. They would come to Moselle, or Maggie and Alec and their children would go visit them in Somerville, or Papa T would come up sometimes and try to hunt or do things like that.
You knew him as Papa T as well?
Yes, sir.
And what'd you know Miss Branstetter as?
Miss Ken. I think they called her Grandma, but I called her Miss Ken.
And they vacationed at Edisto, Mr. and Miss Branstetter, with Alec and Maggie and Buster and Paul, right?
They would be at Edisto some, yes, sir.
And can you tell us a little bit about Alec's relationship with Paul and Buster's friends?
Alec and Maggie both seemed to welcome, I mean, they were great to my children and seemed to welcome my children into their house and into their lives, and did the same for Paul and Buster's other friends.
And and at Edisto was Alec and Maggie's home, was that opened up to a lot of Paul and Buster's friends? They have a lot of people staying over, coming over and visiting?
You know, it seemed to be that way. I mean, I wasn't over there all the time when there were children or kids around, but sometimes, yes, sir. And my kids would say, especially my daughter would say, I'm going over to hang out with Paul or Buster at their place.
Right. And do you remember, sort of move forward, Memorial Day weekend of 2021?
I do.
Did you and your family go to Edisto that weekend?
We did.
And was Alec down there with Maggie and Paul and Buster and some of Paul's friends?
There were.
And do you remember getting together over at Alex, Maggie's home over that weekend?
Yeah, we got together Saturday evening, I believe it was. We got together to cook out over at their house Saturday evening with them and a bunch of other people.
And Maggie and Alex getting along as far as you knew?
Yes, sir.
Was it a fun time had by everyone, best you
Yes.
could tell?
Yes, sir. I think it was right around about Alex's birthday. We not only were cooking out like a big shrimp bog, but also having some cake and kind of a little birthday celebration.
I want to play that right quick, Your Honor. I think it's Defendant's Exhibit 61 or 59, Doug? 61. 61 is in evidence, Your Honor. Play it very briefly. Tell me if this is what you're referring to.
Yes, sir.
Apparently we don't have audio again. Just run it through. We don't have to have audio. Who is that?
It's Paul.
That Alec?
Yes, sir. Yes, sir.
And was that a typical family gathering? Was this something like really didn't happen very often?
No, that was, I mean, the times that I was around them and their family, things were much like that.
So that was the weekend of Memorial Day weekend, and then the very next weekend was the Super Regional Baseball games in Columbia, right?
Yes, sir.
And that's when you met up with Maggie and Alec on Saturday at a tailgate with, y'all had a mutual friend, I think maybe whose son played? Or
Son played for Carolina, yes, sir.
Right.
I think it was one of Maggie and Dana's sorority sisters, and a guy that Alec knew from college, but I don't know if they were, I don't know how they knew each other, and their son played first base for Carolina.
Okay. And
And it was Maggie, Alec, Buster, and his girlfriend, Brooklyn.
and you stayed, you maybe didn't see Alec and Maggie on Sunday, but I think y'all communicated, just about how poorly
We
South Carolina
talked, and
did.
my wife talked to Maggie. Saturday after we tailgated before the game, we all split and went our separate ways to go sit in different areas. And I don't think we saw them after that on Saturday. We were supposed to get together on Sunday, or try to get together on Sunday, but didn't do so and ended up going to the game separately.
And,
But we talked or texted, and I think Dana talked or texted with Maggie.
sure. And I believe you testified earlier that during this weekend, you had gotten an update on Alec's dad, and he wasn't doing so well.
Yes, sir. I know on Sunday, I talked to Alec when they were going home, or they were headed home, and we were talking about just how the Gamecocks had, blown the chance to move forward, and we talked about his dad, and that's when he told me things were getting much worse with Mr. Randolph.
Okay.
But I kind of already knew that from the days and, leading up to that. I already kind of knew that. We had talked about it before, but I remember that Sunday, him telling me things were really getting much worse.
And you knew that with a common knowledge in the tight-knit legal community of Hampton and Colleton area?
I mean, I can only speak for myself, but I knew that, and people seem to know that, yes, sir.
And Mr. Randolph was he was beloved by a lot of people, was he not?
Yes, sir.
And not just his immediate family, but the broader legal community.
And most people I knew that knew Randolph seemed to respect and love him. Really, everybody I knew.
Right. And we know he died on June the 10th, right?
Thursday, June the 10th, yes, sir.
There's been, how's it been? You mentioned something, I just want to go back to the Ferris case, and you and Alec and Mr. Ridgway, who were representing the plaintiffs, Ms. Ferris, or the estate, that you thought Mack Truck didn't want to produce some discovery, and that leveraged y'all in the ability to basically just have a damages hearing
Yes.
with a judge. Is that right?
Yeah, so we had some discovery we had asked for. They sought not to produce it. We had some motions to compel that were argued. I think we were successful in those. I mean, I can't say what they were thinking, but it felt like that we had an opportunity to structure a good chance for our client to get a good result, because they didn't want us moving forward with some discovery.
And so in the Ferris case, you succeeded in getting an order to produce the information you sought, yet y'all worked out a different way to resolve the case. Is that right?
Just kind of, not to get too deep into it, but just to give you some context. This is like, there was only one prior reported case of something like this happening in the world that we could find, like in Australia or something.
Right.
And this was one of the only times that it had happened while a vehicle was actually in motion on a highway. I think it might have been the first time that it actually happened. So there was very little, there was very little chance we felt like that we were going to be able to make a punitive damage case out of it, because there had not been a lot of prior instances for Mack to be on notice on. So for us to waive that didn't feel like we were giving up much. And I think they did not want us to discover some things because there might be other cases that were coming from that defect. This was very early on in the discovery of that defect and things starting to happen with it.
And moving back on track, I'm sorry for diverting, but
Sure.
on Monday, June the 10th, you didn't speak to Alec any during the day, as I understand it.
Monday would have been June 7th, but I don't remember.
I'm sorry,
That's
Monday,
okay.
June 7th, yeah.
Yeah, I don't remember speaking to him on that day, earlier in the day.
But you had some things you needed to talk to him about. And you mentioned a case where a potential product liability case,
Yes, sir.
and that whoever was holding the equipment wanted to, either you got to come inspect it or don't inspect it.
Yeah, they wanted us to go ahead and get it inspected so that they could put it back into operation. We needed to gather what we wanted from it so they could repair it and put it back into operation.
And so Alec calling you on Monday, June the 7th was not surprising, right?
No, sir.
I mean, because you could talk multiple times a day, you just hadn't talked this day.
Yes, sir.
And when and you would talk to him when he was traveling, to the office and back to Moselle frequently. I mean, it wasn't the first time you'd ever talked to him when he left Moselle or coming back to Moselle.
I mean, I don't know where somebody is when I'm talking to him on the phone, but I mean, it oftentimes he would say, I'm, headed to Moselle or I'm leaving the office. I mean, it felt like a lot of times when he do the same thing I do, you make your phone calls while you're in the car because you're busy doing other stuff if you're at the office or wherever else.
But it was a little more than that. I mean, you knew that when he was coming up to Moselle, the phone would normally drop.
Phone service is bad out there, yes, sir.
And you'd drop a call, would you not?
Yes, sir.
And you've been out in Moselle a lot, haven't you?
Yes, sir.
And calls get dropped out there frequently, do they not?
Yes, sir.
And you can frankly be in one part of the house and maybe have coverage and be in another part of the house and not have coverage, right?
I don't really know about parts of the house, but I mean, there'd be times that I'd be on the phone that I would drop service or not be able to get on the internet or do things like that.
And
But it's spotty.
And just driving around the rural areas, I guess you know some areas where there's just dead spots, and you just know there's going to be a dead spot coming up.
Very much so.
And there were such spots on Moselle Road, were they not?
For me, when I was trying to use my phone, yes, sir.
Now you went over your phone bill to get times for phone calls, and you went through them. But I want to go through some more detailed documents that are in evidence, reviewing your phone calls with Alec on the 7th, and Defendant's Exhibit 60 is in evidence. And Doug, if you'll go to page 3078, and let me give you your copy of your Verizon bill. I guess Verizon, was that the service provider?
Yes, sir.
451. It's in evidence. I'm going to hand it to you and just compare along to some of this detailed information. And Doug, if you'll go down to the bottom entry, 9/12/14. You got that pulled up? Can you see this and compare it to your phone bill? But it says Alex Murdaugh calls Chris Wilson at 9:12:14, and it was a 42-second call. Does that sound about right? I don't know that your Verizon bill is that accurate on the time.
Is this supposed to be June the 7th, Monday, June the 7th?
Yes, sir.
My phone bill that I pulled and or my phone records that I pulled and provided to SLED say I had an incoming phone call from phone number ending 1227, which is Alex's cell phone number, at 9:11 p.m. that lasted 2 minutes.
Okay. And so some of these extraction data that's in evidence says the call is 42 seconds long. You think you talked to him for 2 minutes, and you may have been billed for 2 minutes, but when you got the call, you said, "I'm fixing the pump, can I call you back?"
Yeah.
Is that a 2-minute call, or is that a 45-second call?
Hey, Bo, how you doing? I'm doing all right. I got my hands in the middle of this. Can I call you back? Yeah, sure, no problem. I mean, probably shorter than 2 minutes. I don't know if that's the phone ringing and the talking.
Right.
I don't know how that works.
Okay. And then, but that was the call, and there was nothing about Alex's demeanor that alarmed you during that conversation, right?
No, sir.
He wasn't breathing heavy, was he?
No, sir.
He didn't sound panicky in any way, did he?
Not panicky, no, sir.
Just a regular conversation with Alex?
All conversations with Alec are a little bit scattered, but no, he didn't sound out of the ordinary.
All right, and then you call him back.
I did.
Sometime around 9:20. What's your Verizon bill say?
9:20 p.m. A phone call from me that lasted 3 minutes.
All right, and if you'll go to page 3082 of Exhibit 60, and if you'll, Doug, pull up the call at 9:20 with Mr. Wilson. You see it? Now, I mean, it really doesn't matter whether the Verizon bill says 2 to 3 minutes, this says 131 seconds, but this is you calling Alec back, correct?
Yes, sir.
And in that call, he is got the same demeanor,
Yes, sir.
not breathing heavy,
No, sir.
not being frantic in any way.
No, sir.
Just
Not that I heard.
normal Alec.
Yes, sir.
And he tells you he just gets to his mom's, and that's how you end the call, right?
He says he's either getting to his mom or about to get to his mom's. I think he said, "I'm about to get to my mom's. Let me
Okay.
call you when I'm leaving here."
All right.
Mr. Griffin, I thought he was leaving the office for whatever reason. I don't have any reason to know that. He didn't say that. But I just assumed he had kind of worked late at the office and was headed
Sure.
to check on his mom before he went home.
Okay.
He said, "I'm about to get to my mom's." He didn't even say where he had been earlier or anything like that. Just, "I'm about to get to my mom's.
Well,
Can I call you? Can I call you later?"
would it strike you as odd that he'd be going to visit his mom at 9:20 in the evening?
No, sir. I knew he visited his mom often. I thought it was mostly during the day, like he'd swing over there for lunch, check on his mom and dad, but it didn't strike me as out of the ordinary for him to go in the evening. I knew sometimes he would go later.
And were you aware that his dad had been put back in the hospital on that day?
Yes, sir. Or I knew he was. I don't know that I knew for sure he was. I know on that Sunday, Alec told me he was either his daddy was being taken to the hospital or was taken to the hospital that day.
And from your knowledge, how frequently would Alec go by and visit his mom and dad?
Almost every day.
Almost every day.
Yes, sir.
When he was in town.
Yes, sir.
And did Alec work odd hours, late hours?
He would usually be somebody that was working later in the evening than a lot of other people would be. Yes, sir.
So
I don't think he got started as early as everybody else does.
So I guess from what you're testifying, his demeanor would have been in his communications with you on this phone call at 9:20, same as it would have been any day he leaves the office. There's nothing out of the ordinary.
Nothing struck me as out of the ordinary, no, sir.
And you think in this call you brought up that you needed to talk to him about the equipment?
I know I did that because they were starting to get frustrated with us and said this thing needs to get inspected so we can put it back in service. So we were needing to get that scheduled.
And he cut the call short before you finished your conversation about the equipment, saying he was pulled up to his mom or about to get to his mom. Is that right?
Yes, sir.
Yes?
Yes.
Okay, thank you. And then the next entry, I'm not sure it wouldn't show up on your Verizon bill, but if you'll go to page 3086, Doug, at the text at 952.15, which I believe that's in.
Mr. Griffin, I don't think we talked about the equipment deal when he told me he was pulling up to his mom's house.
Okay.
I mean, I asked about how his mom was doing, and I asked about how his dad was doing. And I said, hey, I need to talk to you. I might have said, hey, I need to talk to you about this equipment case, and I got something else I need to talk to you about work. We didn't get into any details about it, because he said, I'm about to pull up to mom's, or I'm pulling up to mom's, let me call you back when I finish there.
Okay. Well, one thing we know you didn't talk about is the Ferris fee, right?
No, sir.
Because there was no issue, as far as you knew, about the Ferris fee.
I knew of no issue with that, no, sir.
Okay. So, according to this exhibit that's in evidence, there's a text at 5:52, 15 seconds. It says, call me if you're up. And I think you put that text into evidence. I may have it here. And it states exhibit 452.
Yes, sir.
Is that the text?
Yes, sir.
And what time did your Verizon, well, I guess you printed that off your phone, is that right?
This exhibit 451 only shows my phone calls, it doesn't show text.
Well, the picture of the text message has a time on it, right?
Yeah, June 7th, 9:52 p.m.
Okay, and the extraction record says 9:52, 15 seconds, but you received that text?
I did.
Okay, and then if you'll go, Doug, right below that, there's a phone call that you made. You made to Alex at 9:52:59. On your Verizon bill, you say 9:52 phone call to Alex.
Yes, sir.
Now, earlier you testified that was a missed call, and you didn't talk to him. I mean, the extraction record says it was for 42 seconds. Do you think you called him, got him, and the call dropped, or do you think it's a missed call?
I don't remember talking to him on that call. I either got his voice message or it didn't answer at all. That's why I called back 1 minute later.
Okay.
He may have picked up, but I didn't speak to him, and I didn't leave a message.
Okay. Well, then the next call on the log, Doug, is 9:53:55, and what time's your Verizon bill say that you made that next call?
9:53 p.m.
Okay. And so right after you tried, according to this exhibit, it was like 42 seconds after you tried the first call.
Yes, sir.
You tried him back.
Yes, sir.
And when you got him, is that when you talked about the equipment inspection?
That's when I would have said, how's your mama doing? How's your dad? We need to talk about this piece of equipment. We got to deal with this inspection that's upcoming. And I got some motions that I think it's some motions that I need some help with, something that I need a little guidance on to bounce off of you. So he was about to get back to Moselle or about to get back home and, may lose service, or was about to get back home and could we talk tomorrow?
I mean, did he in fact tell you, I'm about to drop service? And
I don't think he said I'm about to drop service. I think he said I'm about to get back to Moselle. I may lose service. Can we talk tomorrow?
And again, demeanor is perfectly normal in this last conversation you had with him at 9:53, correct?
Nothing stood out as different to me.
And he wasn't breathing heavy, he wasn't being frantic, nothing out of the ordinary, correct?
Yes, nothing that I heard was out of the ordinary, no, sir.
Okay. And then you went to bed and you got notified by your wife and the phone was blowing up, and you immediately got in the car and went to Moselle, is that right?
Immediately, yes, sir.
And you got there roughly about 1 in the morning, is that right?
About 1 in the morning, yes, sir.
And you were directed to the main house,
Yes, sir.
and there you think Alex was already in the main house?
I know he was already there because I walked in. The first thing I did was walked over. He was crying, and I was crying, and I just walked over and hugged his neck. We didn't say a word.
You remember what he was wearing?
I don't.
Who was in the?
I mean, I think I remember a white shirt, but I don't remember for sure.
Well, when you were there, did SLED agents come and take his clothes?
I was not there that I remember seeing SLED agents take his clothes or anything like that. If they did, I was somewhere else in the house.
Okay.
I did not see any of that take place. I was told that they did, but I did not see that.
Well, you were told that when you were in the house?
Yes, sir.
Okay. Did it appear that they had already taken his clothes when you saw Alec?
I have no idea.
Well, did you see him change clothes during the period of time you were with him?
Not while I was there, no, sir.
So while you were there, he had the same clothes on from when you got there to when you left?
As far as I remember, yes, sir. I mean, I wouldn't. I mean, as far as I remember, yes, I was focused on my friend, his son. I wasn't paying attention to whether he changed clothes or anything like that. But I don't remember him changing clothes or anybody taking his clothes. But I wasn't really focused on that.
And what was Alex's demeanor that night?
He was destroyed.
He was destroyed.
Yes, sir. He was crying, quiet, just whimpering,
And he-
trying to be gracious to the people that had come at times, but I mean, none of us knew what to say. None of us knew what to do. You know, there was a lot of quiet.
I want to ask you about the comment he was trying to be gracious. Is when Alec meets people coming up, is he polite, respectful? Is that his normal habit?
Yes, sir. He's good with people. I mean, he does it. He's the kind of person that I doesn't ever seem to have met a stranger. Always seems to talk to people.
Right. One of the things that was just, well, let's set the table. You were there, and a number of his law partners were there. Is that right?
As I recall, yes, sir.
You remember Mark Ball being there?
I don't remember Mark. I remember Mark being there at points and times, but I'm not sure about that night when I walked in.
Well, Ronnie Crosby,
I remember Ronnie being there. Austin Crosby, Lee Cope,
Austin Lee, Randy,
yes, sir.
I guess his brother John Marvin.
John Marvin was
up
already
there.
there. I don't remember if Buster had already gotten there or not. I think he got there right after I got there.
And then y'all were there for a number of hours, and everyone said, we just need to go and try to get some rest. And so you went to your office and laid down on the couch and tried to sleep, right?
Yes, sir.
And you were back at 9 in the morning?
Yeah, somewhere thereabouts 9 shortly after.
And were the same lawyers there?
Pretty much. I mean, there was a lot of comings and goings, and at very points in times, Alex partners would some be there and some not. But yes, sir, pretty much the same number of people and the same people the next morning.
Right. And at some point in time, there was a discussion and a recommendation that you agreed with that Alec not speak to any law enforcement without somebody with him, right?
Well, we were standing around in the driveway talking, and I think it was Lee Cope, Mark Ball. I don't remember if Ronnie Crosby was in that conversation, a couple other people. And there was some discussion about Alec's interaction with SLED. And the discussion that was had was, look, he probably doesn't need to interact with SLED by himself, because don't know what state of mind he's in and don't know what the circumstances are. But he also doesn't need 7 or 8 lawyers trying to advise him or deal with him. I made it very clear that I wanted to be his friend and not his lawyer. That I didn't feel comfortable with that, and that one person needed to be, for lack of a better term, the point person.
And the concern was that he wasn't in a state of mind to do so, to have conversations with law enforcement.
Well, I mean, Mr. Griffin, we're all lawyers, and even if you don't practice criminal law at all, even if all you do is civil law, every lawyer knows that generally criminal lawyers advise their clients not to interact with law enforcement without their involvement or at least their approval.
No,
And so every one of the lawyers standing there either knew that or should have known that.
But
So whether it was his state of mind or whether it's just the general, what we're all taught and trained, but yeah, we all felt like that Alec wasn't in a position where he needed to or maybe was even able to talk to SLED by himself.
and that's
I felt that way, and everybody else expressed the same thing.
and then that gets to my point. You didn't believe he was able to talk to SLED because he was so distraught and destroyed over the murder of his wife and son.
That wasn't I mean, I'm not trying to argue with you. That wasn't a decision for me to make. That's why I did not want to be acting as his attorney. I wanted to be his friend. That's what I was there for. That would be a decision for whoever was going to be representing for him and his representation. Whoever it was going to be at that point in time, whoever was chosen as the point person, that was a decision for them to make about how he would interact with SLED.
I understand, but you agreed with the recommendation that he was in the state of mind to sit down and talk to SLED by himself.
I agreed that he did not need to interact with SLED by himself. Yes, sir.
Based on his state of mind.
I can't. He was destroyed. He was upset. And I don't know whether he was able to talk with SLED at that point in time by himself or not, but I knew that that's not something that somebody should do.
Do you remember testifying
I mean,
for the
I've done
state?
criminal work in my past, way back in the past, and that's the advice that I would give every one of my clients.
Do you remember testifying before the state grand jury, stating he, Alec, wasn't in the state of mind to do so, and that we all didn't need to be his lawyer?
I don't remember specifically saying that.
I'm going to show you page 152, lines 22 through 25.
Sure.
See if it refreshes your recollection.
Sure. He was not in a good state of mind, I will tell you that.
152 down to the bottom.
You want me to read it out loud or just read it to myself?
Refresh your recollection that that was your testimony.
Yes, sir. I said he wasn't in the state of mind to do so and that we all didn't need to be his lawyer. I didn't want to be his lawyer. I was his friend. I didn't want to be in the lawyer scenario.
He wasn't in a good state of mind, that's for sure, correct?
No, sir. Nobody was.
Right. Now, you got there about 1 in the morning, and there were a lot of people around Alec at that point in time?
There were already people inside the house around him, yes, sir.
And then when you left, Alec was with
I think
Randy, John Marvin, Buster by that time?
I think the decision was made they would go to that at least Buster and Alec would go to Alameda and spend the night. And I don't remember whether John Marvin or Randy went with them, but they were leaving as a family.
And as far as you know, that they left as a family and they came back as a family the next day?
Yes, sir.
And when you got there the next day, more people showed up around Alec.
Yes,
correct?
sir.
And I think the Branstetters showed up eventually.
I don't remember. Yeah, I think Papa T and Miss Kim were there the next day.
Now, the immediate days following Maggie and Paul's murder, Alec spent a lot of time down in Somerville. Do you recall that?
Yes, sir.
And that's where Papa T and
That's where Maggie's parents
Miss
lived.
Kennedy, and spent a lot of time with them.
Seemed to, yes, sir.
And then he would stay with John Marvin down at Okatee. You mentioned that
That's
you
where
thought-
I'm sorry. That's where I thought he was staying a lot. Yes, sir.
And he would stay with his brother Randy,
Yes, sir.
and then they would go to Edisto, he and Buster sometimes.
There were several times that he and Buster would go to Edisto, and I'd try to go down and just see them there. I think they were just, I mean, I know Buster, and I think they were just trying to kind of go somewhere where there weren't quite as many people around.
And you begged him, I think you said, or encouraged him to come to the trial lawyers convention at Hilton Head so that maybe, he and Buster could have some normal time.
At least to play golf with us one day. I told him he at least should do that.
And you were concerned he had lost a lot of weight, had he not? Or,
He didn't seem to be sleeping or eating very well.
and he was, and as his friend, you tried to give him a shoulder to lean on and an ear to talk to, right?
Yes, sir.
And he asked you rhetorically, what are we going to do without Maggie and Paul? You remember that?
I don't remember those exact words, but I mean, he said he didn't know what he was going to do without them. Yes, sir. I don't know if he said what are we going to do.
And he told you that he just couldn't go back to Moselle, that he was going to have to sell it because he just can't go back out there. Do you remember that?
He talked to me about he and Buster were going to talk about selling Moselle. He didn't. I mean, that was Paul's thing. Paul loved that property and being on that property. And I don't know that Buster loved it as much. He did, but I don't know that he loved it as much as Paul. And I don't know that they, that Ellie just talked to me about he didn't know that he was going to want to keep it, and that he didn't go. But I don't think he ever went back out there and spent another night. Don't know that for sure, but I never talked to him when he was there.
And you advised him just take it one day at a time?
Yes, sir.
Mr. Wilson, do you see Buster in the courtroom? Stand up, Buster.
I do.
Is that Buster?
Yes, sir.
And is Brooklyn seated next to him? Can you stand up, Brooklyn? Is that Brooklyn?
Yes, sir.
All right. Thank you, Your Honor. That's all the questions I have.
Thank you, Your Honor. Briefly, you were asked by Mr. Griffin on June 7th whether or not you brought up anything about the Ferris fees, but at that point in time, you hadn't had to cover $192,000 for the defendant, had you?
No, sir, I had not.
And
It
as far
was
as
July the 15th, 16th, 17th, somewhere around in that range, middle of July, that I had to cover that $192,000.
that he called you with some story about how he had the money in the wrong structures and he needed to send it back to you, but he was 192 short.
Yes, sir. I'm sorry.
Don't lead the witness.
Did the defendant tell you that the issue of notifying his firm had been handled
Yes, sir.
about the fees?
Before I wrote the checks in March and afterwards.
Before June the 7th, you were asked about that call with Lee Cope.
Yes, sir.
And did you talk about some fees and expenses that were still pending?
Not
Lee Cope?
Not with Lee Cope, no, sir.
What did you talk about with Lee Cope?
Lee asked me if all the money in the case, the Mack Trucks case, had been dispersed. And I told him that it hadn't. We were holding back some lien money, some medical bill money. And I was in Hampton, I believe, trying a case down there the whole week, and he approached me while I was working in and out of their office sometime. And I think that's when he approached me and spoke to me about it, and I told him I'd have to check. I wasn't in the office.
Did you tell Lee Cope at that time that you had already dispersed the fees and written them directly to Richard Alexander Murdaugh?
No, sir, he didn't ask me about the fees.
You were asked about the phone call that took place, or the phone calls, series of phone calls that you had with the defendant on the night of the murders, correct?
Yes, sir.
And he called you first, correct?
Yes, sir.
And then he sent you a text saying you up?
Yes, sir.
But in those phone calls, you were the one who raised the issue about the equipment issue, correct?
Yes, sir.
Were you the one who raised the issue about the equipment?
I did. I mean, I kept up with our deadlines and things that needed to be dealt with. And I want to say that the lawyer had reached out to me sometime around that time, I don't know whether they couldn't get Alec or just chose me to be the person to reach out to, but I was being contacted.
You were asked about him going to visit his mother in Alameda, typically during the day. And were you aware that he didn't go visit his father that day, despite the news that he had been put in the hospital?
I don't know. I don't think we talked about that night on those phone calls whether he had gone to see his father or not. I asked how his father was, but I don't think he told me whether he had gone to see his father or not.
You were asked about your conversations that night with him, and I think you said he was acting like the normal Alex.
Yes, sir.
And you were asked about the fact of your observations of him as a husband,
Yes, sir.
as a father.
Yes, sir.
You said you saw no erratic behavior over the years that you've known him.
No, sir.
Saw no evidence of opioid use over the years that you've known him.
No, sir.
You said that he came from a prominent law firm,
Yes, sir.
prominent family,
Yes, sir.
that you respected him as a lawyer,
Yes, sir.
that his clients trusted him.
Yes, sir.
Object.
Sustain.
Was the defendant effective in closing argument?
Yes, sir. Very.
Did the defendant show emotion in closing argument?
I mean, yes, sir, he did.
Was the defendant good with people?
Very good with people. That's one of Alex's strengths is with clients and people he met, connecting to people that he, didn't know quite as personally. He could make connections with people. He seemed to know what made people tick. He knew what was important to people. He could spot issues and address issues in a case. When you got him to focus, he could handle those things.
Did your kids grow up together?
They did.
Did you try cases with him?
We did.
You've done business with him over the years? Have you done business with him over the years?
Yes, sir, lots.
Have you been roommates with him?
Yes, sir.
When you covered $192,000 for him, did you trust him and believe him when what he was telling you?
I believe that he would pay me back and that what he had told me happened had happened.
On September 4th,
And I knew I had to cover that money with my trust account. So, yes, sir.
on September 4th, 2021, did he confess to you the truth of his life that those of whom were close to him, no one knew?
He confessed to me things about him that I didn't know.
And you had no idea about any of that.
No, sir.
And he said it had been going on for years, the reality of his life.
He told me that he had been addicted to opioids, and I think he said either 420 or over 20 years,
And also,
and that he had been stealing money from his clients in the firm.
and that was a lightning bolt because you had no idea, despite being his best friend.
Objection leading, argument.
Were you one of his best friends?
Yes, sir.
Did you have any idea about any of that had been going on for a decade?
I had been told by Lee Cope the day before in that phone call that Alec had been stealing from his firm and from clients, and that he had a drug problem and was going into rehab, and that's the first I would have ever known that.
September 4th, 2021.
That was Friday, September the 3rd, when I talked to Lee Cope. And then again when I talked to Alec on Saturday, September the 4th.
Hit you out of the blue.
Like a ton of bricks. I mean, it floored me when Lee called me, and I never expected that.
Thank you. Nothing further.
Further questions? You may step down.
Thank you.
We'll recess now for 1 hour and 15 minutes. Please go to the jury room. Please do not discuss the case. Anything before the jury comes in? Yes, sir.
Please, Court, Your Honor, Mr. Waters has informed me that he is going to call a young man named Satterfield, who was one of the heirs of the Satterfield estate. Allegation is that Mr. Murdaugh converted those proceeds as like all the other conversions we've heard about. The difference is, in this case, he is the victim, and you know, Mr. Waters used the term gilding the lily the other day. He told us it meant piling on. Under the 403 analysis, and again, this is being allowed for the limited purpose of motive, we believe and would submit to the court that this is more prejudicial than it is probative. They've got records they put in of millions of dollars of theft, and you know, we would offer that if he has some summary chart, or we would, pursuant to our previous objections, stipulate to it as to the loss involved in this case for purposes of what Your Honor's already allowed, with the obviously that stipulation be subject to our previous objections, rather than calling, you know, witnesses who are victims that add nothing to the evidence that Your Honor's allowed. And we would, under Rule 403, object to the prejudicial being more outweighed, the prejudicials outweighed by any probative value.
No, yes, sir. Mr. Waters?
Your Honor, again, Mr. Satterfield testified in camera. There has already been testimony admitted again about him stealing through the fake forge from his clients, stealing from his law firm. But this is something different. This is where a situation where he was actually a civil defendant and still managed to misappropriate that money as well. And additionally, the amount of money is extremely significant. It's millions of dollars. And the other thing about this is that, as you heard from Mr. Satterfield, you know, the fact of this being out there was kind of percolating out in the world, and he had conversations with Mr. Murdaugh as time was approaching, and Mr. Murdaugh's telling him, oh, everything's okay with the case and all the rest of it, when the money had long been misappropriated and spent by Mr. Murdaugh. So this is a different type, and it also has a connection with the overriding situation that Mr. Murdaugh found himself in. And so we believe that it still is fair game, and is not its probative value is not substantially outweighed by the danger of any unfair prejudice.
What is the timeline with regard to Satterfield?
So, Mr. Satterfield, as far as the communications with the defendant, the money, actually, the first settlement, I believe, was misappropriated not long after the boat case in March of 19, which is actually another aspect that's going on as well. There's been testimony about how the boat case changed things and created some very significant difficulties for the defendant that was coming to a head at that time. The subsequent recovery, which was much larger, of about $3.8 million, was at some point after that. However, there are, in fact, communications, and you heard from Mr. Satterfield, there are communications, text messages, which I provided to the defense in April of 2021, in which the defendant is assuring him that they're working hard on the case and everything is fine and all the rest of it. And so that is, again, this is part and parcel of the things that are in these hidden aspects of this whole other life that the defendant had that are percolating as everyone moves to June of 2021. Additionally, there are calls. I think Mr. Satterfield testified as to calls in June of 2021. The records reflect some calls on June 22nd between the two of them, but there still are text messages from the defendant. Your Honor, I can have something marked at this time and pass it up if you'd like to see it. These actually were identified after he testified last time, but the defendant reaches out to him and tells him, hey, just checking on you, everything's fine, we're working on the case, it's a tough case, it's a complex case, and therefore, don't worry about it, when, again, the money had been long misappropriated.
Long answer, but not to the question. I said, what is the timeline? And perhaps the text messages have something to do with the timeline. I recalled his testimony, Satterfield's in-camera testimony, something to the effect that in early June or around that time?
The money was diverted in May of 2019.
Yeah, the discovery is what the discovery.
Did not come until
June 22nd, 2021.
Right.
Satterfield testified that he heard reports at some point in time. That's my question to you. The
He
timeline.
testified that as we move into 2021, late 2021, he's hearing reports, and there are reports out there that there had been a settlement in the case. And so ultimately, there's discussions with Alex Murdaugh, which he'll testify he would, talk with a few times a year about the case, and was assured, even though, yes, Mr. Harpootlian's right, that money had been misappropriated a long time ago, that everything was okay, he was working hard on the case. And so the fact of the important point to this case is that issue for the defendant is still out there, and he's got this young man, as we move into the spring of 2021, believing that the case is still ongoing and he's still working on it. And that's the connection here as part and parcel of the overwhelming set of circumstances for the defendant.
Your Honor, just briefly, money is misappropriated in 2019. That young man testified he didn't know when he learned about it may have been a settlement. Could have been before June 7th or after June 7th. And the fact that he doesn't know when, I think, contributes to the fact that it caused for speculation that he knew something or that would have, in some way, would have influenced Alex Murdaugh to murder his wife and son. And that's what the only reason this testimony is coming in is to show there was some immediacy. And by the way, if you look at the phone records, the only calls between these folks began on June 22nd, 2 weeks after the murders. So it's not temporal, and he can't say whether he had any knowledge of the misappropriation of the settlement. Actually, all he know about would be the settlement. That again, there was nothing immediate about this on June 7th from this particular witness. Now, again, we'd be more than willing to some sort of stipulation that that's the timeline, subject to our previous objections, rather than putting a witness up who's going to testify. He doesn't know when he found out about it. Could have been before June 7th, could have been after, and they don't even begin phone calls about it until June 22nd, and there's nothing that no actions begun, nothing coming forward after or prior to June 22nd, and these emails all occur after June 7th. So again, this is a prejudicial versus probative, and this is gilding the lily, this is piling on, this is just more trying to prejudice the jury into believing that somehow someone who steals a bunch of money in any way whatsoever would commit a murder. This is character evidence, pure and simple.
Your Honor, the final misappropriation in the Satterfield case was in October of 2020. And again, there were press articles out there. The texts, he said these emails were after June 7th, and they're not. They're in April. Mr. Satterfield testified in camera that he remembered having a conversation in June of 2022. After that, we actually looked, and we found some phone records, which again are June 22nd of 2021, but we also found these text messages from April in which the defendant is reaching out to Mr. Satterfield and assuring him that he's working hard on the case and all the rest of it. And again, that's part and parcel of the things that were percolating out there and part and parcel of the pressures that were on him that the state's theory is he could not solve.
Your Honor, just one last point. This all began with this idea, argued very thoroughly by the Attorney General, that all this financial crime stuff is to prove that on the night of June 7th, he knew, because of that conversation in the office, that the jig was up, that he, in a day or two, that hearing on Thursday, everyone would know that he was a thief and everything had crashed down on him. And to distract from that and delay things, he went home and butchered his son and butchered his wife. And by the way, I might point out, that same day he learned his father was terminal and wouldn't live much longer, and that would be, in my opinion, as much of, if not more, well, enough of a distraction.
I agree.
For, you agree? That that he didn't need, I mean, there's no rational way he would think he'd need to butcher his wife and son to distract, knowing his father's getting ready to die, which would be a distraction in that community, in that law firm. So again, I think we need to get back to why we began this 3 or 4 or 5, I can't remember how many days we've been doing financial. I mean, this is a murder trial, not a financial fraud trial. And to the extent it goes to motive, again, we're more than willing to stipulate that this amount of money disappeared, that the rightful heirs of it, receipt of it, didn't get it. But putting a child on the stand to talk about, and again, he didn't know when he found out about it, or when he began to raise those issues.
I believe he's an adult, isn't he?
He is an adult. He has a job in an emergency room as a tech.
I apologize to the young man. He looks young to me. I'm sorry.
Anything further?
Your Honor, the only thing I would say is that the state's theory isn't as simple as that. It's broader than that. But again, I think that this is a different category, and it's part and parcel of everything that was going on as we moved to June 7th, and therefore is relevant for the jury to understand very much as the pressures that could cause him to murder his wife and son, particularly in the face of the defense contention that he could never do such a thing.
Satterfield testified in camera that in June of 2021 he made a call to Mr. Murdaugh asking about the status of the case. He made that call, he testified to, because he had heard reports that that there was some concern about the status of the case sufficient to cause him to call Mr. Murdaugh to ask about the status of it. And he testified that he could not remember if he called Mr. Murdaugh or if Mr. Murdaugh called him. But yes, I talked to him in June of 2021. That's according to the rough draft of the transcript that has been provided to the court. I find that this testimony is consistent with the state's theory of of the defendant being in a frantic state, seeking to avoid disclosure of these financial crimes and thefts, and that this testimony is consistent with the state's theory. The court has granted the state's motion to allow evidence of other crimes, and this is additional evidence that that is close in point in time and is admissible, and I deny the motion to exclude it. Yes, sir.
Bring to your attention one factual issue. The Attorney General has...
Of course, I asked, is there anything else? But go ahead.
I apologize, Your Honor. I'm trying to hurry if I can because, there may be an ending to this case someday, but I'm not trying to delay it. The phone records the Attorney General is going to present through this witness indicate the only calls between the two of them were on June 22nd, 2 weeks after the murder. So if there's some phone call, there's no mystery about when the phone call came. After June 7th, 2 weeks later. So in terms of him putting Mr. Murdaugh on alert that something imminent was going to happen, it's 2 weeks later.
Well, it's impossible for anyone to know what's on one's mind or state of mind at any given point in time. But the magnitude of this case almost morphs all the others in the amount, and it is something that I would, if one is being concerned and attempting to prevent disclosure and seeking to divert attention from the impending disclosure of information, and that disclosure would likely have taken place not only for some of the others that we've had testimony concerning, but most definitely this particular one. So I understand your objection. That's a fact and issue, but I find that it's more probative than prejudicial for all of the reasons I previously explained. Yes, sir.
So,
and I don't think whether it's June 1st, 2nd, 3rd, 20th, 21st, 25th, I don't think it's of any significant difference.
well, Your Honor, as you said just a moment ago, and if you charge a jury with this, maybe I'll sit down, which is no one knows what's going on in somebody's mind. Right. And maybe that's something you can tell the jury at the end of this case. Secondly, since this is
specific charge on that intent. Right.
Moving on, we would ask two things. One, I would accept your ruling. I'm not sure I have to do that, but I'm from the old school. If you didn't preserve it,
yes, sir,
it was gone. Secondly, we would ask you to, and I know you said yesterday you weren't going to do this again, but this is, as he's just pointed out, a horse of a different color. It's a different character, kind of witness. I would ask you to read your charge on this testimony once again. And hopefully, I think that we're close to the end of this financial testimony, so it may be the last time I would request you to read it.
Yes, sir.
Thank you.
Yes, sir.
Obviously, leave that to the court's discretion.
Yes, sir. I have it right here. I will give it one more time.
Thank you.
Let's bring the jury. Sir, thank you. Welcome back once again. Ladies and gentlemen, the state's next witness is expected to give testimony, further testimony regarding other crimes committed by the defendant, other alleged criminal activity by the defendant. And as I instructed you earlier, the fact that the defendant may or may not have been involved in other criminal activity is not evidence of or proof that he committed the offenses alleged in the indictments against him. This testimony is allowed for the limited purpose of assisting the state in proving the state's theory or allegations regarding motive, and you may not consider it for purposes of Mr. Murdaugh's character, or you cannot consider that as for propensity to commit other crimes, or that it's more likely that he committed these other crimes which he's been charged but not convicted of but it is being allowed based on the state's theory and representations that it helps explain the defendant's motive to commit the crimes for which he is accused. And you may call your next witness.
May it please the court, Your Honor, the state calls Tony Satterfield.
Left hand on the Bible. Do you affirm the testimony you're about to give the court shall be the truth, so help you God? State your name again for the record. Spell your last name after you sit down. And pull your chair up so we can hear you, okay?
My name is Michael Satterfield. My last name is spelled Satterfield.
Mr. Satterfield, how you doing today?
Good, how are you?
I'm good. Tell the jury just a little bit about yourself. Where'd you grow up, and what do you do for a living?
I grew up in Hampton, live in Beaufort, and I work at Beaufort Memorial Hospital.
Okay. Awesome. And court reporter's taking stuff down there. I'm really known for talking fast too, but let's slow it down so they can get everything down. You grew up in Hampton, you said?
Yes.
And you said where'd you work?
Beaufort Memorial.
Okay. And what do you do there?
Work in the ER.
How long have you been working there?
A little over 5 years.
Okay. And where did you work anywhere prior to that?
I did.
And where'd you work?
The pharmacy.
Pharmacy. Who's your mom?
Gloria Satterfield.
Gloria Satterfield. And is your mom still with us?
She's not.
And when did she pass?
February 26, 2018.
And do you have a sibling?
I do.
And what's his name?
Brian.
Where'd your mom pass?
In the hospital.
Did something happen to her?
Yes.
Tell the jury what happened to her.
She had a trip and fall.
And where did that occur?
I'm not sure the exact date that occurred.
But where?
I'm sorry. At Moselle in Colleton County.
Okay. Was she working for the Murdaugh family?
She was.
And what did she do for them?
She was their housekeeper, babysat for them, and anything else they needed.
Babysat, whatever they needed?
Yes.
Housekeeper? How long did she work for them?
A little over 20 years. I'm not sure the exact amount.
20 years. During that time, did you get to know the Murdaugh family?
I did.
Did you get to know the defendant, Alex Murdaugh?
I did.
Do you see him here in the courtroom today?
I do.
Can you point him out to the for the jury? Can the record reflect he's identified the defendant? Your mom worked for this family for 20 years, babysitting. She helped raise the children.
Yes.
Did you get to know Maggie?
A little bit, yes.
Did you get to know Paul or Buster at all?
A little bit, yes.
And you got to know Alec? Right?
Yes.
You said your mom had a trip and fall at Moselle at their property?
Yes.
And she go to the hospital?
Yes.
Was she ever able to tell you how she tripped or anything like that?
No.
How long was she in the hospital before she passed away?
Give and take 4 or 5 weeks, somewhere up in there.
After she passed away, did you, was there a funeral?
Yes.
And after the funeral, did people go to somebody's house and visit like people do?
Yes.
At any point in time during that funeral or thereabouts, did you have a conversation with the defendant over there?
Yes.
And what?
Objecting to questions by Mr. Water that respond with a yes or a no. Those are typically leading questions. Not that I'm concerned about these questions, I just don't want my lack of objection to lead to somebody's belief that he can ask questions that respond with a yes or a no.
Mr. Waters?
I think my question did not suggest the answer. It said, did you have a conversation? And my next question was, what was that conversation? So what was that question, what was that conversation you had with the defendant at the funeral or thereabouts?
If I remember correctly, I'm gonna kind of take care of you boys and kind of, you know,
He's going to do what? I'm sorry?
take care of you boys.
All right. Did he say how he was going to do that?
Partially, yes.
And what did he say?
He was gonna file a claim against his insurance company.
He's going to what?
File a claim against his insurance company.
His insurance company?
Yes.
Did he say how much coverage there was?
Like 505,000, I believe.
505,000?
Yes.
And did he say anything about how much money you may receive?
The goal was to get me and my brother Brian at least $100,000 apiece.
And did any other bills need to be taken care of?
The medical bills.
For who?
My mom.
When he told you that, did you agree to do that?
Yes.
Did you view the defendant as your lawyer?
Yes.
Did you go and meet with him about it?
Yes.
Did he tell you about what to do with any paperwork you may receive?
Any paperwork or bills or anything, just send them to him.
Have the Elmo, please.
No objection subject to our previously made objection.
All right. Is that something you're offering into evidence?
I'm going to show it to the witness, but yes, sir. Yeah, I'll offer States 372 in evidence. So.
No objection.
It's submitted without objection.
Let me ask you this. So, did you agree to let the defendant go forward with this claim?
Yes.
And I'd asked you whether or not what he told you to do about paperwork, and I'm going to show you what's been marked as Exhibit 372 to your testimony. Do you recognize that?
Yes.
Tell the jury what that is, please.
This is a cover sheet that I sent him with, I believe behind it was like a hospital bill and some kind of other important paperwork.
Okay. So you had received some paperwork in the mail?
Yes.
And did you handwrite this?
I did.
All right. And who did you send this to?
Alex Murdaugh.
Put it up on the screen. And tell the jury quickly what this is about. Can you see it on the screen? I can bring it back to you if you need.
Okay. So this is a cover sheet that I attached to the documents that I sent Alex.
Okay. And what kind of documents? Do you remember what kind they were?
One was a hospital bill, and one was from the trailer company, I believe. I don't recall exactly what it was.
The trailer company for who?
My mom.
For your mom. And the hospital bill for who?
Yes, my mom.
Your mom? Okay. And you sent these to him because they were relevant to the case?
Yes.
At any point in time, did you, as this case was developing, did you go and meet with the defendant at his office?
Yes.
Did he have any paperwork for you?
Yes.
Did he get you to sign some paperwork?
Yes.
Did you become the personal representative of your mom's estate?
I did.
And who gave you the paperwork to sign for that?
Alex.
When you signed that paperwork, were you aware that there had already been a...
Your Honor, leading.
Can't lead the witness.
I'll rephrase. At some point in time, did Alex say he wanted to involve another lawyer?
Yes.
And who was that?
Corey Fleming.
And what did he tell you about that?
If I understood it correctly, I'm going to send you to Corey Fleming, my friend, because I can't do it against, do the claim against myself because it would be a conflict of interest. That's how I understood it.
And did you ultimately meet with Corey Fleming?
Yes.
How many times did you meet with him?
If I recall correctly, maybe once or twice.
Over the course of this case, if you had a question, who would you call?
Alex.
At some point, did the defendant, Alec, have a conversation with you about letting someone else be PR?
Yes.
And what was that conversation?
That I should let somebody else be PR because based on he's a businessman and it would be hard for the insurance to go up against somebody like that.
Okay. And who told you that?
Alex.
And what did you say to that?
Yes.
All right. And did somebody else get involved at this point?
Yes.
And who was that?
The PR, Chad Wessendorf.
At that point in time, did you sign any paperwork for him to become PR?
I
Chad?
did.
All right. And who brought you that paperwork?
I believe I signed it at Alex's office or either I went to the bank. I can't recall.
And at that point in time, were you aware of any recovery in the case?
No.
Were you aware a recovery had already been received in the case?
No.
Did anyone at that time tell you there was already $505,000 that had been recovered?
No.
That's not in evidence. I mean, he's just throwing these numbers and times out. There's nothing in the record to indicate when it was received or how it was dispersed. I object.
I asked him, Your Honor, I'm sorry. I asked him if he was aware of that. I think that's relevant.
Aware of something that no one's said happened? I mean, I would object.
You rephrase your question, please.
Did Alec tell you there had been a recovery of $505,000 already in the case at that time?
No.
Did he ever tell you there had been a recovery of $505,000 at that time?
No.
Was there a recovery at that time of $505,000 as you come to find out?
Later on.
Later on you found out?
Yes.
And did he ever pay you one dime?
No.
Who was the PR that the defendant talked to you about appointing instead of you?
Chad Wessendorf.
Did you ever meet with him?
Yes, like once or twice.
Did he ever tell you about a $505,000 settlement that already had occurred?
No.
Did the defendant ever tell you that he also had a $5 million umbrella policy?
No.
Did he ever tell you that there had been a recovery against that?
No.
Did he ever tell you that there had been a recovery for $3.8 million against that?
No.
Did he ever pay you one penny of $3.8 million?
No.
As the months went on and moving into the early part of June 2021, would you periodically have conversations with Alec about the case?
Yes.
How often do you think you would talk to Alec?
Every 3 to 4 months, give and take.
And do you recall what Alec would tell you about the case?
Yes. First it started off, the hard case, and then it was making progress.
Say that again.
At first it started off as it was going to be a hard case, and then it turned into we're making progress.
You're making progress?
Yes.
And what had the defendant told you about the most that you could recover? What did he tell you at least?
Nothing.
I'm going to show you what's been marked as State's Exhibit 463 to your testimony and see if you recognize that document.
Yes, I do.
And what are those?
These are text messages between me and Alex.
Your Honor, at this time I would move State's 463 and 453, excuse me, into evidence.
Subject to previous objections, no objection.
Okay, it's admitted.
All right, I'm going to put this up on the screen and kind of zoom it in. You got a screen over there, but if you can't see it because the writing's kind of small, you let me know and I'll bring it to you, okay? Do you recognize that's on the screen right now?
Yes.
And who is that text from?
Alex.
And who is it to?
Me.
And can you read to the jury what that text says?
It says, "Hey man, just checking in, been working on case and made me think about you. Hope all is good. Call me anytime I can help."
And what was the date of that text?
April 12th, 2021 at 12:47.
All right. I'm going to go to this next one. Do you recognize that text?
Yes.
And who is that from?
That is from me to Alex responding to his text.
All right. And read that text to the jury once you sent.
That text says, "Hey man, I'm doing good. By the way, how's the case going? Just curious. But how are you?"
I'll show you this next text. Do you recognize that?
Yes.
And who is that from?
That is from Alex to me.
All right. And can you read that to the jury?
"Finally getting some movement. Still a ways to go. Doing good. Was just thinking about and thought I'd check in. Hope to see you soon."
Still a ways to go is what he said?
Yes.
At that point in time, did he tell you there had already been 2 recoveries in the case?
No.
Going to this last text, what is that? Who is that from?
That is from me back to Alex responding to his text.
All right. And what does it say?
Cool, thanks.
Hold on for me just one second. Your Honor, I believe without objection, I'm going to strike out one of the phone numbers on here so it can't be viewed. That's correct, Your Honor. Around this point in time, so we're in the late spring of 2021, had you become aware of any media reporting about there actually being a settlement in your mother's case?
Yes, somebody sent me a text or something saying a legal document, but I can't remember who sent it to me.
All right. And you can't remember who sent it to you?
Yes, that's correct.
Did that cause you to reach out to the defendant and ask the status of the case?
Yes.
Do you remember roughly when that was?
I believe in June.
Okay. And do you remember if that was before or after the murders in this particular case?
I believe that was after.
Okay. And have you seen some records since the previous time in talking about this?
Previous to the call, no.
I'll show you what's been marked as 454 to your testimony. Is that some records you've been provided?
Yes.
And those just some records of phone calls between you and Alec
Yes.
on June 22nd?
Yes.
Did you have any, would you periodically reach out to the defendant and get updates about the case?
Yes.
And you had family reach out and ask you to get updates because of reading things in the media, is that correct?
That is correct.
And you had conversations with him in June of 2021?
Yes.
You don't remember if those were before or after the murders?
He already answered the question after June 7th. I would object to the leading question. I would object to the suggestion that he hasn't already answered that this occurred after June 7th of 2021. He's impeaching his own witness.
Trying to impeach this witness. I think I'm establishing a point that's not in dispute. These records say what they say.
I'm talking, I think he was prefacing that question with, you don't remember when you learned about it, sometime in early June. If he's conceding the witness said he didn't learn about it until after June 7th, we don't have an argument. He's already testified to that.
Final speaking response.
Your Honor, this witness has testified he had a conversation in June. He's testified in the spring of 2021 that he became aware of media reports and reached out to him. We've already seen some texts and we have some calls. I'm just following up on the fact that he had repeated communications with the defendant, asking him what is the status of my case, and was told as we move in time to the murders, oh, everything's fine, I'm still working on it.
Objection sustained as to leading the witness.
For thanking you. It's just a habit I got in and I can't seem to break it. I apologize. And by the way, if you ruled against me, I would still say thank you. It's just what I've learned to do. I don't know whether it's an old-time thing or not. But I apologize.
Thank you, Mr. Harper. Just to clear this up, how often would you talk to the defendant?
3 to 4 times a year, something I believe. I can't recall. Every few months.
Would you talk by phone or would you talk by text or both?
Both.
And when you would talk to him, would you ask about the status of your case?
Yes.
And each time you talked to him, what did he say?
It was making progress.
Making progress. Did he say it was a hard case or not?
Yes.
Did he ever tell you about how much money he might be able to get for you?
The goal was to get $100,000 apiece for me and my brother.
At any time over the years, did he ever tell you that there had already been a recovery in the case?
No.
At any time over the years, did he mention anything about having a $5 million umbrella policy?
No.
At any time, did he ever pay you 1 penny?
No.
You testified earlier that you became the personal representative. Is that right?
That is correct.
Why were you the personal representative and not your brother?
Because my brother is a vulnerable adult, meaning he has a disability. That my brother, he's a vulnerable adult, so he's not able to function as a normal human being to be doing stuff like that.
He's a vulnerable adult.
Yes.
After the murders happened, at some point after that, did you go seek, or did you and your family go seek additional representation about this matter?
Yes.
And who did y'all eventually go to?
My aunt and my uncle went to Mark Tinsley, and then they sent us to Eric Bland.
And are you aware of there being a confession of judgment in your case against the defendant for those missing recoveries?
Yes.
This document.
Sir.
Your Honor, I'll offer states 352. And you're aware there's a confession of judgment in that case?
Yes.
Did you have to file a claim against the defendant for those 2 recoveries you never got for your mom's case?
Yes.
And I'm going to show you 352. You're not a lawyer, are you?
No.
And have you read all that legal stuff in there?
Yes.
All right. But this has been something that you're aware of that occurred in your case. Is that correct?
That is correct.
And ultimately, there's a confession of judgment in the case. Do you know how much it is right there?
$4,305,000.
And is that for $3.8 million for one of them?
Yes.
And for $505,000 for the other recovery?
Yes.
Oops, I just did it. When the defendant came to you around the time of your mom's funeral and said he was going to help you and file a claim on your behalf, why did you agree to that?
Because I trusted him.
Thank you. Nothing further.
Examination.
Please report, Your Honor.
Yes, sir.
Your name is Tony.
Yes, sir.
May I call you Tony rather than Mr. Satterfield?
Absolutely.
Call me Dick instead of Mr. Arpisian, and then we'll make this a little quicker. Between your name and my name, it might add a little bit to this cross. So let me ask you a few questions about your mother's death, and I apologize if in any way this brings back bad memories. I apologize. Y'all filed a lawsuit or made a claim against, basically Alec told you he would be the defendant. You'd be suing him, right?
Yes.
Okay. And it was based on some dogs tripping your mom as she was going down the stairs. Is that right?
That's what they said, yes.
Okay. But the only person that represented dogs tripped your mother going down the stairs was Alex, right?
Yes.
Okay. So without his assertion, if she just fell down the stairs, there'd be no lawsuit, right?
I guess that's correct.
Okay, I'm sorry, you're not a lawyer. You would accept my representations if she just fell down the stairs on her own. There would be no one to blame for that, right?
All right. Repeat the question because I don't understand the question.
It's okay. Strike it, withdraw it. It's going down a rabbit hole. Don't need to do that. So let me ask you this. During this process, your lawyer, for the record, he told you, was Corey Fleming, right?
Yes.
And that was your lawyer.
Well, it was Alex Murdaugh. They were all a team.
They were a team. The person being sued, and
Yeah.
again, you're not sophisticated on this, was part of the team to get you a recovery.
Yes.
Okay. Now, there's a guy named Chad Westendorf. He was with a bank, right?
Yes.
And he was actually the PR. He took over, and it was his job to make sure y'all got your money, right?
Yes.
Did you ever meet with him?
Yes.
And what did he say?
Like one time, it was just to sign some paperwork for him to be PR.
Right. And did you ever call him and say, what's going on with my case?
No.
Did you ever call Corey Fleming and ask what's going on with my case?
No.
And let me make sure I understand your testimony. You got some notice of something in the paper, and at some point after June 7th, you had either a phone call or a text or an email with Alex Murdaugh asking him what's going on, right?
Yes.
Now, and again, we see a series of phone calls on June 22nd.
Yes.
Is
Yes.
that right? Where y'all were talking about this.
Yes.
But was there anything on June 7th or prior to June 7th where you accused him of anything?
Prior to June 7th, no.
Okay. Now, after you became aware of we saw just a moment ago a confession of judgment where Alex Murdaugh admitted that he owed you $3 million. Not get this wrong. Where's the confession of judgment? There it is. $4,305,000. Is that right?
That's the judgment, yes.
Okay. But you hired a lawyer, Eric Bland, very fine lawyer, and he actually sued Mr. Murdaugh's firm and some other folks and got you $6.5 million, right?
Yes. Or no, not that I'm aware of.
Pardon me?
Not that I'm aware of. The only thing I'm aware of is the judgment.
So Mr. Bland didn't tell you about the $6.5 million?
Yes.
Okay, I'm sorry. I just want to make sure history's not repeating itself here. And so you actually recovered $6.5 million, which would be couple $1 million more than you would have gotten had you received the money that Alex took, right?
Yes.
Okay. So you've been made more than whole for that loss.
Yes.
$2 million more than you would have gotten had he not taken your money, right?
Okay. Yes.
Okay. Now, sort of the last question that I think I have for you, but let me check with my co-counsel before. Well, one last question is this. On June 7th, prior to June 8th, had you ever threatened Alex Murdaugh with exposure?
All right, could you repeat the question again?
Prior to June 8th, 2021, did you ever threaten Alex Murdaugh saying, I know you stole my money, where's my money? You know, I know you've got the money. Did you threaten him in any way?
No.
Okay. Thank you. I have no further questions.
Thank you. Going back to, excuse me, get the right exhibit. States 453. These were texts that you had about the case, is that right?
Yes.
And when did those occur?
These occurred in the spring and April of 2021.
April of 2021. And there had been media reporting about there being a settlement in this particular case, even though you hadn't received any money?
Yes.
Did you have periodic conversations with the defendant over the course of time?
Yes.
And would you ask him about the case?
Yes.
And he would tell you what?
It's a hard case, but it's a work in progress.
After all this happened, have you come to find out that the defendant took all of your money?
Yes.
And that's what led to that confession of judgment?
Yes.
Did he, though, ever pay you 1 cent?
No.
You were asked about Corey Fleming, and I think you said they were all a team. Is that
Yes.
right?
Yes.
At its core, who did you consider was your lawyer for your mom's case?
Alex.
Thank you, Mr. Satterfield. Nothing further. He may have one more question.
Anything further?
No. Thank you.
All right. You may step down. Thank you. Let me call your next witness.
The state calls Jan Malinowski.
Raise your right hand. Left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? I do. Take a seat in the witness stand, please.
Thank you.
State your name again for the record. Spell your last name.
My name's Jan Malinowski, M-A-L-I-N-O-W-S-K-I.
Mr. Malinowski, how are you doing today?
Doing well, thank you.
Good. Introduce yourself to the jury a little bit. Just tell them a little bit about yourself, kind of a little bit about your background and your career, and ultimately where you are now.
I am currently the CEO of Palmetto State Bank, headquartered in Hampton. I work in the Beaufort office. Started banking career out of the Citadel in the late 70s. Went to graduate school at the University of South Carolina. Had a progression of jobs at larger banks, Wachovia Bank and Trust, Barnett Banks of Florida, First Union Bank, and then in February of 1991, I joined Palmetto State Bank.
Okay. And Palmetto State Bank, so you've been there since 1991?
Yes, sir.
And what roles have you served at Palmetto State Bank over the years?
Principally in charge of both of our branches. We have two branches in the Beaufort area, one on Ladies Island and one in the Burton, which is west of Beaufort. And that's been primarily my focus on a day-to-day basis, but I do have other responsibilities inside the company.
Okay. And your primary focus has been on Beaufort. Here recently, has your duties or your role expanded?
It has.
And what is your current duty right now, or what your current
I'm the
title?
Chief Executive Officer.
The CEO. Okay. And when did you become the CEO of Palmetto State Bank?
April of last year.
April of last year?
Yes.
Would that be 2022?
Excuse me, I mean August of last year. I'm sorry.
August of last year. 2022.
Yes, sir.
Who was the CEO prior to that?
Russell Lafitte.
We'll talk more about that in a bit. Tell me a little bit more about the governance of the bank. Is there a board of directors?
There is
And how many people are on the board of directors?
currently 8.
And is there a executive committee of board of directors and other senior leadership at the bank?
There is.
And can you describe that for the jury, please?
The executive committee today consists of our chairman, Becky Lafitte, Norris Lafitte, Liz Malinowski. I'm on the executive committee, and Gray Henderson is on the executive committee.
All right, but describe to me how that works. What's the purpose of the executive committee?
The executive committee is charged with typically making the senior decisions, management, upper management decisions that affect the day-to-day operations of the bank.
And let me ask you this. As far as giving loans, are there levels of authority for different officials in the bank, and does that sort of graduate depending on the amount?
That's correct.
Can you explain that to the jury?
Throughout the bank, we have a number of loan officers, each of whom is granted a certain level of lending authority, which is approved annually by the board of directors. Any loans made, single loans above their lending authority or above their limits would then go to 2 executive officers, either myself or Ms. Henderson, to be approved or denied within our level of authority, which is up to $1 million. And then if for any loan, single loan or relationship from $1 million to $1.5 million, both she and I would have the approval authority, and anything above $1.5 million up to $8 million currently goes to the executive committee for approval.
With those levels of authority, still if you have large loans with a particular customer or typical client, are those the kind of things that might be discussed and updated in board meetings and executive committee meetings?
Executive committee meetings first, and those would be minuted in the executive committee minutes, and then elevated to the board, and periodically there'd be board discussions, yes.
Let's talk a little bit and going back to September 2021 and before. And just want to talk a little bit about the bank then. Your primary focus in the bank was where at that period of time?
Beaufort.
All right. And was there another sort of hub of focus in the institution?
Well, Hampton is our main office.
Okay.
It's the largest branch among the 7 branches.
Back at that period of time, September 2021 and prior, explain to me how those 2 hubs work and just generally how the bank operated in practice in that regard.
Well, Hampton, being the largest office, had the most business. It was also a location where Russell Lafitte had his office, his father Charlie had his office, and Sister Gray Henderson had her office. Largely, I was focused on the activities in Beaufort, as I said earlier.
Did the bank have kind of a decentralized functioning that Hampton kind of did its thing and Beaufort did its thing to some extent?
Yes, sir, to some extent.
And was the defendant a customer of the bank?
Yes, he was.
And was he more in the Hampton side of things or the Beaufort side of things?
Hampton.
Did the defendant have a particular banking relationship with one particular official at the bank or former official?
Yes, Russell Lafitte.
Russell Lafitte? Moving into 2021, spring of 2021, or just during 2021, did you, as primarily the Beaufort side, but also as a board member, did you have any particular concern at that time about the defendant, Alex Murdaugh's, the nature of his relationship with the bank?
At that time, no.
Didn't have any concern at that time.
No, sir.
You were more focused on Buford, is that right?
Correct.
And you had no reason at that time to think that anything was going on, is that correct?
No, sir.
At some point in time, did you become aware, obviously, of the murders of Maggie and Paul Murdaugh?
Yes, sir.
After that happened, did you have any particular concern about the defendant and any loans he owed to the bank or anything like that at the time?
He had significant loans with the bank. The murders were obviously traumatic and tragic. And the board and executive committee did bring up Mr. Murdaugh's relationship with the bank.
Grab some exhibits real quick. We'll show you what's been marked as Exhibit 355 to your testimony. Let me show the defense counsel real quick. And we'll see if you recognize this document.
It's the minutes of a board of directors meeting of Palmetto State Bank, Tuesday, July 20th, 2021.
All right. And who was the secretary for those minutes?
Ray Henderson.
All right. And just quickly tell the jury what minutes of a board of directors meeting are. What do those mean?
The minutes should memorialize the discussions of the board members across any number of topics: loans, operations of the bank, any other topics of interest.
Okay. And just look at that real quick. That's on what date?
It's the meeting of July 20, 2021.
July 20, 2021. And I looked through there real quick, and was there any discussion or any mention of any discussion of any loans with the defendant, Alex Murdaugh?
No, sir, there are not.
Okay. Your Honor, at this time I would move, I believe without any additional objections, State 355 into evidence.
No other objections.
It's admitted.
Moving on from July, I just want to be clear. Were you aware in July of 2021 of any additional loan being made to Alex Murdaugh?
No, I was not.
Moving on into August 2021, did you at some point become aware, or was there some event occurring at the bank where any loans to Alex Murdaugh came to the board of directors' attention?
Yes, on August 9th.
Go ahead, describe that to the jury.
On August 9th, our board member, Norris Lafitte, emailed the board and the executive committee asking for a complete accounting of Alex Murdaugh's loan relationship with Palmetto State Bank.
All right, and did any events start to happen as a result of that?
Yes, there were.
All right, let's take them in order, and let's go nice and slow so I can follow along. What was the first thing that happened?
A deposit of $400,000 was made to one of Mr. Murdaugh's account.
A deposit of $400,000. Who caused that deposit to be made?
Russell Lafitte.
At that time, on August 9th, do you know what the balance was in that particular account that money was in?
It was overdrawn significantly, I believe, above $367,000.
All right, and I'm going to hold on for me real quick. Thank you, Judge. State 356. I'm going to show you this document, see if you recognize this.
This is a copy of an account statement, page 2 of an account statement, of account number ending in the 4 digits 6092 of Richard Alexander Murdaugh.
All right. And can you tell me on August 6, 2021, what the balance was in the defendant's account at Palmetto State Bank?
On August 6, 2021, the balance was a negative $347,784.67.
Had the bank continued paying expenses for Alex Murdaugh from June 7th to this date to the tune of $347,000 in money he did not have?
Correct.
Your Honor, at this time I'd move State 356 into evidence.
No additional objections, Your Honor.
It's admitted.
So right here, what date is that?
August 6, 2021,
We'll go up to the top. What's the name on this account?
Richard Alexander Murdaugh.
And what's the balance in his account again, please?
A negative $347,784.67.
What is that right there?
Overdraft charge,
How much is the overdraft charge?
$5.
$5. Is that typical policy for a bank to pay overdrafts over the course of a month for $347,000?
No, sir.
And were you aware of that at the time?
I was not.
What is this right here? This transaction, what's the date on it?
August 9th, 2021.
And what is that right there?
That's a deposit of $400,000.
Okay. And is that what you were describing was the first action as a result of one of the board members inquiring about the status of Richard Alexander Murdaugh's accounts with the bank?
Yes, sir.
And who caused that deposit to be made?
Russell Lafitte.
And what was the source of those funds of $400,000?
It was a debit to an account or general ledger account called Loans Not on System.
What does that mean? Where is that money coming from? Did that belong to any entity? Where did it come from?
It came from the bank.
From the bank. At that period in time, was there any loan application in existence or any sort of paperwork to justify that $400,000?
No.
And after that $400,000 went on in, what was the balance of the account?
Had a positive balance of $52,215.33.
A little walking around money.
Yes, sir.
When that deposit went in, were you aware of a deposit of $400,000 going in at that time?
At that time, no.
And you're a board member, correct?
Yes, sir.
All right, that was the first action. What else occurred, if anything, as a result of an inquiry being made about the defendant's finances?
There was a flurry of activity inside the Hampton office to create loan documents.
To create loan documents?
Yes, sir.
To create loan documents after the fact?
Yes, sir.
What, if anything else, happened after that as a result of that inquiry?
As a result of that inquiry, a memo was drafted and submitted to the executive committee outlining the relationship of Alex Murdaugh at that time.
One second, we'll try to knock out two at once. actions take place, at some point, does this finally come to your attention and to the rest of the board's attention?
It does.
And you recall about what date that was?
I believe it would have been the date of the executive committee on the 12th.
All right. And I'm going to show you what's been marked as State's Exhibit 354 to your testimony and see if you recognize that.
These are minutes of the executive committee that took place August 12th, 2021.
All right. And then reviewing those, do they generally accurately reflect what y'all talked about at that executive committee meeting?
Yes, sir.
And is there any reference or discussion of the defendant, Richard Alexander Murdaugh?
There is.
All right. And again, was this the first time that you were aware of the true nature of his financial condition and the fact of any further monies being expended to him from the bank?
This was, again, the formal summary of his banking relationship at that time. Yes.
Your Honor, at this time I'd offer States 356 in evidence. 354, my apologies.
It's 354, correct?
354.
And no additional objection, Your Honor.
Submitted.
All right. And the first sentence is, what does that say right there?
It says Gray Henderson distributed a memo to the members outlining the bank's current relationship.
Okay. And what's the second sentence right there?
Indebtedness totals $4.2 million, consisting of various unsecured and secured notes, a co-borrowing, and guaranteed loans.
So he owes the bank how much at that point in time?
At that time, $4.2 million.
You also got that too, correct?
Yes, sir.
I'll show you what's been marked as 365 to your testimony or to this trial and see if you recognize that.
This is a copy of the memo that was presented to the executive committee on the 12th of August.
All right. And Your Honor, this time I'd offer States 365 in evidence.
No additional objection, Your Honor.
Submitted.
And this is that memo you were talking about that was prepared?
Yes, sir.
All right. And does this kind of set forth some of the debts and obligations that were owed by the defendant at that point in time?
It does.
All right. And in that second sentence, what is that total amount?
He currently has total principal balance through family, et cetera, of $4,219,623.
This list right here, what does that reflect?
It lists all the loan numbers, the principal balances, and the collateral if they were secured.
Now, you mentioned we've talked about the memo, we've talked about the transfer, and you mentioned that there was some application documentation that started to be created. Is that correct?
Yes, sir.
All right. And you're the CEO now, is that correct?
That's correct.
And you've had a chance to go back and to look into what's happened and review these various records, is that right?
Yes, sir.
Is Exhibit 362 to your testimony and see if you recognize this document.
This is a copy of a Palmetto State Bank promissory note, commercial, single advance, loan number 6996048, in the amount of $750,750.
And who's the borrower on that particular document?
Richard Alexander Murdaugh.
All right. And then I'm going to show you what's been marked as 363 and see if you recognize that.
This is a document that accompanies the note. It's part of the loan package. It's called a business purpose statement.
All right. Your Honor, this time I'd move in States 362 and 363.
No additional objection, Your Honor.
Submitted.
All right, let's take a look at this document real quick. This is 362. Looking at the last page, what date is that document signed?
July 15th, 2021.
All right. Going back and looking at the first page, could this document that was at least supposedly signed on July 15th, 2021, could it have even existed on July 15th, 2021?
No, sir.
It could not have.
It could not have.
And tell the jury why you know that.
Because the loan numbers generated by one of our software programs related to loan transactions, the loan numbers are issued sequentially.
All right? And so this sequential number
This was not a July sequence number.
all right? And so what month would it have been a sequence?
August.
And is that how you know that this didn't occur until August after that inquiry was made?
Yes, sir.
Well, let's talk about July 15th, 2021. As things have come to light and you look more into this, did it come to your attention as to why these documents would have been backdated to July of 2021?
Yes, sir, because there was another subsequent transaction.
All right? And what transaction was that generally?
It was a wire transfer.
Okay. I'll show you what's been marked as States 358 to your testimony, see if you recognize that.
This is our standard domestic wire request form dated July 15th, 2021.
Okay. And, Your Honor, this time I would move to admit States 358. No additional objection.
Admit it.
Did you know about this wire when it was sent?
No, sir.
Did you know about this wire in August of 2021?
I did upon subsequent investigation, yes,
And when did you find out about that, roughly?
in August of 2021.
Put this up on the screen. What's the date on this wire?
July 15th, 2021.
And where does this wire go?
It goes to the Wilson Law Group, LLC, IOLTA account.
IOLTA account? Are you familiar if that's a lawyer trust account?
Yes, sir.
And what's this page that's attached to it?
Appears to be the wiring instructions. The account name, Wilson Law Group, LLC, IOLTA account. Bank is South State Bank in Bamberg, South Carolina, and South State's routing number. Contact information is Chris at wilsonlawgroupsc.com, Gail at wilsonlawgroupsc.com.
And what is the source of funds for this $350,000?
Again, it's the bank's internal account, general ledger account, loan not on system.
Loan out on system. It's bank money.
Yes, sir.
And at this time, was there any documentation whatsoever justifying $350,000 of bank money being given to the defendant to send to Chris Wilson?
No, sir.
When you had a discussion at the board meeting in August of 2021, were there any representations made to you about the purposes for some new loan to Alex Murdaugh?
Yes, there were.
And what were you told the purposes were?
Repairs to Beach House.
Repairs to the beach house?
Yes, sir.
And who told you that?
Russell Lafitte.
Okay. And did he tell you at any time that it was $350,000 to Chris Wilson to put some fees back?
No, sir.
Did he tell you that at any time it was $400,000 to cover a negative $347,000 overdraft that the bank had been paying for him since June of 2021?
No, sir.
I'll show you what's been marked as Exhibit 359, see if you recognize this.
This is the customer copy of a cashier's check number 287933 in the amount of $400,000, dated 8/9/2021.
All right. And does it have what appears to be a copy of a sticky note on there?
It does.
And whose writing is that? Do you recognize it?
Russell Lafitte's.
All right. And there's a reference to Green Swamp stock. Is that correct?
Yes, sir.
Do you know what that is?
It's a hunt club. It's shares of a hunt club, a share of a hunt club.
I'm going to show States 363 up on the screen, and I showed you this previously, but what is this document?
That's the business purpose statement.
All right. And what does it say? Is this for that loan in which the application is being drafted after the fact?
Yes, sir.
And what does it say the purposes are?
Purpose is investment.
All right. And what, again, had you been told as a board member was the purpose of this supposed new loan?
Repairs to the beach house.
As you've come to review all of this information, was any of that $750,000 used for any repairs to the beach house?
To my knowledge, no.
And when it's $750,000, we're talking about the $350,000 of the wire to Chris Wilson, correct?
Yes, sir.
And then the $400,000 to cover the overdraft, and then a little bit.
Yes, sir.
At some point in time, was there any discussion about collateral for this particular loan?
Yes, there was.
All right. And tell me about those discussions. What was your understanding of collateral for these loans?
The collateral was to be a second mortgage on the beach house and the one share of Green Swamp stock.
And as things progressed, did any of that change as far as collateral?
We did not put the mortgage on the beach house.
And why was that?
Mrs. Murdaugh was deceased, and she had an ownership interest in the beach house.
At some point in time, I'll get to that in a minute. So ultimately, this particular loan, did it have any collateral at all?
Nominally, the Green Swamp stock.
And why do you say nominally?
It had been cross-collateralized to other loans.
In your experience as a banker, is it common or usual to provide a new loan to cover an overdraft like was done in this case?
Not to this magnitude, no, sir.
Let me show you what's been marked as States 357 and see if you recognize this.
These are minutes of the directors of Palmetto State Bank, Tuesday, August 17th, 2021.
Your Honor, this time I would offer States 357 into evidence, I believe, without additional objection.
Correct. No additional objections.
Submitted.
All right. Is there a discussion of the defendant in this particular document?
There is.
Now, we'd seen one before, which was an executive committee meeting in August. And was this the subsequent board meeting?
Yes, it was.
All right. Let me put that up on the screen. You have a screen right there. If you can
Yes, sir.
see that. If you have problems seeing it, just let me know, and I'll bring it back to you, okay?
Yes, sir.
All right. And this is the discussion as it relates to the defendant right there?
Yes, it does.
All right. And real quick, what's the second sentence right there in this particular discussion?
Russell L. Lafitte stated that his intention is to sell the farm.
All right. And down here at the bottom, what does that sentence right there say? Starting with Elizabeth.
Elizabeth Malinowski commented the $750,000 loan did not appear to have been approved by the executive committee.
All right, and then what's the next sentence?
Russell Lafitte explained that 3 of the 5 members approved the loan.
All right, and so with 3 of the 5 members approving the loan, were you on the executive committee at that time?
I was, yes.
But you were not informed of any of these monies being expended or this after-the-fact documentation or any of it, is that correct?
No, sir.
As some of these things ultimately came to light in the months following, what happened to Russell Lafitte?
He was terminated from the bank.
And is that what led to you ultimately becoming CEO?
Yes, sir.
In the course of your review as CEO of what had been going on at your institution, did you become privy to information that Russell Lafitte had been converting trust account checks from PMPD made out to Palmetto State Bank?
Yes, sir.
And that those checks had been converted, that those were client money checks and had been converted for the benefit and for the personal use of the defendant?
Yes,
And is that practice improper?
it is.
I'm going to show you what's been marked as States 366 to your testimony. See if you recognize this document.
This document is a printout from our loan accounting system, which summarizes the loans outstanding to Mr. Richard Alexander Murdaugh
As of a particular day?
as of June 7, 2021.
Your Honor, this time I'd move State 366 into evidence.
No additional objections.
Submitted.
All right, let's take a look at it. Can you see that all right?
Yes, sir.
All right, there's certain numbers that are highlighted here. Is that the balance as of that particular date?
It's the principal balance, yes, sir.
All right, and so that number right there is what?
$104,119.80.
And the balance right there is what?
$806,666.26.
And the balance right there is what?
$195,171.64.
And that balance right there, what is that?
$999,650.94.
And then finally this.
$91,368.90.
This particular one right there, is that a line of credit?
Yes, sir.
And how much, what's the limit on the line of credit? Line of credit's kind of like a credit card. It's got a limit on it, right?
That's correct.
What's the line of credit? How much was it for?
$1 million.
And what was the balance on it?
$999,650.94.
Pretty much maxed out.
Yes, sir.
Going back to States 365, we've got this one right here. What was the balance on that one with this memo that was prepared around August of 2021?
That loan balance is $599,400.
And was that also a line of credit as well?
It was,
And what was the limit on that line of credit?
I believe, $600,000.
So that one was pretty much maxed out too, correct?
Yes, sir.
Not listed on States 366 are two that are on this memo. One says Zero United and one says Red Deer. Are you familiar with what those are?
Yes, sir.
And are those business entities?
They are.
And do you know who those are associated with?
Mr. Murdaugh was a partner, member of the LLC.
All right. And had those two loans been charged off?
They had been.
And to your understanding, those entities own real property?
Yes, in Berkeley County.
All right. When you say charged off, what does that mean? Explain that very quickly to the jury.
In the banking, if a loan becomes uncollectible for whatever reason, the borrower suffers financial difficulties, other issues, the bank will at some point in time make a determination whether to take it off its books and subsequently charged off.
Okay. Did the bank foreclose on the properties under those particular two entities?
We did not.
All right. And so it takes it off the books, so it stops accruing interest and late charges and all that kind of stuff, right?
Actively, yes, sir.
Actively, at least, correct?
Yes.
And did the defendant, was he still, though, expected and required to keep paying on those particular loans?
It didn't dissolve him of his obligation, but he periodically made payments.
Periodically made payments on
Yes.
those loans. If the defendant had tried to sell those properties or something like that, what if anything, would the bank would have been entitled to in the event that was attempted?
We would have been entitled to the outstanding principal balance at the time, plus lost interest and any late fees and charges.
All right, so that would have to be applied against any sale price before those things could be, that property could be sold, correct?
Yes, sir.
And it would be somewhat higher than the numbers on this memo, is that right?
Yes, sir.
One of the things on here is this particular loan right here. And what is that for?
A house in Edisto.
And in April 2021, was there any sort of thing going on with that particular loan that needed to be addressed?
The loan had matured.
It had matured? And explain to the jury what that means.
At that time, the balance of the loan, the note itself had reached its maturity date, and the borrower would be required to, the bank and the borrower were required to come together and determine what they wanted to do, either renew it, extend it, whatever.
Right, and it had not been paid off, correct?
It had not been paid off, no.
Since it matured, it either had to be renewed or paid off, correct?
Yes, sir.
And because of that need for a renewal, had an appraisal been sought in April of 2021?
Yes, that's my understanding.
All right. Let me show you the exhibit. You need to show it to the defense counsel. Show you what's been marked as Exhibit 364 to this trial, and see if you recognize this.
Top page is an email from Chastity Malfris to Charles Lafitte III, who is the bank's appraisal officer, regarding an appraisal request for 3606 Big Bay Drive, Edisto.
Is that the Edisto house we're talking about?
Yes, sir, it is.
All right. And is this, and that's the appraisal request form underneath it?
It is?
Okay. And that relates to the renewal of the existing loan on Edisto, is that correct?
That is correct.
Did this appraisal have anything to do with this $750,000 that you've been telling the jury about?
No, sir.
This was already in existence because of an existing loan, is that correct?
Yes, sir.
And, Your Honor, this time I would offer States 364 in evidence.
No additional objection.
Submit it.
Almost done. Real quick, one I forgot, states 360. We'll show this to you real quick, and then we'll get to the beginning of the end. Yeah, can you tell me what that
Yes,
is?
sir. This is, I'm sorry, it's the checking deposit ticket of a $400,000 deposit going into an account, last four digits 6092, in the name of Alex Murdaugh. Underneath that is the cashier's check itself, which accompanied the deposit ticket. Cashier's check number 287933 in the amount of $400,000 dated August 9th, 2021.
Your Honor, this time it offer states 360.
No additional objection, Your Honor.
Submit it.
All right, and this is that $400,000 that covered the big overdraft, is that right?
Yes, sir.
All right, I'm going to show you one last series of documents here, one at a time. I'll show you first what's been marked, has not been marked. Show you what's been marked as states 367, and is that a statement balance for an account in the name of Alex Murdaugh?
It is. It's Alex Murdaugh, farm account, account number 1646.
All right, and on June the 7th, 2021, can you tell me the balance on that account?
The balance of the account is a negative $2,458.23.
Okay. Your Honor, this time I'd move to admit states 367.
No additional objection.
Submit it.
I'm going to show you what's been marked as 368 and see if you recognize that document.
It's a copy of an account statement for account number 6092 in the name of Richard Alexander Murdaugh.
All right. And can you tell me what the account balance is on June 7th, 2021?
On June 7th, the balance in the account is $2,185.23.
All right, Your Honor, this time I'd move to admit states 368.
No additional objection.
Submit it.
I'm going to show you what's been marked as states 369, excuse me, and see if you recognize, or you can tell me what the balance, what that document is. If I can get a question out eventually.
This is the account statement for a health savings account. Last four digits 3094, also in the name of Richard Alexander Murdaugh.
All right. And can you tell me what the balance of that was on June 7th, 2021?
On June 7th, it would be $7,540.61.
And that's a health savings account?
Yes, sir.
Can that be used for any expenditures, or is that limited? Is that a special type of account that's limited to medical expenditures?
It's a special account, generally limited to medical expenditures.
Your Honor, this time I'd move states 369 into evidence.
No additional objection.
Submit it.
I'll show you what's been marked as states 370, and see if you can tell me what that particular document is.
Another account, copy of an account statement. This one is the last four digits 6649 in the name of Alex Murdaugh.
All right. Can you tell me what the balance is on June 7th, 2021?
The balance on June 7, 2021 is $62,115.06.
And then finally, I've got a set of documents. And Your Honor, real quick, I'll move states 370 into evidence.
No additional objection.
Submit it.
All right, last one. Can you tell me what that particular document is?
It's a copy of an account statement, number 5109, in the name of Margaret Maggie Murdaugh.
All right, and just real quick, for the record, I'm having you look at States 371. All right, could take a look at it again.
Same account number, Margaret Maggie Murdaugh.
All right, and just go back, can you tell me what the account balance is on that particular account, at least as of, go back to the first one, of June 24th, 2021.
June 24th, 2021, the balance was $23.97.
Your Honor, at this time I've moved States 371 into evidence.
No additional objections.
It's admitted.
All right, I'm almost done. Mr. Malinowski, if at any point in time, if the bank over the years at any point in time had become aware that Alex Murdaugh was having a bank official take client trust money checks and convert them into cashier's checks and other transactions for his own personal use, what would have happened?
Certainly would have a significant conversation in the bank, and we would have asked the bank official to stop doing that.
All right. And what would have happened if you uncovered that the defendant, Alex Murdaugh, was stealing client funds through that method?
That would have certainly affected his borrowing relationship with the bank and any other relationship he had with the bank.
Would they, if you found out the defendant was stealing, would you loan another dime to him?
No, sir.
If you found out that the defendant had created a fake business account in the name of a legitimate entity and was routing and stealing client money through that account and converting it to his own personal use, at any point in time, what would have happened with his relationship at the bank?
It would have ceased.
Would the bank have loaned him any more money?
No, sir.
If the bank found out that the defendant had been forced to resign or been fired from his job, what would have happened with his banking relationship? Would the bank have loaned him any more money after that?
No, sir.
If the bank had found out at any point in time that he had been disbarred, what would have happened to that banking relationship with that defendant?
It would have ceased.
Look at Exhibit 368. What account number is that? What's the last four digits of that account number?
6092.
And on June 7th, what's the balance?
$2,185.23.
Looking at Exhibit 356. What's the account number?
6092.
And by the time that applied for deposit comes in, what's the balance on August 6th, 2021?
On August 6, 2021, the balance is a negative $347,784.67.
Hold on for me 1 second. Thank you, Mr. Malinowski. Please answer any questions the defense may have.
Ladies and gentlemen, we have you go to the jury room for a break. Please do not discuss the case.
Come to order. Please be seated. Your Honor,
Yes.
we have a matter that would need to be heard outside the court's presence.
Okay. Yes, sir.
Hey, please report. This is something new that has come up, Your Honor. I'm sure Your Honor recalls the testimony of Shelley Smith this Monday, and her testimony was, let's say, somewhat malleable. We've discovered late last night that a GoFundMe page was set up for Ms. Smith, soliciting donations until the wording was changed during the testimony of the last witness. It read that my mother was caretaker for Alex Murdaugh's mom. She recently had to testify against him, and goes on to say, I want to reward her for her bravery and honesty. The very first donation made on this GoFundMe page, which was made shortly after it first went up last night, was made by attorney Mark Tinsley, who paid her $1,000, presumably following the description of this in consideration of her testimony. And Your Honor, I have, if you want, printouts of the screenshot showing that. Shortly after Mark Tinsley's name actually appeared as the donor for $1,000, he removed his name, and it now appears as anonymous. But I'm told the Attorney General has confirmed with Mr. Tinsley that he admits he did make this payment to the witness in the middle of trial, who is still under subpoena.
And therefore,
Your Honor, and therefore, the defense would move to exclude his testimony. And
on what basis?
Your Honor, the legal standard here is difficult to find. I cannot, searching Westlaw, find a single case in which a prosecutor has tries to put to the jury a lawyer who has already testified he has a direct financial interest in the outcome of this case, who is also making monetary payments to prosecution witnesses during the trial. Your Honor, I believe that this is a question of first impression. And because it's a question I understand that the facts here in this case are disturbing, but because it's a question of first impression, I would respectfully urge the court to keep in mind the aphorism that bad facts make bad law. A prosecutor, to my knowledge, to Westlaw's knowledge, has never before done this.
What's improper about what he did?
About what Mr. Tinsley did?
Yes.
He made a financial payment to a witness in the middle of a trial that he has a financial interest in the outcome of. He has testified. Who is under subpoena. She's still under subpoena. He made a $1,000 payment as a reward for her honesty, testifying in a matter that he has testified that he has a direct financial interest in.
Well, that would be good fodder for cross-examination.
No, Your Honor, I respect the court's ruling.
I'm not going to strike his testimony. It may be good fodder for cross-examination.
Yes, sir. Thank you, Your Honor.
Yes.
One other issue. Given the testimony in the in-camera proceedings, we would ask that he be precluded from offering testimony about focus groups on the verdict for the Beach matter, speculation about fixing a jury in Hampton County. These matters don't go to the motive purpose that his testimony is being offered for, and would be prejudicial.
Well, I'm loath to attempt to screen testimony in advance. Lawyers ask questions, lawyers object, and judges rule. So you've sounded a warning to the state that you object to that testimony, and if such a question is asked and an objection is made, then I will rule on the objection.
Yes, Your Honor.
Anything else?
Nothing from the state, Your Honor.
Jury. Okay, cross-examination.
Please record.
Yes, sir.
Good afternoon, Mr. Malinowski.
Mr. Riven.
The $750,000 loan that was made in July of 2021, that was approved by 3 members of the executive committee, was it not?
Yes, sir.
And the 3 members that approved that loan were Mr. Charlie Lafitte, Mr. Russell Lafitte, and Ms. Gray Henderson. Is that correct?
That's correct.
And Mr. Charlie Lafitte was chairman of the board of the Palmetto State Bank at the time. Is that right?
Yes, sir.
He was the largest shareholder of Palmetto State Bank.
Him individually, no.
He wasn't the largest individual.
Nope.
Did he own 30% of the bank?
Not individually, no.
Okay. And then his son was Russell Lafitte,
That's correct.
and his daughter was Gray Henderson.
Correct.
And it was his position that if Alex Murdaugh wanted a loan from Palmetto State Bank, that the bank would loan him the money. Is that correct?
That was his opinion.
And Alex Murdaugh was a member of PMPED law firm. You're aware of that at the time?
Yes, sir.
And PMPED law firm was one of the most largest customers of the bank.
It was a large customer of the bank.
And the partners in the firm all had banking relationships with the bank, correct?
I'm aware that many did, yes.
And oftentimes when members of the law firm had clients who needed to borrow money before they got recoveries in their case, the partners from the firm would send them to the bank, and the bank would loan money on future recoveries. Are you aware of that?
Yes, I am.
And so the firm was good business for the bank.
It was a good customer.
And the bank, in turn, provided good services to the members of the firm.
Yes, sir.
And if it meant, getting a loan in a rush without having all the I's dotted and the T's crossed, that would happen. Isn't that right?
Not to that magnitude, no.
Well, it certainly happened with Mr. Alex Murdaugh in July of 2021, right?
Yeah, I believe in August of 2021.
Well, the loan was made, the money was provided to Mr. Alex Murdaugh in July of 2021, right?
$350,000 was provided with that wire transfer I subsequently had knowledge of.
And the documentation was essentially loan not on the books, or what's the acronym?
Loans not on system, LNOS.
Right. But it's a loan, it's just not on the system.
It's an advance from a general ledger account.
To be documented as a loan down the road.
One would hope, yes, sir.
And that's what happened here.
Eventually.
In August.
In August.
Now, Alec didn't work for the bank, did he?
No, sir.
He didn't represent the bank, did he?
To my knowledge, no.
He was just a good customer of the bank. Is that right?
Yes, sir.
And the bank treated him like a good customer because that was in the bank's interest.
Yes, sir.
Now, you said something on direct that I want to follow up on. And my notes say that after the tragic murder of Maggie and Paul, that the bank undertook a loan review of Alex's loans. Is that right?
In response to the August 9th email, yes, sir.
Well, the August 9th email was triggered because of Maggie and Paul's murders?
That and other information, yes, sir.
Okay. And what other information?
I think Mr. Norris Lafitte had asked some questions or had conversations with individuals and wanted to know the full accounting of the bank's relationship.
Okay. And one of the factors that Mr. Norris Lafitte included was he had just lost his wife and son, and let's take a look at his standing with the bank, loans outstanding, et cetera.
I think that's a fair statement, yes, sir.
Okay. Up until June 7th, 2021, the bank was not examining Alex loans, were they?
We're not scrutinizing them, no, sir.
Yeah. He did he and Maggie had a loan review from the bank, whether they knew it or not, back in July 10th of 2020, correct?
Yes, sir.
And I'm going to show you Defendant's Exhibit 91 and ask if this is the loan review that was done, documented to the Executive Committee on July 10th, 2020.
Yes, this is a copy of a loan review prepared by Gray Henderson, the relationship summary of Alex Murdaugh and Maggie Murdaugh.
Thank you. And what's the date?
2020.
July 2020. Your Honor, I would move Defendant's Exhibit 91 in evidence at this time.
No question, Your Honor.
It's admitted.
Just put the front page up there. And so, Doug, go down so we can see keep going. There you go. So, to the Executive Committee on July 10th, 2020, who was on the Executive Committee with the bank?
At that time, Charlie Lafitte, Russell Lafitte, Gray Henderson, myself, I believe Scott Swain was on it at that time.
And it's a 5-member Executive Committee?
Yes, sir.
And I think you mentioned earlier that does it take the majority of the committee to approve loans over a certain amount?
Sitting in a meeting, yes, sir.
Excuse me?
In a meeting, yes, sir.
Okay. And Gray Henderson is preparing this loan review for Alex Murdaugh, right?
Yes, sir.
It says Richard Alexander Alex Murdaugh is a lifetime resident of Hampton County. He and his wife, Margaret B. Maggie, recently sold their home in Hampton and moved their permanent residence to their farm in Islandton. Alex is a respected partner with Peters, Murdaugh, Parker, Ellsroth, and Dietrich law firm. They are currently involved in a wrongful death suit involving their youngest son, Paul, in a boating accident. Civil case is still pending. So that was the background on this.
That was a general summary of current situation.
And then they've reviewed financials related to their tax returns and whatnot. Is that correct?
She's just stating in there that what financial information we have on file.
Okay. And then you go through each outstanding loan. Is that right?
It's a summary of the loan, yes, sir.
Okay, and the first loan is can you tell us what that is? Williams Island on St. Helena?
We had a loan, I believe that loan was a joint loan with a gentleman by the name of Barrett Bowler, secured by 2 or 3 little islands off St. Helena.
And that loan's in good standing? Says all payments
made as agreed, yes, sir.
Okay. And now the next loan is a loan on, that's the Edisto Beach House, is that right?
Yes, sir.
And here it says that the home appraised for $440 in February of 2016, and current balance on the note was $206,000, and this is in July of 2020. Is that right?
That's what it says, yes, sir.
And it says they've been 30 days late 3 times. I think that's what it says.
Yes, sir.
I guess if you go over 30 days on your loan payment, that's a strike against you when
It gets noticed.
it gets noticed. But that house at Edisto, the bank had a mortgage on it dating back at least for some time, right?
Yes, sir.
And you know it recently sold,
Yes,
that
sir.
house. And do you know the sale price?
I think it was just below $1 million.
Okay. So the bank's in a pretty good position here in July 2020 with $200,000 on what sold a couple of years later for $1 million, right?
Many years later, but yes.
How many years later?
Well, I think it occurred in 2022, and this is in 2020.
2 years then? We go with that?
Yeah, I'll go with that.
Is too many?
In the real estate market, 2 years can
Right.
be a long time.
All right. Then the next loan is first mortgage on, I don't know what you're doing there, Doug. It's on 856 acres and the second mortgage on 914 acres. That's the Moselle property, is that right?
Yes, sir.
And what's the outstanding balance of that loan?
$719,769.16.
And what kind of value do you have there?
Good value in it. If the appraisal is $3.3 million.
Now, you know there's a contract on that property today?
I understand there is, yes.
You know what it is?
No, sir, I don't.
Okay. You know it's more than 3.3?
I don't know that.
Okay. Bank still has a mortgage on it?
We do.
Okay. You turn the page, Doug? If that's the last one on there. And here's another loan. And I guess that's part of the same. That's another tract at Moselle with additional, was that the same loan? Are we talking about a new loan here?
I believe we are, yes.
Okay, and what is this?
This balance is $888,527.08.
Okay. And what's the value we have on this?
Assume it's the Moselle $3.3 million from the preceding loan.
Okay.
Two mortgages on the single property.
All right.
Or the acreages.
And then the conclusion here, the summary is Alex and Maggie Murdaugh are longtime customers of Palmetto State Bank. They've had some late payments, but in my opinion, those are mainly due to Alex being hard to reach and set appointments to sign the paperwork. The majority of his payments are set up on an annual basis because the law firm makes their distributions in December. Now, let me ask you about that. Were you aware that a lot of the partners at the law firm who owe money to Palmetto State Bank just pay once a year because that's really when the bulk of their income is generated or received?
That's my understanding. That's correct.
And so this was not special just to Alec, but it's not. But other partners at the firm have the same payment plan.
You're setting up the repayment to coincide with the receipt of their income or the bulk of the income.
Sure. And it says the Murdaughs have always paid their loans to the bank, and I do not see that changing. And it says depending on the outcome of the pending lawsuit, they may have to liquidate some assets, but our loans are more than sufficiently collateralized. Meaning you've got plenty of security. Is that right?
In 2020, yes, sir.
Okay. Thank you. Alec and Maggie have, to your knowledge, never been turned down for a loan at Palmetto State Bank.
My knowledge, they have not.
Now, there were some loans that were, I guess, written off, as you said, or charged off, where Alec was a member of a partnership, LLC, some sort of structure where there are other partners involved, and that those loans went in default. Is that right?
Yes, sir.
But Alec kept paying on those notes, did he not?
Periodically, he'd make payments.
Did any of the other partners in Redbeard or United, were they making payments?
To my knowledge, no.
To your knowledge, it was only Alec that was making the payments?
Yes.
To your knowledge, was there any reason in the world for Alec to believe that in June of 2021, if he needed additional money from Palmetto State Bank, that he couldn't just go down there and talk to Russell Lafitte or Charlie Lafitte and ask for a loan?
In June of 2021,
Yes, sir.
I don't see any reason why he couldn't have that conversation with Charlie and Russell.
And he had, to your knowledge, never put on any notice that your business is not welcome here at Palmetto State Bank in June of 2021. Is that right?
In June of 2021, that's correct.
In June of 2021, the bank is fully collateralized on the outstanding notes.
With the exception of the one where he was a co-borrower, I believe, with his father. I think that was an unsecured loan.
And his father being Randolph Murdaugh.
The third, yes, sir.
The third, yes. One second, Your Honor. I have no further questions, Your Honor.
Redirect.
Very briefly, Your Honor. You're asking about whether Alec made some year-end payments on some of those charged-off loans, correct?
Yes, sir.
And your review was some of that money that was used to make those payments ultimately converted money from client funds?
I believe so, yes.
You were asked whether or not in June of 2021 whether Alec could have talked to Charlie Lafitte or Russell Lafitte about another loan. Is that right?
In June of 2021, yes.
In June of 2021. At that point in time, had it come out that he had been stealing client funds for years?
No, sir.
Had it come out that he had been disbarred?
No, sir.
Had it come out that he had been diverting fees from his law firm?
No, sir.
Had it come out that he had been forced to resign from his law firm?
No, sir.
If any other things had come out, would the bank continue to have loaned him money?
No, sir.
Mr. Griffin asked you if Alec had been a good customer. Correct?
Yes, sir.
When all of this crashed and burned, was the bank left holding the bag for all these uncollected loans,
Yes, sir.
including the $750,000?
Yes, sir.
Nothing further. Thank you.
Mr. Malinowski, the bank had mortgages on the properties that we just went over, did it not?
They did.
And those mortgages didn't disappear when Alex Murdaugh, when all this came to light, did they?
No, sir.
All right. Thank you.
You may step down.
Thank you.
Let me call your next witness.
Thank you, Your Honor. The state calls Mark Tinsley.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give this court in this trial shall be the truth, so help you God?
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name, please.
Afternoon, Your Honor. My name is Mark Tinsley, Tinsley.
Mr. Tinsley, how are you doing today?
Good.
Introduce yourself to the jury a little bit. Please tell them a little bit about yourself, where you grew up, where you went to school, and a little bit about your profession, please.
Sure. I said my name's Mark Tinsley. I'm a lawyer. I practice in Allendale. I've been there since about 2000. I'm originally from...
Mr. Tinsley, get that mic a little bit closer to you.
Well, the mic's short, and my knees apparently are long because this is the most uncomfortable place to sit.
You can bend it down a little bit, maybe.
Yeah. I'm from Anderson originally. I went to Clemson. I carried an orange book bag when I was at Carolina. I went to law school there. I graduated in '98. I worked in Columbia for a couple of years doing primarily insurance defense work. You've heard a lot of plaintiffs' lawyers. So I would have been one of the lawyers representing an insurance company that was hired to or had the coverage on somebody who was getting sued, or I would have dealt with coverage. Is a specific loss covered or something? So that's primarily what I did for the first 2 years. One of my good friends was originally from Barnwell. I made my way to Allendale in 2000, and I've been there ever since.
And so since Barnwell, have you been in a law firm? You've been in practice? Tell us a little more about that.
I have. I practice with Gooding & Gooding. When you live in a small town, you do all kinds of things. I have the luxury of having a successful practice and being able to go to different places and handle cases. I try cases. I try truck wrecks. I try highway defect cases where there's something wrong with the way that the contractor had not really designed the road, but maintained the road, and somebody gets catastrophically injured. I've tried bad faith cases where an insurance company has coverage, but for some reason or another they don't do what they were supposed to do under the contract, and their insured gets harmed as a result or suffers a loss. And so, I pick and choose, but when you're in a small town, you help people. And so I end up doing all kinds of things. There's no case that's too small, no case that's too big. If I can help you, I try to help you.
All right. Over the years, being a lawyer doing this kind of work in this area, have you had call to get to know the lawyers and what used to be known as PMPED?
I have. There's only 17 miles basically between Allendale and Hampton, small bars. At one time, I think there were really only 4, maybe 5 lawyers in Allendale, and about twice, maybe it ultimately gets up to 3 or 4 times that many in Hampton, but it's a small bar. And I had occasion to work with, you saw Ronnie Crosby, I think, yesterday. I've handled a number of cases with Ronnie Crosby. You've heard Lee Cope's name mentioned. I've had cases with Lee Cope, but I knew everybody.
All right. And did that include the defendant, Alex Murdaugh?
It does.
And how long have you known him?
It's hard. I heard Chris Wilson this morning. I don't remember exactly. I came in 2000. I always remember him being there, so sometime shortly after I came to practice in the 14th Circuit.
And do you see him in the courtroom here today?
Sure. He's immediately to the right of Mr. Harpootlian.
Can the record reflect he's identified the defendant? Over the years, as you knew Alex Murdaugh, did you ever do anything professionally, either with him or against him?
I hate to be a lawyer, Mr. Waters. I have. I had a case where a defendant was in default, and Alec was a special referee, meaning you may remember Chris Wilson said in that Mack truck case, one of the defendants didn't answer, and so if you get sued and you don't respond at the right time, then you're in default, and so the other side by default wins generally. And Alec was my special referee, meaning this guy had been accused of selling some property under lien. He was arrested at his job, and we sued a company called Southern Finance that incidentally went into bankruptcy. It's a long, complicated story, but we got reversed, and so I didn't do that again.
But just generally, have you had? Go ahead.
Well, yeah, but I didn't handle cases with Alec. I didn't, unlike say Ronnie or Lee Cope, and we just didn't have that sort of relationship. I guess he and I did so much of the same thing. I don't recall a time over the last 20 years where we worked on a case together.
Being a small bar and doing the same kind of thing, though, y'all are generally familiar with one another and the type of cases y'all were handling and that sort of thing?
Oh, absolutely. I mean, it's a small bar, and you go to the roster meetings, you know what everybody's doing, you see what cases they have. Yeah, absolutely. You know if they have a success, a big case, or a failure.
You ever been in court when Alec was doing a closing argument?
Yes, probably a couple of times. There was he tried a case in Allendale. It was the first case. I think it was '98 that the Allendale courthouse burned. The story is that Judge Peoples from Barnwell was going to sentence some guy for a drug offense, and Judge Peoples was very strict on drug offenses, and so the guys who were going to be sentenced on Monday decided Sunday would be a good day to burn the courthouse. So they burned the courthouse, and so many months later, I think Judge Peoples ended up sentencing them.
Relevance grounds?
At any rate, they rebuilt the courthouse, and so the first case that was tried in 2005, Alec tried, and I was there when he made his closing argument.
You were present when he did the closing on that?
I was.
Did he get emotional during that closing?
He cried.
Relevance?
Response.
Your Honor, I think this is just relevant to the defendant and his practice as a lawyer, background information, and I think there's been a lot put in issue about the defense about that as well, and I think this is fair from this witness.
We're in the year 2000.
2005, March of 2005, it was...
Sustain the objection.
Let me ask you just a little bit about, though, being in this kind of type of work in a sort of small bar in a small area. You said y'all are generally familiar with what each other are doing who do similar work?
I think so.
All right. And when you're, are there any sort of documentation at the court, jury rosters, anything like that, or rosters that you can pay attention to and have an idea of what each other's doing?
Well, I mean, it is a roster. It is a list of cases. Generally, a case comes up for trial, not in civil cases I'm talking about. Supposed to be about a year old. It's usually longer than that, but they go on this list. And so come Monday morning, all the lawyers would show up. There's 100 cases, and so you see what's coming up, who has what cases. And in Hampton in particular, Alec usually seemed like a majority of the cases on the Hampton roster. His name would be on them anyway.
And being a small bar and being, part of that, kind of doing the similar work, is it not uncommon for you to have some knowledge of some of those cases and for others to have knowledge of the cases you're working on?
Sure. Lawyers are the biggest gossips in the world. I mean, everybody knew what everybody was doing.
If you see a case that's on there and then it gets removed or disappears, does that indicate anything to you?
No. I mean, it indicates they were settled. But oftentimes, when you go through the roster, there's actually a notation. The case is settled. The judge will sign what's called a form order, which just administratively disposes of it, takes it off the roster so that it doesn't stay on that list.
And being as part of that small bar, and this is kind of work you do, that's something you generally pay attention to, as other lawyers part of that area do as well.
Well, it's a lot like sitting in here. I mean, it's easier to pay attention than to just sit there bored. So, yeah, you pay attention to it.
Are you familiar with what's been known as the boat case?
I am very familiar. I represent the Beach family, so I filed the boat case.
And you say the Beach family, are you talking about the family of Mallory Beach?
The family of Mallory Beach, that's right.
And is she the young woman who died in the boat accident?
She did.
And what was the date of that accident?
It was the early morning hours of February 24th, 2019.
At some point, you said you were representing the Beach family. At some point, you were approached by the Beach family?
I was. Shortly after the wreck, there was an incident on the causeway. So this boat crash happens, there's a bridge called, you go over Archer's Creek. Archer's Creek is a creek that separates Paris Island, the marine installation, from, I guess that's Port Royal. And the boat crash happened at that bridge. There's a road, if you can imagine the causeway, there's an old road that goes down to the base of the bridge. And after the boat crash, the law enforcement had cordoned off, had a rope up or yellow flag, yellow taping up, and so Miss Beach wanted to go down to see where her daughter had died. And she wasn't allowed to.
Objection, relevance, 403.
Objection is overruled.
Please continue.
She wasn't allowed to go down to the bridge.
She was
told
not?
She was not. She was told it was a crime scene, and she couldn't go down there.
All right. What else did she, and when she was hiring you, what else did she report?
Almost immediately thereafter,
Hearsay.
For the truth of the matter, asserted the effect on the listener and the reasons for the actions he took, which has become relevant in the boat case.
Only argued when requested by the court.
My apologies.
Objection is overruled.
almost immediately thereafter, a car pulled up driven by Alex's father. His wife was in the front seat. Alex's wife, Maggie, was in the front seat. They were waved down to the bridge, and that caused her a great amount of distress.
Did she ultimately hire you to represent her?
That day I got involved.
At some point, as you get involved, do you start to investigate the occurrence?
I did. I started to investigate, but I started to try to put pressure on law enforcement, which is, I'm drawing a distinction there almost immediately, because the concern was that it was going to get covered up by the Beach family, and they didn't want that to happen.
Your Honor, I would object to these references to covering up. It's not relevant to the motive purpose for this testimony, and it is prejudicial under 403.
I sustain the objection.
Strike the previous response.
Objection is sustained. You may proceed.
Yes, Your Honor. Just generally, you investigate the case, is that
I did.
correct? And at some point, did you reach out or have any discussions with anyone who was representing the defendant, Alex Murdaugh?
I did. Well, I've talked to a number of the partners, but after
When you say partners, you're talking about PMP?
Yes, I'm sorry.
All right.
But eventually I came to know that Danny Henderson was appointed as Alex's personal counsel, who was one of the partners. You may remember there was a video from Alec in the front seat of the law enforcement car, and the arm that reaches up and squeezes his shoulder while he's crying. That's Danny Henderson.
All right. And did you and Danny Henderson, did he have any documents for you to review?
He brought me all of the insurance policies for all of the insurance that Alec had in place at the time of the boat crash.
And for what reason did he bring you those documents?
Well, when you do what I do, we can't turn back the hands. We can't undo what's happened. And so, the best that you can hope, and when you get a case like this, this kind of loss, nobody gets what their case is worth, if that means anything. I mean, nobody would willingly trade place with these people for money. But that's all that you can do in a civil case is recover money. And so some things are covered by insurance, some things are not. And so many times when we are drafting lawsuits, we want to know what insurance there was so that we try not to destroy the ability for the insurance to apply in the beginning. So that would have been the reason I was looking at the insurance.
His attorney, Danny Henderson, brought the defendant's policies to you to review. Is that correct?
It seems like it was a week, 10 days after the boat crash.
All right. And did you review those?
I did.
And what if anything, did you find in those documents?
It did not appear to me that that he had any coverage other than there was a policy with Progressive, a watercraft policy that applied to the boat. It was $500,000, and it was offered by Progressive immediately. When you have a catastrophic loss, it's not unusual that an insurance company will say, here's our money, take it, please, because they have an obligation to protect their insured if they can. The other policies that he had didn't provide coverage except for a for-hire hunting operation, which this didn't arise out of.
What company was that with?
Philadelphia Insurance.
All right. And again, that policy was limited to what?
The occurrence, the accident, if you will, had to arise out of a hunting operation, a business operation. And even if there were some way to say that this boat ride this night did that, there were very specific watercraft exclusions that then excluded the coverage. So accidents are covered, but then you have all these exclusions that take the coverage away, and so there was no coverage.
Did the defendant have an umbrella policy? First, tell the jury what an umbrella policy is very quickly, if you could.
An umbrella policy would be if you have a primary policy, say on your car, the umbrella policy would sort of be a coverage. It could be broader than your car. It could also apply to your house. Generally, that coverage is the limits are multiples of maybe what your liability limits are, and it could be broader than just your house. It could apply to your house and your car. So I don't remember. I think all of the coverage was with Philadelphia, and I remember reviewing all the policies. I don't remember if it was exactly what they were referred to this time.
Did you ever find out if the defendant had an umbrella policy or the status of that policy?
There was no coverage for this boat crash other than with Progressive on the boat.
Did the defendant have an umbrella policy at one time, to your review?
He had coverage. He had the coverage with Lloyd's of London and Nautilus immediately before, which was the coverage that was in effect when Gloria Satterfield fell at his house. And he had an umbrella policy there.
All right. And what happened to that policy, that coverage?
The policy came up for renewal. Normally they're a year. It comes up for renewal, and this claim's still open. And so when it came up for renewal, the insurance company wouldn't renew the policy, and they canceled it, which is why he then went and bought this hunting club operation or hunting for hire operation, whatever that policy was, but didn't really cover anything because he didn't have that kind of business.
In your assessment and judgment, would that Philadelphia Hunting Lodge policy provide any coverage for the boating accident?
It did not. I told Danny Henderson in November of 2019 that it did not. Philadelphia filed something called a declaratory judgment action where they go and ask the court to declare their rights, meaning we don't have any coverage. It's clear the policy doesn't apply. Judge, tell, in this case, the plaintiff, because they sued us, the Beach family, and they sued Alex Murdaugh for a declaration there was no coverage. I refused to participate. I said I would just be bound by whatever the result was because I knew what the result was going to be.
Generally, at this point in time, what was your assessment of the defendant, how lucrative the defendant's practice was and his general wealth?
Well, so I believe that he was making lots of money. I told you that he had most of the cases. So if that's 50% or 60% of the cases that are actively resolving, he's actively making money. Money's coming in. Now, whether I knew that how the law firm worked in terms of they would get their money at the end of the year, that's not uncommon, but it doesn't really change the fact that he's making lots of money. And that didn't really change in the time that I knew him. It certainly hadn't changed in the years immediately preceding the boat crash, so by the last 3 to 5 years.
All right. And ultimately, with your review of the insurance coverages, the only one that you thought was applicable was which one?
The Progressive boat policy.
And how much was that?
$500,000.
And from your assessment of the case, was that going to be enough?
No, it wasn't. There were 6 people on the boat, including Alex's son, Paul. So there was one girl whose hand was pretty severely injured. She had about $130,000 in medical bills, a couple of surgeries. You had one boy who was thrown into the console and had a broken jaw.
Object to this, 401, 403.
Objections overruled.
And his medical bills exceeded $100,000. So, you got a death, you got 2 people with substantial medical bills, and there was just no way there was enough coverage at $500.
As a result of that assessment and your assessment of the defendant's lucrative practice and wealth, what, if any, goals did you develop for this particular litigation?
I don't know if it's as easy to answer that, but as I began to realize there was no coverage, it was clear that and oftentimes when you have someone who is very affluent, who has a lot of money, it's not uncommon for those people to pay in addition to what they have in insurance. And so Alec was going to have to pay out of his own pocket to settle the cases.
Did you ultimately file suit in this matter?
I filed suit, I think, about a month after the boat crash. I filed suit before the criminal charges were brought.
Criminal charges against who?
Paul, I'm sorry.
And so in March of 2019, you filed suit?
I believe so.
And did you sue the defendant?
I did.
All right. Without getting into the weeds too much, what's the basis of potential liability for the defendant?
So, in the very beginning, if there was any chance at coverage, the allegations were that he knew that his son Buster, his older son Buster, who was 21 years old, had obtained a duplicate license, and that Paul was using that license to buy alcohol. And so it's sort of Alec's lawyers from time to time have characterized it as negligent parenting, but it's in the law you have this idea that there's this thing called negligent entrustment. You know that somebody drinks. You know that he has a propensity to drink in excess, get drunk. You give him your vehicle, you've created a hazardous situation. And so that's the liability against Alec. And so what I did in the very beginning, in the first lawsuit, was I drafted it to try to see if there could be coverage, even though I didn't think it was going to be successful.
You testified that you'd made the assessment that the defendant was going to have to personally pay in this matter, correct?
He was.
Did you ultimately communicate that to his attorneys and to the defense in this case?
Multiple times and very clearly.
And in this case, I mean the boat case.
Yes.
Is there such a concept as a friendly defendant or a venue defendant or a placeholder defendant in civil litigation?
There is.
Can you just very quickly explain that to the jury?
It started, you first see the references back in, I think it was the 40s and 50s, and it was a way that if you're from out of state and you get sued in South Carolina, you have a right, rather than be in state court like we are now, you could have it, that case against you taken to federal court. And so oftentimes what people would do to keep the out-of-state person from taking it to federal court and rather keep it in the county where they knew everybody is you would also sue someone in state. And so it was a venue defendant. Now, and that kept the federal court from having what's called diversity. But in civil cases in state court, sometimes you do that. I mean, if there are two people driving a car, driving two cars, two people involved in the wreck, the passenger didn't cause the wreck. So you could sue both and let the jury sort out who it was, even though you believe that probably 99% of the liabilities on one person, or maybe all of it's on one person. Juries do crazy things sometimes.
Had you made it clear to the defense during this time that you were not considering the defendant just a friendly defendant or a placeholder defendant or a venue defendant?
From the beginning and very clearly.
And that meant you were seeking a personal recovery against him?
He was always going to have to pay, and pay a lot of money.
Does your area of the law, do y'all have some sort of annual conference every year that many people involved in it attend?
We do. Michael Gunn mentioned it. I think he called it SCADS or SCAD. I don't know. So I called it the Trial Lawyers Conference. It was at the Westin at Hilton Head every year.
And what time of year does that? What month does that take place?
It's usually the first weekend of August. So that if that's first, second, third, or fourth, fifth, and sixth, but it's usually that first week of August.
In August of 2019, did you attend that conference?
I did.
And did you see the defendant there?
I did.
And did you have any conversation with him?
Normally, different law firms have dinners and groups of lawyers, because it's marketing too, right? I mean, you go and you have dinners and you take other lawyers out who may send you cases or get you involved in cases. And so after dinner, everybody sort of comes back to the hotel, and there at the Westin, there's a gathering area. And I think it was a fundraiser, either for Mr. Harpootlian or for Lindsey Graham. But there was a whole room of lawyers, and he saw me. And this is the first sort of gathering. There's a little tension, I think, generally in the room about it. And then he beelines across the room and gets about this close.
And what does the defendant say to you?
Hey, Bo, what's this I've been hearing about what you've been saying? I thought we were friends.
And did you respond to that?
I did. I told him that we were friends, that if he didn't think that I was going to do everything I needed to do to help my clients, he was wrong, and he needed to settle the case.
Was that conversation about your intent to seek a personal recovery?
That's when he said, what's this about what I've been hearing? I thought we were friends. That's what he was talking about. He didn't like the fact that I was saying he was going to have to come out of his pocket and pay.
Moving on to the following month, was there a mediation in the case?
The next year. So that was
2020.
August of 19. We don't have the mediation until September of 20.
At this point in time, the case has been filed, and without getting into detail, you're generally engaging in the discovery process. Is that correct?
We are, which is you go and you put witnesses under oath, and you take their depositions, and you examine them, and you collect documents and those sorts of things. But we were taking depositions, primarily of law enforcement, the people at the emergency room, that sort of thing.
What happened in March of 2020 that affected everybody?
Well, COVID began to shut the courts down. We continued to take some depositions, but ultimately, I think it was probably April, May, then we were sort of confined to our offices by then. So in March, we're still taking depositions of law enforcement, and it sort of slows down.
Do you continue to work on the boat case?
We did.
Continue to gather evidence and documentation?
I did. There was a number of things that we knew existed that had not been collected by law enforcement and didn't appear to exist as far as law enforcement were concerned. And so, for instance, I subpoenaed from the Department of Defense, I believe, and ultimately got all of the federal government's documents of affidavits and things of witnesses that were out there from Parris Island.
And without getting into all the details of the evidence, were you gathering evidence that you felt made your claim against the defendant strong?
It did.
And did you share some of these, at least some of these findings with the defense?
Well, they're sitting in the room. I mean, they might not know it until I bring it out. The first lawyer asks questions, and then the person may or may not be completely truthful, and then you bring out the document. And so they're seeing it happen. And that's mainly with law enforcement. There were a number of law enforcement depositions where that happened.
As you're moving through the months of COVID and their shutdown and everything like that, is one of the things that you do is use a mock jury to sort of assess your case.
Objection, Your Honor. 401, 403.
Objection's overruled.
I did in this case.
All right. And some of this evidence that you felt was strong, did you sort of present that to this mock jury? It is just as a tool to help you assess how strong your case is and how likely it is of a recovery.
Yes, and I was specifically interested in Beaufort County, and I can explain that if you want.
Just very briefly. Let's try not to get into the weeds too much, but just yeah, if you can.
So the alcohol was sold by a convenience store, Parker's convenience store, and the Parker's lawyer at times would seem to act like Paul wasn't the driver, and at other times.
The objection's overruled.
At other times, he would go after law enforcement specifically about that particular officer's connection with Alex Murdaugh or the Murdaughs in general. And so you really can't have it both ways, right? I mean, if Paul's not the driver, you don't really worry about the alcohol that was sold, then the connection with law enforcement sort of becomes irrelevant. So and it was clear what they were doing was they were trying to try a case that look at all the bad things, don't let him get away with this because of verdict against Parker's. And so I was interested in if we went to Beaufort, because I'm being told by Alex's lawyer, that a Hampton jury won't return a verdict against him. And so what I'm trying to determine is if we go to Beaufort, is the evidence that I have uncovered so overwhelming that a jury ignores the clear breaches by Parker's company?
And ultimately, again, without getting into the weeds, were the results of that exercise with the mock jury, did that give you further confidence in the strength of a large recovery against the defendant? Just answer that.
Yeah, absolutely.
And ultimately, did you communicate that to the defendant's defense team?
I did. I also, to Ronnie Crosby, who said that he would talk to Alec, and then they wanted copies of some of the statements by the people that wanted to take everything he had.
What time period are we talking about right
This
here?
was May of 20.
Did you have anything else going on in your life as this time period was going as well?
Well, I was getting divorced.
That's significant.
Yeah. But yeah, so,
All right.
but, yeah, I think you're later in the summer, but.
I got you. As we move from May of 2020 into the fall of 2020, are those conversations continuing with the defense about the strength of your case and your desire to have a personal recovery against the defendant?
Sure, there was a lot of pushback about the shock that I would hold Alec personally responsible, make him pay. And then in August of 20, I figured out that I had cancer, and but we continued to work. And then probably by November, I knew how bad it was, and I knew that I was going to be gone. And so I tried to make arrangements to do things, because I'm still having to decide. The case is getting some age on it. We filed it pretty soon a case that gets about a year old ought to go on the trial roster. We have mandatory mediation. We're going to mediate it in September, and then immediately after that, it would be eligible for trial. We didn't settle the case, and in November, I sent some requests to admit, which is in the law, in civil cases, there's all this evidence. It's like in here, you've seen this. You have to bring somebody in here that says, I opened the car door, and then you bring the next guy in and says, well, I took the mats out. And if that's not disputed, then we can send something, it's a written question, say, admit that it was daylight when this happened. Okay, we'll admit that. So we don't have to call somebody in. And so it's admit certain facts to be true, and then those things are taken as true, and we don't have to present them. So I had made up my mind that I was going to send the case to Beaufort after the focus groups, and I was going to try the case in Beaufort. So I sent requests to admit in November of 19 before I was about to leave to go to Florida for my cancer treatment.
In November of 19?
I'm sorry, November of 20. I think it was November the 19th. But.
All right, before we go there, you'd had some discussions with the defense about the strength of your case, as you've talked about, correct?
Oh, yeah.
And the strength of your case against the defendant, is that correct?
Yeah, and one
just
of the
real
other...
quick, let me ask a question if you could.
Sure.
Had you had any discussions about a number that you were seeking from the defendant, roughly?
Ultimately, I have that conversation. They pushed me for a number. By November, I've given them a number, yes.
All right. And roughly what that number was?
That number, he was going to have to pay $10 million out of his pocket.
And did the defense have any response to you eventually?
That he could cobble together $1 million.
Did they have any other response?
He was broke.
He was broke. He can only get $1 million.
Maybe could get $1 million.
Based on your knowledge of the defendant and his practice as you've testified, did you accept that response that he was, quote, broke, end quote?
No, I didn't believe it at all.
Did you offer him any other sort of settlement, any sort of type of plan or anything like that?
If you're broke, I'm happy to work out a payment plan. You can make payments. You can convey Moselle. I knew he had Moselle. He got Moselle right after a big settlement in 2012. So that's 1,700 acres. Conveyed Moselle, convey the beach house. He still had the house in Hampton. And we'll work out a payment plan on the rest.
Did they reject that?
He did.
Having been told that the defendant is broke despite what you believe, did you have a response to them?
I did. In October, almost immediately after the mediation, I served some discovery. Again, it's a written question, and there are two different types. There's interrogatories where you ask a question, tell me where you bank. And then there could be requests for production, give me your bank records. Now, I didn't say that, but I did. I sent discovery to...
And just real quick, we'll talk about discovery in a second, but generally, what is that response? He says, I'm broke. What are you saying in response?
There's no way. I mean, like I said, he has a spigot of money that's running. He's settling cases. He's got big cases. He's got lots of cases. He's got generational wealth. There's no way he's got 1,800 acres in Moselle. He's not broke by anybody's standards.
Did you ask the defense to, okay, show me the books, prove to me that you're broke?
I did.
And what was the response?
No.
So that led you to some discovery?
It led me to send discovery to get that information.
And specifically, what information as it relates to the defendant's books and the defendant's accounts are you talking about?
Well, it was broad, so it was broader than this, but what I was looking for was the institutions, the accounts, where he did his banking. Because if he was, in fact, broke, if his bank account says $0 or $5,000 or $7,000, it was because he was hiding it, in my opinion, at the time. So that's what I was looking for.
All right. And so you sent those discovery requests?
I did.
And did the defendant provide that information, or did they decline to provide that information?
They objected almost immediately.
And so did you then file some subsequent legal papers because they refused to provide the information about the defendant's accounts?
I did. I filed what's called a motion to compel, where I asked the judge to compel or make him give me the information.
I'm going to show you what's been marked as State's Exhibit 402, and just generally just see if you recognize this document. If you flip through it real quick.
I do. It's the motion to compel that I filed with three exhibits, which are his lawyer's responses, the objections to the questions.
All right. And what's the date on that document?
The
motion
date-
to compel.
The motion to compel was filed October the 16th, 2020.
Your Honor, this time I would offer State's Exhibit 402 in evidence, I believe, subject only to a previous objection.
No additional objections, Your Honor.
It's admitted.
All right, can I have the screen over there, please? All right, this is State's 402, the one you just described, is that right?
That's right.
And that's the date on it right there?
Correct.
And I've turned over what's Exhibit B to this document. And is this some of that discovery asking for for the defendant to identify his specific bank accounts that you were just describing?
That's right.
And can you just read number one right there? That's a question that you're asking the defendant to provide to you, correct?
Yeah. What you see there is the bold. The answer is, so this is, Alex's lawyer has retyped the questions that I sent. So that's the question that I wrote. Number one, list all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, and any other accounts over which you had signature authority for maybe in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present. And then the answer is what his lawyer said, which is generally an objection that's overbroad, it's unduly burdensome, it's not relevant, doesn't have anything to do with it. So
they had objected, and you filed a motion to compel. And again, without too much detail, is a motion to compel to ask the judge in the civil case to force them to provide you this information.
that's right.
And if that motion, and we'll talk more about this in a minute, but if a motion to compel is successful and you had gotten the defendant to produce the identity of all accounts he had, what would have been your next step if you continued to follow that thread?
Well, so I knew some information. I would have verified that he was telling me the truth, right? So some things I'm verifying, but I would have ultimately sent subpoenas to the banks, and then I would have begun to subpoena the accounts. I mean, I know he's got a personal account. I know that the law firm's got accounts, but he's got these other entities, these partnerships and things. I didn't know if he had accounts there. So that would have been what would have happened next.
At this point in time, were you aware of any institutions that you believe the defendant had bank accounts at?
I knew about Palmetto State Bank, and I believe that I knew about Bank of America.
At this point in time, though, did you have any idea about all the stuff over there with the fake forge account and all this other stuff that the jury's heard about?
Not a clue.
But had you been successful, you would have sought to identify all accounts in his name and then reviewed those accounts. Is that correct?
Yeah, the subpoena to Bank of America wouldn't have said, give me the information for account 102 or whatever the number was. It would have been for all accounts that have his name on it, period, in any capacity. So it would have been very broad.
And to be fair, they could continue to object to subpoenas and that sort of thing, but this was, if you had to follow this thread, that was the tack that you were taking by filing this document. Is that correct?
That's exactly what it was, and I was doing it, like you heard Chris Wilson talk about in that Mack truck case, that the defendant didn't want this to happen. Well, this is normal in a civil case. There's lots of times that defendants don't want certain things to happen, and so if they don't want it, that's what I want. And so I'm putting pressure where I can put pressure, and this is a place that I can put pressure. At the time, I think it's because he's making so much money, he doesn't really want us to know how much money he's making.
That motion's filed in October of 2020. Is there any hearing on that scheduled right away, or does that take sometimes a while for that kind of thing to happen?
It took a while. COVID wasn't over, but the courts weren't really running. There were some courts, when the Chief Justice began to open the court system back up, they had to have some kind of COVID plan in place. Hampton wasn't one of them. This case had been specially assigned to a judge from Lancaster, and so there weren't any real opportunities to get the motion heard at that time.
You had initially described how you were initially. What county did you file this lawsuit in?
I first filed the lawsuit in its first draft in Beaufort County.
Okay. And as we're moving to this time period, COVID slowed things around. You filed your motion to compel. Are you considering moving that to a different county?
By November, I've pretty well made up my mind that I'm going to move it back to Beaufort County. And it's not just that I'm moving it back, it's that Parker's also had a motion, so I could consent to its motion to move the case back.
And so you're considering putting it in Beaufort at this point, is that right?
That's right.
And was that in part because the defense or the defendant over there believed that you couldn't get a verdict against him in Hampton County?
He was insistent.
As we move into early 2021, again, I don't want to get in for purposes of this trial for the specific discussion as it relates to other defendants, but had you started to reassess the decision to maybe take it to Beaufort County?
Yes. While I was in Florida, beginning in January, Mr. Parker, who owned Parker's Convenience Store, began to do a number of things that I thought would weigh against me going to Beaufort County.
And so did you communicate perhaps moving it or keeping it in Hampton County or moving it to Hampton County?
Not until I got back from my treatment in mid-April.
All right. Stand by for me real quick. Let me ask you this. You said you'd started considering moving it back to Hampton County because of some things that was happening with another defendant, that being the convenience store in Beaufort County, correct?
You said Hampton. I think you meant Beaufort.
Sorry. Let me rephrase that. You're in Beaufort at this point, correct?
No, I'm in Hampton. I filed it initially against Luther's, which was a bar after. So the kids launched a boat from Alex family place to Chess, and it's owned by family trust, Murdaugh family trust. Maybe there are two properties and there's two trusts. So I sued Alex's father. I sued the trust because there could have been that alcohol was provided there. It turned out it wasn't. But the kids drank and launched the boat from there. And then they went to an oyster roast. I sued the people who had the oyster roast. From there, they went to a bar called Luther's where Paul had 2 shots. And so I sued Luther's, and I sued Alec. And I'm not 100% certain in that first lawsuit whether I sued Buster or not, but I ultimately did sue Buster.
You were describing you were in April 2021. Had you at that point had some thought process that you communicated to the defense about having the case in Hampton?
Yes, I did.
Okay. And was it because of some of those things with that other defendant that you had mentioned?
So,
Without getting into the specifics.
It was. And the motions were coming up. I mean, it was, I've been gone for 4 months or whatever it is, 4.5 months, and so the motions are set to be heard. And there are a number of motions. Parker, as I said, had filed this motion to transfer the case to Beaufort before I left.
As you're thinking about, as we're in April of 2021 and you're thinking about putting it in Hampton, you were still concerned, though, about a case against the defendant in Hampton County, his home county, correct?
I think you're still getting Beaufort and Hampton mixed up, but so not exactly. I was.
All right. Well, you explain it
Okay,
to me.
I'll explain. There were a number of reasons that I wanted the case in Beaufort. I had substantial evidence. One of the things that we didn't talk about was when you have a 17, 18, 19-year-old girl, which I have, she constantly has her phone and she's constantly taking videos. And so one of the things that I discovered is that Paul's girlfriend had tons of videos of alcohol, family trips, videos of Paul drinking in front of his parents, videos of him grossly intoxicated. And so that evidence I shared with Alex's lawyers as well leading up to it. I didn't share it. They didn't serve the same discovery on me because they didn't want the other defendant, Greg Parker's, to have it at that time because they were so entrenched in that there was some sort of venue-friendly lawsuit going on between Alec and myself, but there wasn't.
As you're considering all these issues, did you ever convey to the defense any issue about suing any other defendants in Beaufort County if you felt like your case was not getting a fair shake in Hampton County?
So once I made the decision.
Ladies and gentlemen, we're going to stop for the day. We're going to resume at 9:30 tomorrow morning. Please not discuss the case. The nature of the objection.
Your Honor, as I understand this, the relevance of this under the state's theory is financial pressure due to he said $10 million that he expected the defendant to pay. These details about interactions with other defendants, the relevance is just not apparent. And then there's giving.
Your Honor, through my questions, I've been trying to minimize getting into the weeds on that. I believe the response that the witness, I'm happy to proffer an answer to that particular question, is communicating to the defense that he intended to sue Maggie and Paul in Beaufort County if he detected anything that he thought in Hampton County that was untoward. And I think that that's specifically relevant to the specific pressures that were rising on this defendant in April of 2021.
Well, I think you could have asked him that question, but I agree with the defense. You said you're not trying to get in the weeds, but you're far into the weeds, into the other case, and I sustain the objection. And we will resume at 9:30. Mr. Harpootlian.
Your Honor. At some point in this case, the defense will have the opportunity to call witnesses.
Yes, sir.
I'm not sure when that's going to be. Anyway, a number of our witnesses, when I say a number, at least 4, perhaps 5, are from out of state. They're experts, so it's prohibitively expensive for us to just fly them in and have them sit somewhere for a week or two. I wonder if we could inquire of the state, is there some end to their case that they predict will happen within, and because, Your Honor, if they tell us they're going to end on, I mean, it's sort of the reverse, they tell us they're going to end on 10 days from today, and they end 8 days from today, we won't have witnesses to put up. So we delay the court. So, and it's not. I've talked to the Attorney General several times, and he has been unable to predict to me when that might happen. I thought perhaps, and I'm not asking he do that right now, but perhaps he could, Your Honor, it would ask him, he could like consult with his team and think about when that might happen. And again, I'm only asking so that we don't say, we don't have a witness here. They're in Chicago or Connecticut or whatever, because they have to book flights and they have to, I'm not whining. I'm just saying to some specific.
Reasonable request. I certainly understand.
I don't hear that much. Thank you.
I believe, and I think the defense counsel will have to concede, I've been very accommodating at what our next day's schedule is and trying to provide that. I've tried my best to communicate with the defense, and I think he would have to concede.
But he's not worried about that part. He wants to know, when are you going to be through?
Well, I think
and I'm not the only one.
And I told, and he says I didn't tell him, and I told him that, right now I'm thinking at the latest midweek next week is what I was thinking. I told him that earlier today. And again, Your Honor understands these are fluid. Objections can happen, cross-examination happens, and camera proceedings can happen. But that is what I told him.
Does that give you a sufficient idea?
Give me an idea. But if, as this process goes on, they decide they need to, I mean, again, I said I accused him of gilding the lily and piling on. It's apparently instinctive. I'm not criticizing it. It's his case. I am criticizing it. It's his case. But I just, and he has every day when I've asked him, who are you calling tomorrow? Been 100% cooperative, and we're going to do the same for him. But as we proceed through tomorrow, and he thinks he's going to be done midweek, Wednesday of next week.
That's my best assessment right now, yes, sir.
Okay, so what we're going to do is we're going to try to structure a plan where we have available witnesses Wednesday, Thursday that we don't have to fly in, but it may be the following week before we can get those folks here, if that makes some sense. I mean, I
understand. Well, we'll need to address it as we go, and I think maybe reassess things and give you some lead time.
I'm in no way criticizing Mr. Waters. I want to say that. I understand it's a fluid situation. I've been where he is. I spent 12 years as a prosecutor. I know how difficult it is to project these things. Having said that, we've been here a little bit longer than I thought we were going to be. We projected a 3-week trial. We're now 3 weeks, or tomorrow will be 3 weeks, and our case is going to take, we think, at least a week. So if you've rented or set aside hotel rooms for a 3 or 4 week trial, it's probably best to make provisions. And we're going to try to pare that back. We think the jury may not remember what they heard 3 weeks ago the further we go on.
Okay, we'll just revisit the issue perhaps on a daily basis and see how we're going.
Thank you.
Thank you, Judge.
All right.